ಮಾತ್ರ ಬರ್ತೀರಾ ಬ್ರಾಂಚ್ ಅವ್ರು ಬರೋದಿಲ್ಲ. ಇದೆಯಲ್ಲ ಇದಿದೆ ಇದಾ ಶುಕ್ರವಾರದ್ದು ಗುರುವಾರದ್ದು ಅವತ್ತಿಂದ ಅವತ್ತಿಗೆ ತಿರ್ಗಾ ಅವತ್ತಿಂದ ಒಂದ್ ನಿಮಿಷ ಬಿಡ್ಲಿಲ್ಲ ಫ್ರೈಡೆ ರಜಾ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಹೋಗಿದ್ರು. ಶನಿವಾರನೂ ಬರಲ್ಲ ಅಂತಾನು. ಶನಿವಾರ ಆಫೀಸಿಗೆ ಬಂದಿದ್ದಾರೆ, ಇಲ್ಲಿ ಬರಲಿಲ್ಲ. ರಾಜೇಶ್ ಆಫೀಸಿಗೆ ಬಂದಿದ್ದಾರೆ, ಇಲ್ಲಿ ಬರಲಿಲ್ಲ.
My Lord, one humble submission.
Yes, madam.
The petitioner wishes to show cause notice to open demolition, but the indications that have already been stayed by the Honorable High Court. Prior to issuance of the notice, they fall into the staff and deal with the last.
Tomorrow. Further orders. Tomorrow. Fifth.
An extendment order has been passed. Is also suffering from some of those.
Have you been heard? You have to file an appeal.
The one case is pending. The rest of the case, only one case has been.
We are not getting into the merits of the matter. If you have been heard, national justice violation, we will interfere. Otherwise, no. Go ahead. Tomorrow.
Petitioner is suffering from heart disease. He is under police judicial custody. He is suffering from heart disease.
Judicial custody. For a parole. Judicial custody, he has been convicted. Judicial custody is only before the 5th order.
Extension of emergency parole, my lord.
5th.
Today is the last date, my lord.
5th.
Today is the last date, my lord.
We take it up on 5th. Let them get the information. Surrender first. Yes.
Here, police petitioner is being a woman, my lord. Respondent to responsibility is police officials. Intention was the petitioner.
In Kerslila.
Petitioner being a woman, my lord. GM police, my lord. Respondent is the police officials.
Threat the petitioner. Without a search warrant. Serve a copy. Get instructions on this.
MTP
Serve a copy tomorrow.
MTP matter 29 weeks pregnant.
2:30.
The impugned order, my lords, orders disclosure of sensitive tender documents, my lords, without considering the exemptions under the RTI Act, my lords.
Without considering?
Exemptions under the RTI Act, my lords.
RTI Act.
RTI, right to information.
So what is the matter about?
The impugned order, my lords, orders disclosure of sensitive tender documents, my lords.
Tomorrow.
Lord, this memo is for recalling the order dated 20th July, my lord.
Recalling the order dated?
20th July. Your lordship passed a order in the writ petition, but unfortunately, the petitioners, while filing the writ petition, my lord, they did not made me as the party, even though I was necessary party. Without making me as the party, my lord, they obtained the order of this honorable court, and now it is adversely affecting me in NCLT.
Recalling is vacating stay.
No, it is already disposed.
Disposed?
Yes, it is disposed also. So kindly have it tomorrow, my lord.
Tomorrow.
My lords, one pending matter, my lords. I am seeking only mandamus. My lords were directed the government advocate to look into the
Pending
matter.
matter will come in seniority.
ಮೊನ್ನೆ ಬಂದಿತ್ತು 2 ದಿನನೂ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ. ಅರ್ಜೆನ್ಸಿ ಇಸ್ ಓನ್ಲಿ ಎನ್ಕಂಬ್ರೆನ್ಸ್ ಅಲ್ಲಿ ಇದಾಗಬೇಕು, ಎಂಟ್ರಿ ಆಗಬೇಕು. ಕ್ಯಾನ್ಸಲೇಷನ್ ಡೀಡ್ ಹ್ಯಾಸ್ ಬಿನ್ ಆಲ್ರೆಡಿ ಕ್ಯಾನ್ಸಲ್ಡ್. They are not entering the same in the encumbrance. The respondent may take advantage and they may alienate the property. ಅದು
in seniority.
ನಾಳೆಗೆ
Yes.
At least 5th your honor, 5th.
December 25th.
ಅಲ್ಲ
ನಿಮ್ಗೆ ಹೇಳ್ತಾ ಇದೀವಿ, we won't make an exception for anybody. Pending matter will come in seniority. Not for you, not for anybody.
ಮೊನ್ನೆ
Yes.
he got all the sanction the same has been intimated to the
Fresh matter.
pending matter.
Pending matter will come in seniority.
Even though they are deducting the amount from real court.
It'll come in seniority. It'll come in seniority. Yes. Twenty-four 80 Bharat. Yes. Fresh matter or pending matter? Kodi Bharat. Yes. Parole 5th Todi. You challenge the order? Sanction. Yes. Conduct a? No, they are permitted to conduct what?
Where the C&D, where it is the forest land reserved as a C&D lands, there, even though there was an embargo and there is an order from division bench, and in view of the order passed.
Fresh matter or pending matter?
Pending matter, I had an application for a direction you got.
It will come.
The connecting road has gone. That is the reason.
You can take 10 minutes to argue the matter at mentioning stage, but it won't be taken up because it will come in seniority. Already the stays have been granted in that. Internal reservation all. Yes. Then next week. Yes. Pending matter. It will come in seniority. Please. Yes. What is the reason? Why 2:30? It will come regular course. Bharat, August 8 in a time ide. Give it, madam. It will come. What is the urgency? Please give the memo. It will come in seniority. It's a pending matter. Just a moment. Fresh mat. Kodi barattappa. 230 ಏನ demolition ಏನಾರು ಇದ್ರೆ mention ಮಾಡಿ. This will come in the regular course. Withdrawal memo kodi. In seniority must open. In seniority we can't make an exception. ಯಾವತ್ತಾರು ಬರುತ್ತೆ seniority. Tomorrow. Tomorrow, 1 day class will go, madam. That's all. Yes. Survey copy. Yes. Father has given a police complaint. What did you do? What did? Regular course. Trial court ಅಲ್ಲಿ police protection order ಇದೆಯಾ? ಮತ್ತೆ ಅಲ್ಲಿ application. Yes. Pending matter. He'll come and see. Yes.
It's a fresh matter, Your Lordship, because they said before this honorable court, then because it was passed over, it could not be reached, Your Lordship. The urgency is that the respondent is constructing a trench in the road, Your Lordship.
Trench matter tomorrow.
Cause list 2 ಅಲ್ಲಿ ಇದೆ ಸರ್. ಕಾಸ್ ಲಿಸ್ಟ್ 2 ಅಲ್ಲಿ ಇದೆ ನಮ್ದು 50ನೇ ನಂಬರ್ ಸೀರಿಯಲ್ ನಂಬರ್.
ಕಾಸ್ ಲಿಸ್ಟ್ 2 ಅಲ್ಲಿ
50 ಸೀರಿಯಲ್ ನಂಬರ್. ಅದು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೆಂಟ್ ನಾನು 14% ಸರ್ ಕೋರ್ಟ್ ಮುಂದೆ. ಆ ಪಾರ್ಟಿ ಪೆಟಿಷನರ್ ಗೌರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ಮೇಲೆ ಅವನು ಮನೆ ಮಾಡಿದ್ದಾನೆ.
ರೀಚ್ ಆದಾಗ ಹೇಳ್ಬೇಕು ನೀವು. ರೀಚ್ ಆಗಕ್ ಮುಂಚೆ ಎಲ್ಲ ಹೇಳೋದು. ಯಾವಾಗ ರೀಚ್ ಆಗತ್ತೋ ಅವಾಗ ಹೇಳಿ
ಸರ್. ಅದು ರೀಚ್ ಆಗ್ತಾನೆ ಇಲ್ಲ ಸರ್. ಅದೆಲ್ಲ
ಅಷ್ಟು ಮ್ಯಾಟರ್ ಇದೆ. ಏನ್ ಮಾಡೋದು? ಯಾವ್ದು ರೀಚ್ ಆಗತ್ತೋ
ಹಾಕೊಡಿ ಸರ್. ನಾಡದಕ್ಕೆ ಹಾಕೊಡಿ ಸರ್.
ನಾಡಿದ್ದಕ್ಕೆ ಹಾಕಿದ್ರೇನು ರೀಚ್ ಆಗತ್ತೋ ಇಲ್ವೋ ಗೊತ್ತಿಲ್ಲ. ರೀಚ್ ಆದಾಗ ಮಾತ್ರ ಹೇಳಿ. ನಾಡಿದ್ದಕ್ಕೆ ಬೇಕಾ ನಿಮ್ಗೆ? ಬಟ್ ಬೇರೆ ಅವ್ರಿಗೆಲ್ಲ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ಬೇಕಲ್ಲ.
ಹಾ ಸರ್.
ಇನ್ಫಾರ್ಮ್ ಮಾಡದೆ ಅಡ್ಜನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ನೆಕ್ಸ್ಟ್
Complied number 1, serial number 1. I complied my.
Serial number 1 appearing for the petition.
Number 2, man.
ಯಾವ್ದು ಕರೆದಿರೋದು ಇವಾಗ?
Serial number 2 to 8. Page number 3. Serial number 9 to 15.
Number 13, madam. To file statement of objections. 2 weeks time may be granted.
ಯಾರಪ್ಪ?
Government
13. That counsel for response submit that he has filed a statement of objections.
2 weeks.
To file statement of objection, to file. Counsel for response seeks for and is granted 2 weeks time finally to file a statement of objection. Objections, if any, by 20th. If not filed by then, it will be taken as not filed. Matter proceeded with. Released on 1st September.
Page number 4. Serial number 16 to 21.
Yes. You're for? Have you informed the other counsels for the respondent? Then please don't mention.
Page number 5.
There are a lot of other counsels also, Mr. Counsel. So you have to inform everybody. Yes. Without informing, please don't mention. Next.
Page number 5. Serial number 22 to 25. Page number 6. Serial number 26. Page number 7. Serial number 27 to 33. Page number 8. Serial number 34 to 39. Page number 9. Serial number 40 to 45. Page number 10. serial number 46.
ಯಾವ್ದ್ರಲ್ಲಿ? List 2. List 2, serial number 68.
And 72.
72. Dismissed as withdrawn.
List number 1, fresh matter, serial
My
number
lords, may I make one submission, my lords?
Yes, madam.
My lords, list 3, serial number 4, my lords, it was ordered to be listed on 10th August, my lords. By mistake, it is listed today, my lords. There were certain directions were issued, my lords. It's a disposed of matter.
We'll have to get the file to see it, madam.
Oh,
If that is the
oblige,
date.
my lords. I'll seek when the matter is called.
If that is
My
the date,
apology, my lords.
we'll adjourn it to that date.
My apology, my lords.
List number 1, serial number 1, Bhaskara Tejasvi.
Appearing for the petitioner, my lord. I pray time, my lord, because petitioner has died in this case. So I have to bring the LRs on record, my lord.
2024 adder.
Also for the 24 matter.
Indeed, my lord, but I seek for a date matter, your honor. I file the necessary applications for bringing LRs on record, my lord.
Counsel for the petitioner submit that the sole petitioner is expired. She seeks for and is granted 2 weeks' time to file an application to bring the legal heirs of the sole petitioner on record. Relist on 1st September.
Please, ma'am.
Serial number 2, Dayananda Saraswati.
Mr. Saraswati. So Dayanand Saraswati. None appears for the petitioner. Learned AGA is directed to accept notice for respond number 1, 2, and 3. Gram Sabha, President Gram Sabha, you will accept notice? Village Forest Rights Committee. Separate council idara. Committee ಗೆ ಎಲ್ಲಿರ್ತಾರ? Kendala Gram Panchayat. Soraba Shumaga.
Shimoga A. Nagarajappa.
Shri A. Nagarajappa is directed to accept notice for respond number 4. Counsel for the petitioner will serve 2 sets of the petition along with annexure on said counsel. Relist on 1st September.
Serial number 3, Ramesh N.
My lord, I appear for the petitioners, my lord.
Yes.
My lord, petitioners were enjoying the judgment and decree in voice number 24 of 2007, which was decreed on 17/4/2017, my lord.
17?
2017.
You are challenging a 17 decree?
No. That's not the just facts of the case. Thereafter, my lord, some respondents, they have filed one more suit for partition, challenging the judgment and decree passed in 24 of 2007 in 7/18 of 2015.
7/18 of?
2015.
15?
Yes, my lord. There, my lord.
17 order 2015 ಅಲ್ಲಿ ಹೆಂಗ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾರೆ?
ಅಲ್ಲ, ಬೇರೆಯವರು ಇನ್ನೊಂದ್ಸರಿ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಹಾಕಿದ್ರು. ಆ ಡಿಗ್ರಿನೂ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು. ಆ ಡಿಗ್ರಿ ಚಾಲೆಂಜ್ ಮಾಡ್ಬಿಟ್ಟು ದೇ ಗೋ ಬಿಫೋರ್ ದಿ ಲೋಕ್ ಅದಾಲತ್. ಅದು ಅಟ್ ದ ಇನ್ಸ್ಟೆನ್ಸ್ ಆಫ್ ಸಮ್ ಪರ್ಚೇಸರ್.
ಹೇಳಿದ್ದು 17/4/2017 ಡಿಗ್ರಿನ 2015 ಸೂಟ್ ಅಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರ?
10/8
something wrong in your submission.
ಅಲ್ಲ, 24/2007 judgment and decree, partition judgment and decree.
2007.
14/10/2014.
Page number decree ಎಲ್ಲಿದೆ?
ಆ ಡಿಗ್ರಿ ಬಂದು ಪೇಜ್ ನಂಬರ್ 56.
56.
Fourteen 10/2014.
56 ಅಲ್ಲ.
Annexure D.
Annexure D.
Judgment is at
67.
66.
14/10/2014.
Yes, my lord.
Dates correct ಹೇಳ್ಬೇಕು ನೀವು.
My lord, this judgment and the contested judgment and decree was in favor of the petitioners, my lord, for partition and separate possession. Shares was allotted. Thereafter, some of the respondents, they filed one more partition suit in OS number 7/18 of 2015.
Muniswamy Naik, Krishna Naik. You are the defendant in that suit.
Yes, my lord.
Which was the next suit?
Thereafter, my lord, in 7/18 of 2015, my lord.
Where is the plaint?
Page number, 1 second. Page number 43, my lord. 43, 44.
Yes.
My lord, there was a, at the instance of some purchaser, my lord, who is not at all concerned with the family, that is defendant number 5, one Munraju. He files an application for compromise before the Lok Adalat.
You are defendant number 1 and 4.
Yes, my lord.
Yes.
They have been taken to the Lok Adalat. In spite of a judgment and decree was operating in my favor. And again, one more partition decree was passed before the Lok Adalat.
Where the compromise petition?
That is at page number 24, my lord. Only 3.
24.
24.
You have signed the compromise petition, both defendant number 1 and 4.
Earlier, there was a judgment and decree. These people were aged about 75 years and 80 years.
So you have signed it.
Like, in spite of a judgment and decree where my shares have been allotted, without setting aside that earlier judgment and decree.
How did you sign this compromise then?
That's what I filed another suit questioning the legality of the compromise which was entered before the Lok Adalat. In subsequent suit, there was a fraud played on me, and by taking undue influence, they also obtained the compromise decree, which was challenged.
You were represented by a council. You appeared before the Lok Adalat. The Lok Adalat made inquiries.
Both are LTM.
LTM alla signature ide.
Illa alla nodi sir.
Defendant number 1 signature, defendant number 4 LTM.
Defendant number 4 LTM and defendant number 1. Defendant number 1 is aged about 80 years, who does not understand all these things.
So the same defendant who is 80 years is before this court, who doesn't understand anything?
No, my lord.
You cannot make that kind of a submission.
No, my lord. Because how the fraud and undue influence has been played.
Then we will not make anybody 80-year-old defendant or a plaintiff.
Rural people, they won't understand. What is
He is represented by a council.
Yes, my lord, that was at the instance. Kindly see the.
Have you taken any action against the council?
That's what I pleaded in the plaint, my lord.
Have you taken any action?
Everything has been pleaded in the plaint. One more suit which has been.
Have you taken any action against the bar council? Complaint kottidira?
Illa, now kottilla.
Bari allegation ಮಾಡಿ lawyer ಮೇಲೆ.
Illa, lawyer ಮೇಲೆ allegation ಅಲ್ಲ. ದಯವಿಟ್ಟು page number 79 ತಗೊಳ್ಳಿ. Page number 79.
Yes.
The said fraud has been questioned by me in 277 of 2020 before the same court. Para number 5, I have stated how the fraud has been played.
79 is a plaint in OS number 24 of 2007.
Allah, 277 of 2020.
Mr. Counsel, ನಿಮ್ಮ ಹತ್ರ page number ಇಲ್ಲ, date ಇಲ್ಲ, numbering wrong ಇದೆ. ಎಲ್ಲ wrong submission ಮಾಡ್ತಾ ಇದ್ದೀರಾ. 79 is OS number 24 of 2007.
75, 76, 76, 70.
Get ready properly, pass over. Next.
79.
Serial number 4.
78, 79.
Yes. ಏನ್ mandamus ಅಪ್ಪ ಇದು? Payment, Suvarna, consider that 30 days. ADA for sound, same order.
Notice for respond number 2.
Respond number 2, you will appear. Mr. Ajay Kumar accepts notice for respond number 2.
D
Same
series,
order.
your lordship. D1.
D series.
My lords have it tomorrow, but just verify. Not sure what the petition is also.
He said mandamus directing you to consider. You consider and reject it or accept it, left to you.
Please.
Serial number 5. Raghu Prakash Babu.
Petitioner.
Yes.
Petition under section 23 of the maintenance of parents. The petitioner is 94 years old, my lord. He had gifted the front portion of the property to his eldest son, that is Mohan Kumar. He in turn, what he does, he represents that he wanted to build a house, and in that pretext, he has got a gift deed executed in his favor. And even after lapse of many years,
Where is the gift deed? Page number?
Gift deed is at page number 30.
30?
60, my lords.
60.
60, my lords. Annexure C. 2012, this gift deed was executed, my lords. And it was with an intention that his elder son will build a house and he will reside there and
Where
take
is the relevant clause?
it is not in the gift deed, my lords.
Where is your complaint?
My complaint is at page 80, 75 onwards, my lords.
Where you said about the intention?
Yes, regarding that, my lords, the petitioner paragraph 4, my lords. The petitioner further submits that he has gifted the Schedule B property to respondent with the condition that respondent should put up only house over the Schedule B property and should not utilize for any commercial purpose. The petitioner also required the petitioner to put up a residential house near the petitioner's house, as the land is within the residential site owned and possessed by the petitioner. Of late, the respondent has developed ill will against the petitioner and started to trouble the petitioner by one means or the other. The petitioner submits that prior to the said registration, the petitioner had clearly and unequivocally stated to all his children that the scheduled property shall not be alienated to third party, nor shall they be used for commercial purposes in order to preserve their sentimental value. Only after receiving the express assurance from all concerned parties, including the respondent, the petitioner proceeded with the registration. The petitioner submits that as per the mutual understanding, the Schedule B property was allotted to respondent for the purpose of constructing a residential building wherein he would reside. The respondent had also
Not about your maintenance, this is about usage of the property.
No, now what has happened, my lords? He has intentionally started troubling by causing nuisance by dumping the site with some hazardous substances, my lords. And thereby, there are two prayers in my petition, my lords. If my lords can kindly see the prayer. If not, the cancellation of the gift deed, my lords. The first prayer should have been considered by the
Mr. Counsel. 23 is a limited role.
Yes, my lords.
Of the assistant commissioner.
Yes, my lords.
If there is any maintenance to be provided, is not taking care of you, that could be looked into. Depending on the what you are seeking is not to put up any structure.
Protection for the senior citizen, my lords.
Who would that be?
If he is causing nuisance to him, this site is situated within the property where the petitioner is residing. It is not a separate property. This property which is gifted to him is in the front side of the property. He is residing at the rear side of the property. That is why the B schedule has been.
You have a separate access.
Separate access within the entire A schedule property is one composite block, my lords.
It won't come under this one.
Out of which one portion was gifted to him, my
issue
lords.
notice to respond number 2 written
Except
by
notice for respondent number 2.
so and so accepts notice for respond number 2 released on 2nd September.
Grateful, my lord.
Want to refer it to mediation if some settlement will happen.
Yes. But mediation, but there is a partition pending by the daughters have filed a partition.
Father and son, is there a possibility of a settlement?
Even it was referred to mediation, my lord. Petitioner won't appear there. He won't come and participate in mediation.
Will not appear.
Now there is no suits pending between the parties, my lord. Now everything
Now
is
there is
ended.
an appeal
We
pending.
want this matter to be referred to mediation.
It may
But
be
will
referred.
you appear?
If
I
they
will-
appear,
I-
my lord, we have no objection.
On next date, I will take consent of these
If
95.
they appear, we have no objection.
Yes, next.
Serial number 6.
For petitioner, my lord.
Yes.
My lord, this is a case where the impugned order was passed against the petitioner by the respondent number 1 without giving an opportunity of being heard, my lords. It's a, Lord,
You're not a party.
in fact, that the petitioner is not even a party to the proceedings, my lords.
What is the order passed against you?
My lord, the order passed by the respondent number 1 is that directing the authorities, concerned authorities, to take the disciplinary action within 10 days, my lords.
Where is that order?
Lord, which is in page number 12, my lords. I'll read the operative portions, my lord, which is in page number 13, my lords.
Yes.
ಆದೇಶ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಶ್ರೀ ಕಾಂತರಾಜು ಹಿಂದಿನ ಸಾರ್ವಜನಿಕ ಮಾಹಿತಿ ಅಧಿಕಾರಿ ಹಾಗೂ ಜಿಲ್ಲಾ ಆರೋಗ್ಯಾಧಿಕಾರಿ ಆರೋಗ್ಯ ಮತ್ತು ಕುಟುಂಬ ಕಲ್ಯಾಣ ಇಲಾಖೆ ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ಜಿಲ್ಲೆಯವರು ಪ್ರಸ್ತುತ ಪ್ರಾಂಶುಪಾಲರು ಜಿಲ್ಲಾ ತರಬೇತಿ ಕೇಂದ್ರ ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ಜಿಲ್ಲೆ ರಾಮನಗರರವರು ಮೇಲ್ಮನವಿದಾರರು ಕೋರಿರುವ ಮಾಹಿತಿಯು ತಮ್ಮ ಕಚೇರಿಯಲ್ಲಿ ಲಭ್ಯವಿಲ್ಲದ ಪಕ್ಷದಲ್ಲಿ ಮಾಹಿತಿ ಲಭ್ಯವಿರುವ ಸಾರ್ವಜನಿಕ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಅರ್ಜಿದಾರರು ಮಾಹಿತಿ ಕೋರಿಕೆ ಅರ್ಜಿಯನ್ನು 5 ದಿವಸಗಳ ಒಳಗೆ ಮಾಹಿತಿ ಹಕ್ಕು ಅಧಿನಿಯಮ 2005 ಕಾಲಮು 6 ಕ್ಲಾಸ್ 3 ಅಡಿಯಲ್ಲಿ ವರ್ಗಾಯಿಸಬೇಕಾಗಿತ್ತು. ಆದರೆ ಸದರಿಯವರು ನಿಯಮಾನುಸಾರವಾಗಿ ಮಾಹಿತಿ ಕೋರಿಕೆ ಅರ್ಜಿಯನ್ನು ವರ್ಗಾಯಿಸದೆ ವಿಳಂಬವಾಗಿ 24 ದಿನಗಳ ಕಳೆದು ನಂತರ ವರ್ಗಾಯಿಸುವುದರನ್ನು ಹಾಗೂ ಮಾಹಿತಿ ಕೋರಿಕೆ ಹಕ್ಕು ಅರ್ಜಿಯನ್ನು ನಿರ್ಲಕ್ಷಿಸುವುದರನ್ನು ಹಾಗೂ ಮೇಲ್ಮೇಲ್ದಾರರು ನಿಗದಿತ ಅವಧಿಯೊಳಗೆ ಮಾಹಿತಿ ಪಡೆಯನ್ನು ಅಡ್ಡಿಪಡಿಸಿರುವುದು ಆಯೋಗಕ್ಕೆ ಗಂಭೀರವಾಗಿ ಪರಿಗಣಿಸುತ್ತಾ ಸದರಿಯವರ ವಿರುದ್ಧ ಅವರಿಗೆ ಅನ್ವಯಿಸುವ ಕೆಸಿಸಿಆರ್ ನಿಯಮಾವಳಿಯ ಅನ್ವಯ 10 ದಿನಗಳ ಒಳಗೆ ಶಿಸ್ತು ಕ್ರಮ ಕೈಗೊಂಡು ಅದರ ಅನುಪಾಲನಾ ವರದಿಯನ್ನು ಆಯೋಗಕ್ಕೆ ಸಲ್ಲಿಸಬೇಕೆಂದು ಶ್ರೀ ಹರ್ಷ ಗುಪ್ತಾ ಭಾರತೀಯ ಅಖಿಲ ಸೇನೆ ಭಾರತ ಕಾರ್ಯದರ್ಶಿಗಳು ಅನ್ವಯ ನಿರ್ದೇಶಿಸಿದೆ. My lord, that the petitioner is not even a party to the proceedings, my lord. My lord, kindly see the page number 12, my lord.
You are the PIO, alva?
My lord, I am not the PIO, my lord. My lord, basically that the respondent, the applicant, wanted some CCTV footage from primary healthcare center, Veere Gaudana Doddi. My lord, in fact, he is supposed to file an application before the PIO, but he has filed an application with the DHO, my lords. DHO supposed to refer this application to the PIO. My lord, while referring the application, there is some slight delay because of the overload of the administrative functions, my lords.
You were the DHO?
No, I am a DHO, my lords.
So application was received by you?
Please, my lords. It's an online application, my lords.
It was received by you?
Please, my lords.
And you delayed in sending it?
Please, my lords. My lords, there is a 24 days delay.
CCTV footage 24 hours delay is a huge delay, Mr. Counsel. It can be wiped out.
My lords, there is a 7 days. In 7 days, it automatically it will overlap, my lord. Overloop.
That is why the reason is that it is very important that you take action immediately.
My lords, my primary contention before this honorable court, my lords, I have not even given an opportunity, my lords.
Okay, we give you the opportunity. Your delayed is admitted.
My lord, there is a genuine reasons, my lords. My lords, because my lords, in that point of time, it was newly introduced this online application, my lords. While referring this application online, by pushing this application to the concerned PIO, there was a delay, my lords.
How much delay?
Lord, there is a 24 days delay, my lords.
24 days delay. 7 days it gets wiped out.
Please,
you are aware of it.
Lord, I was not aware of that, my lords.
You are aware of it. So there's.
Lord, I was not aware of that, my lords.
Lord AG, sorry, K. Rajshekhar for respond number 1. Notice to respond number 2 is dispensed with in view of the proposed order to be passed. And AGA for respond number 3 and 4. Petitioner is before this court seeking for the following relief. By way of order dated 18/2/26, the first respondent in case number 24337 of 2023 had directed disciplinary proceedings to be taken.
There is section 20, my lord. There is section 20. That's the statutory notice has to be issued.
You can give that there. This is a recommendation made by the authority. We are very happy that at least in one case it's been done. In most cases, they only impose 25,000 rupees fine.
There is a statutory notice has to be given under section 20.
The authority will give you
please
this disciplinary proceedings under section 20 of the Right to Information Act. The submission of learned counsel for the petitioner is that the petitioner was not heard in the matter, inasmuch as the petitioner, being the district health officer, had received the application and the RTA Act and forwarded it to the public information officer. The petitioner was not a party to the said proceedings before the KIC, and therefore no order could have been passed against the directing disciplinary inquiry against the petitioner. RTA Act could. What was sought for under the application filed under the RTA Act was for making available the CCTV footage. The application, though received, wrongly filed before the district health officer, was received by the district health officer, that is the petitioner herein. It was the bounden duty on his part to forward it to the public information officer immediately.
Within 5 days.
Instead of doing so, the petitioner forwarded the said application after 24 days. By that time, the CCTV footage, which was only available for 7 days, was also overwritten. In that background, excising powers under Section 20, the State Commission, subsection 2 of Section 20, recommended disciplinary action against the petitioner. This court does not find any infirmity in the said order, inasmuch as admittedly there is a delay of 24 days in forwarding the application. There would be no purpose served by remanding the matter and providing an opportunity of the petitioner being heard, since the facts disclose the delay of 24 days, by which time the CCTV footage was overwritten, since the same gets overwritten every 7 days. Of course, the petitioner would always have the, of course, once disciplinary proceedings are initiated, the petitioner could always place his defense on record before the disciplinary authority, reserving all defenses of the petitioner to be agitated before the disciplinary authority. Petition stands dismissed.
Serial number 7, Mohammed Anwar.
Lordship, in this petition, the petitioner seeks only rephrasing of the account of petitioner, Lordship, bank account, except lien amount of 1,33,000 euros, Lordship. That is the judgment of coordinate bench.
Is the communication received from the authorities?
Yes, Your Lordship. Communication received at page number 20, Your Lordship. Page number 20.
Page number 20.
Yes, Your Lordship.
20 is a communication from the bank.
Yes, communication.
Where the
from
communication from the police authorities?
There is no police complaint at all, Your Lordship. Only dispute amount is 1,33,000, Your Lordship. There is a coordinate bench judgment, Your Lordship, on the same issue.
First, you have to be clear on your facts, Mr.
Yes,
Counsel. I'm a judgmental bunny. Where the communication from the bank about freezing?
Your Lordship, page number 25.
25.
Is
your
email
email
sent by the petitioner to the bank, Your Lordship.
Where the communication from the bank is what we have been asking you.
Your Lordship, there is no police complaint at all. In
RBL Bank, Yarama.
yes, Your Lordship.
Sridevi
RPL.
Maruti Zirali. Sridevi Maruti Zirali.
So is direct to accept notice for respond. Counsel for the petitioner served 2 sets of the petition along with annexure on said counsel. Relist on 19th August.
Obliged.
Serial number 8, Vandana PL.
Yes.
This petitioner, my lord, is a developer, which is known as, my lord, presently known as, my lord, Sammy's Dreamland. It's a huge development consisting of more than, my lord, 126 huge sites, out of which, my lord, the authority has, the local authorities have released about 93 and sold are few. Many of them are still held by, my lord, the developer only, because, my lord, they have premium plots. And with respect to some plots, my lord, there are some disputes with respect to, my lord, rights, which are seized of this honorable court and certain revenue authorities. In the meanwhile, my lord, only 7 of them, my lord, would go and form a registration, my lord, a society under the
That is Registration Act.
under the
And
society.
AGA for respond number 1 and 2 issue notice to respond number 3, returnable by 25th August. The operation of the registration certificate dated bearing number so and so dated 12/6/24 at annexure A is stayed till the next date of hearing, since the division bench, honorable division bench of this court in writ appeal number
In writ appeal number,
914 of
yes, I'll give the number, my lord. In fact, I read this.
has held that a society under the Karnataka Societies Registration Act cannot be formed for the purpose of maintenance of a apartment or a residential complex.
Greatly obliged.
Process
I'll
fee
give
and
the writ
copies
appeal number, my lord. It's
by end of day tomorrow, failing which the interim order will stand automatically vacated.
greatly obliged.
Serial number 9, Satyanarayana.
I'm for the petition. Petition for the suppliers of medical apparatus and equipments. During COVID-19, supplies were made to the respondent in the year 2020.
Yes.
Now, my lord, a notice under annexure A3 at page 22 has been issued, stating that the one-man commission has recommended for recovery of the amount already paid to us. On the other hand, our claim petition is pending before the felicitation council, my lord, at annexure F, working around.
The inquiry report has come by the
Inquiry
former judge
allowed.
of this court
It's
who has
only
directed the recoveries.
interestingly, the page 24 may kindly be seen, my lord. It's an extract of the report furnished to us.
Yes.
At page 27, the relevant paragraph at 11.3. Here it is, installation reports are not found. In the endorsement back on the invoices, it is specifically noted, installations are pending. Hence, it is deemed that the supplies were not made.
Yes.
Consequently, the payment should be
Yes.
recovered. On the other hand, my lord, I have produced the copy of the invoice also.
Where the installation certificate?
Page 21 may kindly be seen.
21.
21 nalli.
Where the installation
ಅಲ್ಲಿ
certificate?
received ಅಂತ ಬರೆದಿದ್ದಾರೆ.
Where
Item
the
received
installations,
ಅಂತ.
what is the equipment?
It's a humidifier, my lord.
Where is the installation report?
ಅಲ್ಲಿ it is there with the respondents.
ನಿಮ್ಮ ಹತ್ರ ಇರ್ಬೇಕಲ್ಲ, ನಿಮ್ಮ ಮೆಜರ್ಮೆಂಟ್ ಬುಕ್ ಅಲ್ಲಿ ಇರಬೇಕು.
ಅಲ್ಲ, they have endorsed, received ಅಂತ ಬರ್ಕೊಂಡಿದ್ದಾರೆ, ಬರ್ದಿದ್ದಾರೆ. Items have been received, installation is pending ಅಂತ ಹೇಳಿದ್ದಾರೆ.
So installation ಆಗಿಲ್ಲ ಅಂತ ರಿಪೋರ್ಟ್ ಬಂದಿದೆ. ಇನ್ಸ್ಟಾಲೇಷನ್ ರಿಪೋರ್ಟ್ ಎಲ್ಲಿದೆ?
Installation produce ಮಾಡಿಲ್ಲ ಅವರು.
ನಿಮ್ಮ ಹತ್ರ ಇರ್ಬೇಕು.
ಅದಕ್ಕೆ ನಾವು ಈಗ sought for an opportunity to appear before the committee. Now they have issued a recovery, not
Karnataka
only
Medical
recovery
Supplies
notice.
Corporation Limited. Sumana Baliga for respond counsel for the petitioner to furnish 2 sets of the petition along with annexures. On said counsel released on 19th August.
Till then, let them not precipitate.
If you show the installation certificate, we'll stop it. Otherwise, no.
My submission.
Serial number 10.
Yes.
Kindly pass over, my lord.
Release of it. KRDCL. And AGA for respondent 1, so on so for respondent. Petitioner is before this court seeking for the following reliefs. The petitioner's deceased husband had been allotted the work of reconstruction bridge in Srirampura, Sale Koppalu, bracket Ashrama Road in KR Nagara Taluk under the KRDCL bridge project. The petitioner claims that her husband had completed the construction and raised a running bill ಯಾವಾಗಪ್ಪ ಇದು? In 2013.
Pass.
Rejected anyway.
So kindly pass over, my lord.
On 28/11/2013. Thereafter, the petitioner had submitted various representations at annexure G and H series, which have not been considered by the respondent. In that background, the petitioner is before this court seeking for the officer relief. Whenever any representation is submitted, it is required for the said representation to be considered and necessary orders passed, either accepting or rejecting the representation made. In either case, accompanied by reasons. Neither of them having been done, this court passes the following order. Writ petition is partly allowed. Response are directed to consider the representation of the petitioner at annexure G and H within a period of 30 days from the date of receipt of a copy of this order and pass necessary orders. It's made clear that this court has not expressed any opinion on the entitlement of the petitioner. The same would have to be considered on the basis of the contractual documents as also on the basis of law of limitation applicable thereto. Please.
Serial number 11, Kritika Raghavan.
Yes, madam.
My lord, this is a mandamus. Petitioner number 5 is an exclusively listed company.
We can't hear you.
I apologize, my lords. Is this better? This is a writ of mandamus, my lords. Petitioner number 5 is an exclusively listed company that prior to it being deemed as an exclusively listed company, was listed with the Bangalore Stock Exchange. After the stock exchange was derecognized, it was moved to the dissemination board of respondent number 4.
How can you ask for a mandamus? There must be other procedures.
No, my lords, unfortunately there isn't. If I may just point out the relevant circulars.
Yes, Ms. Nischal. They filed an application.
Yes, yes, my lords.
Lord, I'm only for respondent number 1.
1.
Union of India. I'm only a formal party in this. SEBI has to answer.
SEBI, who is for SEBI?
Nitin Prasad.
Sri Nischal Dev accepts notice for respondent number 1. Sri Nitin Prasad accepts notice, is directed to accept notice for respondent number 2. Metropolitan Stock Exchange of India.
My lords, that's the company, that's the recognized stock exchange on whose board I'm seeking listing of now.
Is there a standing counsel?
I can verify and provide the name, my lords. At the moment, I'm not aware.
Counsel for the petitioner is permitted to serve the standing counsel for respondent number 3. Issue notice to respondent number 3, returnable by 7th September. BSC, Bombay Stock Exchange, any standing counsel?
NK Dilip. NK Dilip.
So and so for respondent number 4. Counsel for the petitioner to furnish 2 sets of the petition along with annexure and set.
Grateful.
Serial number 12, Varun Jepati.
For the petitioner's counsel.
Respondent number 3.
Yes. Yes, Mr. Patel.
In the meanwhile, there was a calendar of events issued. The Lordship may kindly see the condition in the calendar of events.
What is annexure K that you have challenged?
That is the amendment of bylaw that is registered. That would be, relevant portion would be page 55. ಮೊದಲ calendar of events ಒಂದು ನಿಮಿಷ ನೋಡ್ಬಿಟ್ರೆ
55.
55 ಇದೆ ಇದು ಕ್ಯಾಲೆಂಡರ್ ನಲ್ಲಿ ಲಾಸ್ಟ್ ಕಂಡೀಷನ್ ನೋಡಿ.
ಯಾವುದು ಲಾಸ್ಟ್?
1000 rupees ಡಿಪಾಸಿಟ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿ ಟ್ಯಾಬ್ಯುಲರ್ ಫಾರ್ಮ್ ಆದ ನಂತರ ಎಂಡಿಂಗ್.
Election to the post. President 1 position, Vice President 1 position, second Vice President 1 position.
ಅಲ್ಲ, ಒಂದು ಅಮೌಂಟ್ ಡಿಪಾಸಿಟ್ ಇಂದಿದೆ ಜಸ್ಟ್.
Bylaw 6, the candidate who is contesting for shall have to deposit amount in following manner. President 1 lakh.
1 lakh. ಅದೆಲ್ಲದನ್ನು ಕೊಟ್ಟಿದ್ದಾರೆ. ಕೊಟ್ಟು ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಇನ್ ದಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್.
Shall be refunded by Sangha upon completion of the election process.
It's so effect of that is amount to be deposited. Only those can contest who can deposit the amount.
What is the bylaw? Bylaw Roman 3.
Controversy, that is, your lordships would get it at page 55.
55. Bylaw Roman 3, election regulation 3C. 55.
14. C.
The
Proposal was non-refundable deposit for election expenses. It was passed by the general body, but while registering, it appears the registrar pointed out, what is this? You are putting such a onerous condition, etc. 1 lakh rupees. So registrar passes an order. It should be refundable deposit.
This is amendment to the bylaws.
Amendment to the bylaws in which the registrar passes the order that it should be refundable deposit. Your lordships get it at page 81.
81. Yes.
Item number 6. ಸಂಘದವರು ಸಂಘದ ಸದಸ್ಯರಿಗೆ ಕಳಿಸಿದ ಬೈಲಾ ತಿದ್ದುಪಡಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದ್ದು, ತಿದ್ದುಪಡಿಯ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಇಲೆಕ್ಷನ್ ರೂಲ್ಸ್ ಅಂಡ್ ರೆಗ್ಯುಲೇಷನ್ ಶೀರ್ಷಿಕೆ ಅಡಿ ಡಿಪಾಸಿಟ್, candidates contesting for the election shall have to deposit the amount in the following manner ಎಂಬುದಾಗಿ ಇರುತ್ತದೆ. ಸದರಿ ತಿದ್ದುಪಡಿ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ನಾನ್ ರಿಫಂಡಬಲ್ ಡಿಪಾಸಿಟ್ ಎಂಬುದಾಗಿ ನಮೂದು ಇರುವುದಿಲ್ಲ. ಇದು ಕೇವಲ ಡಿಪಾಸಿಟ್ ಎಂದಿರುತ್ತದೆ. ಸದರಿ ಪ್ರಸ್ತಾಪಿತ ತಿದ್ದುಪಡಿಯನ್ನು ಸಂಘದ ವಿಶೇಷ ಸರ್ವ ಸದಸ್ಯರ ಸಭೆಯಲ್ಲಿ ಯಥಾವತ್ತಾಗಿ ಸರ್ವಾನುಮತದಿಂದ ಅಂಗೀಕರಿಸಿರುವುದಾಗಿ ಲಿಖಿತ ಹೇಳಿಕೆ ಹಾಗೂ ಸರ್ವ ಸದಸ್ಯರ ಸಭೆಯ ನಡವಳಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸಾಮಾನ್ಯ ಇದನ್ನೆಲ್ಲನ್ನು ಸಾಮಾನ್ಯ ಚುನಾವಣೆಗಳಲ್ಲಿಯೂ ಸಹ ಚುನಾವಣಾ ಠೇವಣಾ ಮಂತವು ಹಿಂತಿರುಗಿಸಲ್ಪಡುತ್ತದೆ. ಚುನಾವಣೆಯ ತಳಹದಿಯು ಪ್ರಜಾಪ್ರಭುತ್ವದ ಮೂಲ ತತ್ವಗಳನ್ನು ಎತ್ತಿ ಹಿಡಿಯುವ ಉದ್ದೇಶ ಹೊಂದಿರುತ್ತದೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸಂಘದ ಸದಸ್ಯರು ಪ್ರಸ್ತಾಪಿತ ತಿದ್ದುಪಡಿ ಬೈಲಾ ಸೋ ಅಂಡ್ ಸೋ ಸಿ ಯಲ್ಲಿ ಕೇವಲ ಡಿಪಾಸಿಟ್ ಎಂಬುದಾಗಿ ಇದ್ದಿದ್ದು ರಿಫಂಡೆಬಲ್ ಡಿಪಾಸಿಟ್ ಎಂಬುದಾಗಿ ಪರಿಗಣಿಸಲ್ಪಡುತ್ತದೆ. 55 ರಿಫಂಡೆಬಲ್ ಅಂತ ಹೇಳಿ ಮಾಡಿ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ತಾರೆ. But as far as petitioner is concerned, he is going a step further. There is no purpose will be served by this, because all that bylaw will now do is, I will not be able to contest to the post of president if I don't have 1 lakh. Because it's not even, part of it is also not even taken.
What were the bylaws earlier?
Earlier bylaw was, there was no deposit at all.
Where is the earlier bylaws?
Please, ma'am.
Annexure C. Annexure C is also approved amendments on 2/5/26. What was it earlier?
There was no deposit for contesting the election. 14.
Non-refundable deposit for election expenses.
Non-refundable deposit ಅಂತ ಹೇಳಿ ಪ್ರಪೋಸ್ ಮಾಡಿದ್ರು.
Yes.
Registrar took the view.
Page 37, Mr. Patil. This is annexure C. This is the unamended one, is what you said. There's no amendment proposed to this at all. Both of them state as non-refundable deposit.
Proposed amendment is second column. ಅದಕ್ಕೂ ಮೊದಲಿನ ಕಾಲಮ್ ನಲ್ಲಿ there was no deposit.
ಅದು annexure D.
ಅದು ಈಗ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದು.
Correct.
ನಾನ್ ರಿಫಂಡಬಲ್ ಅಂತಿದ್ದನ್ನ ತೆಗೆದು,
the requirement to deposit was always there.
No, there was no.
That is why we are asking you which
center column is the column proposing the
amendment.
Please.
Approved bylaw amendment by SGM on 2/5/26.
Last column is approved.
The last, what was it prior to this?
Prior to this, there was no.
Existing is, where is the existing?
Page 54 ತಾವು ನೋಡಿದ್ರೆ, the existing bylaw was, all the donations sponsorship collected by the subcommittee shall be deposited with Sangha and accounted after issuing the receipts and all the payments above. ಹೌದು, election ಸಂಬಂಧಪಟ್ಟದಲ್ಲಿ
Election expenses ಏನು ಇರ್ಲಿಲ್ವಾ? Was there any?
ಇಲ್ಲ, ಯಾವುದು ಡಿಪಾಸಿಟ್ ಇರಲಿಲ್ಲ.
Nothing earlier. Yes, Mr. Shetty, there is nothing earlier.
I would be correct on the facts. Even though the earlier bylaws have not been produced by them, my information remains that I don't think there was any deposit that was
There was no
calculated earlier to this amendment. That is my knowledge. We can get instructions.
There was no clause.
I don't think there was any.
I don't think, Allappa. Yes or no?
There is not. I can ascertain and also submit.
By afternoon, you can make your submission.
Only one
By
submission
by afternoon, I will get the.
Only one submission I would make in this matter is, now what had happened was the amendment to the bylaws came to be passed by the general meeting. When earlier what was proposed was a non-refundable deposit itself, that also I stand corrected on the fact. But in the SGM, they did not want to make it as a non-refundable deposit. They just mentioned deposit for contesting the election.
Where is that?
Yeah, that is what was approved. That's what is mentioned in Annexure K also. So Annexure K, what the registrar held while accepting the registration is, you cannot retain the amount. General election rules also offers for refund of deposit post the election. So you make it a non-refundable. Accordingly, a non-refundable deposit was introduced, corrected into the submissions. That is the only grievance they have before this honorable court. Now, only my submission before this honorable court is this petitioner number 1. In fact, in page 66, my lords would kindly see. In page, he lodges a complaint 65. Relevant portion is in page 66.
Yes.
Where in the first paragraph he says that non-imposition of a non-deposit itself is a bar on people who cannot afford it.
Correct.
And his petition before this honorable court is it should not be refunded also.
No.
His case is his grievance is that now we have introduced it as a refundable deposit. Now we introduced it as a refundable deposit. That seems to be his grievance. It should not be refundable. It should be held by the society.
We understand.
Yes.
Is that what it is, Mr. Patil?
No, that's not. We don't want the deposit as it existed earlier.
No. Kindly see the petition. What are the grievances that
we need
have?
3 facts.
Yes.
What was the clause as regard this deposit, refundable or not?
Maybe taken at 230, my lord, I'll
prior
give
to
that.
this amendment. Now, amendment has been approved by the SGM. It's a contractual issue.
Yes, please.
So if the contractual issue, it will go to civil court. We need the resolution and we need the earlier.
Now, another important aspect is the petitioner number 1 himself says deposit should not be taken. Here, if the petition amendments are seen and the prayer is seen, he wants this collecting of deposit has been, that aspect of the matter. Otherwise, he himself is applied.
Everybody wants a lot of
No, he
things,
himself.
but you will have to show us what the.
No, he himself is applied and taken refund. He is become an ineligible applicant in the election process. He himself is taken refund of this money. The petitioner number 1, who is before this honorable court.
He is not.
He is given a deposit also.
He did a deposit.
He did a deposit, and he is taken a refund.
If he had done a deposit, he can take it later. Why was it to be taken now?
He become an ineligible candidate. Petitioner number 1.
Can Sariyak check ಮಾಡಿ, Mr. Patil?
Those aspects tomorrow I will.
Kindly call it at
Tomorrow. We'll have it tomorrow.
Great.
Then
AGA accepts notice for respond number 1 and 2. Shri S. Shekhar Shetty, who has filed KVT, accepts notice for respond number 3. He is directed to place on record the bylaws as existent prior to the proposed amendment, the resolution proposing the amendment, and the details as regards whether the petitioner had made any deposit or not.
13, H. Mohan Kumar.
I appear for the petitioners.
Yes.
This is very unfortunate that the litigants had to come before this honorable court for getting NOC from the council.
NOC from the council.
That is the only
It is
issue
very
for this
unfortunate.
honorable court. Now, the facts leading to the case is an MBC case came to be filed during the year 2025, July. And after 1 month, the petitioners in the MBC case, they claim NOC from the advocate on record. And when he declines, they approached the tribunal in an interlocutory application. That is in the month of August 2025, which was kept before the court for 1 year, and the claim of the petitioners came to be rejected by an order dated 15/6/2026. That can be seen at Annexure C, more particularly at page 26. As far as obtaining NOC is concerned, the petitioners can redress their grievance before the proper and appropriate forum. The petitioners cannot file interlocutory application in person when there is already an advocate on record. Hence, the present application filed by the petitioners under section 151 of CPC seeking change of counsel is rejected as not maintainable. And this is not a list between the other respondents.
But that counsel is not a party to these proceedings.
Yes, he cannot be made a party because he is not.
He is the one who is objected.
I understand.
Okay. Any order passed here would be.
I'm very precise on the order made by the learned judge. Whether I can maintain an application before the court for getting an NOC from the council on record or not. That is the only question to be dealt with. And I am relying upon the order passed by this honorable division bench of this honorable court. Para 7.
But the issue is that he was heard when this order was passed.
Yes.
And he is not a party here.
And if it's
Now, if
so
we were to
necessary, I'll make him a party.
Make him a party. Let us ask him. National General Insurance.
L. Shrikant Rao.
L. Shrikant Rao for respond number 3. Who had appeared for 1 and 2 is L in this.
I don't think the notice
All
is required
causes.
for the other respondents. We have no grievance against those.
Notice to respond number 1 and 2 is dispensed with. Learned counsel for the petitioner seeks for and is granted a week's time to make the earlier counsel a party. Respondent in
Should I make an application or?
Make an application.
Please.
Relist on, when will you make the application?
This week only.
Relist on 12th August.
Please.
Serial number 14.
Yes.
Mandamus Lord seeking directions, Lord, the respondents to remove the digital imprint, Lord. The FIR and the proceedings were quashed, Lord, against the petitioner. The petitioner, Lord, the issue here is that the petitioner is a resident of America. His visa is up for renewal. And when it is searched on the web crawler, Lord, the name still reflects, Lord, in spite of the quashing order. The order is at Annexure A, Lord. Notice may be issued. I'm not seeking any interim order, Lord.
It's only at the FIR stage or crime
It was
stage?
at the FIR stage that and the FIR is still reflecting on the KSP portal, my lords. Now what happens here, my lords, is that
AGA accepts notice for respond number 1 to
4. Manu Kulkarni for 5.
Manu Kulkarni for respond number 5.
Ditya Singh for.
I appear for 6 and 7 minutes. I'll take notice for 6 and 7.
Jaisimha Rao for respond number 6 and 7. Counsel for the petitioners furnished 2 sets of the petition along with annexures on said counsel. Relist on 19th August.
Please.
Grateful.
15, N.R. Ravi Kumar.
Petition. This petition, my lord, she has purchased the property, my lord, to the extent of 1 acre, 10 guntas, on 6/3/2002, my lord, under the Bhu Vaditana Yojana, my lord. She has availed the loan from the third respondent and provided the loan facility and purchased the property, my lord. Now the third respondent had put the permanent restriction not to alienate the property, my lord.
My lord, cooperation, my lord.
It's a loan. It's a loan, man.
I understand, my lord.
Ambedkar Development Corporation. Yes.
Dr. S.V. Girikumar.
Girikumar and AGA for respond number 1, S.V. Girikumar for 2 and 3. Counsel for the petition. Furnish 2 sets of the petition. This matter is connected, my lord. This matter is
ಮೊನ್ನೆ
connected.
ಇನ್ನೊಂದು ಬಂದಿತ್ತಲ್ಲ?
ಇನ್ನೊಂದು ಬಂದಿತ್ತು ಅದರಲ್ಲಿ.
Connect with WP number.
20489.
ಯಾವತ್ತಿದೆ ಅದು ಡೇಟು?
10 ಗಿದೆ ಸರ್. ಈ ತಿಂಗಳೇ 10 ಇದೆ.
10/8.
ಮಚ್ಚೋಬಳಿ.
16, Rashid Chitra.
Petitioner. The petitioner is the insurance company seeking recalling of the settlement reported before the
recalling of the settlement.
The facts leading to the case are two KSRTC buses were involved in the accident. One was insured with the petitioner, and the tribunal passed a judgment fixing liability of 30% against me to pay the compensation. Against that, the company challenged the judgment. Wide annexure A, the Honorable Court, Your Lordship, come to page number 28. In this instant case, the driver of the KSRTC bus was rash and negligent and has caused the accident. I am of the view that the tribunal is not right in appropriating liability in ratio of 30/70 between Volvo bus and KSRTC bus. I hold that the appellant insurance company is not liable to pay the compensation. Subsequent, though the petition was filed by the petitioner earlier to the judgment and he was a party in the proceedings, subsequently he moves this was not connected and he moves before the local adalat and gets a settlement done of 50,000.
MFA 9512 came to be disposed.
All the six judgments were
Series, yes.
common judgment was possible, and subsequently the matter came to be settled before the tribunal, and by with all bona fides the petitioner has settled the matter.
Yes.
In 2014, the judgment passed in writ petition, the MFA is in 2013, and now in 23 they have filed an execution petition, and arrest warrant has been issued. And have filed my detailed objections. It is by annexure A, annexure D, I'm sorry. So the amount involved is 50,000. Since the liability,
You succeed and they're accordingly allowed. The appellant were
the
insurance company.
Insurance company was the appellant.
Judgment and order directing appellant to depart 30% is set aside. The respondent corporation is directed to depart the entire compensation within a period of 6 weeks. What is the execution petition filed? Page number?
Execution petition is wide annexure C is the execution petition for which I have filed my objections.
Page number?
Page number 32.
32.
And he was aware of the fact that the company has been exonerated. He was a party to the proceedings in the MFA.
It's a different matter. This is MFN
95.
99.
That is MBC. 9513 of 11 is his.
Where is Vijay H. Madhusudan? He is not a
Yes,
party. in
9513 of 2011 is my appeal. It's referred to at page number.
Vijay Madhusudan. Yes.
Vijay Madhusudan, page 15.
ಮತ್ತೆ ಇದಕ್ಕೆ
9939 is the MVC number.
3250 ಏನಿದು MFA 3250.
3250 is filed with the petitioner, the first respondent. That was not clubbed along with this appeals of the company, and subsequently it was settled before the local adalat, and with all bona fides the petitioner settled the matter.
It is appeal filed by them.
Yes, my lord.
Your appeal came to be allowed. Their appeal you settled.
They settled subsequently after one long year. That could not connect the matter. That's the.
Your officer has signed it.
Yes, it has been done.
And you are bound by it.
Not because these facts and circumstances.
What is the point in having Lok Adalat if you are going to come and say, no, no, I
Because-
did not know?
Because he was a party to the proceedings in the MFA.
What action have you taken against your officer who has signed this memo?
I have no idea.
Pay the money. Petitioner, insurance company is before this court seeking the following reliefs. The submission of the counsel for the petitioner is that the award passed in MVC number 9939 of 2008 had been challenged by the petitioner in MFA number 9513 of 2011 successfully, and it was the respondent Road Transport Corporation who was directed to deposit the entire amount. On that basis, he submitted that execution proceedings could not have been filed by the claimant and a warrant be issued in the said matter, in the said execution proceedings. A peril of the papers indicates that the claimant had filed one other appeal in MFA number 3250 of 2012, which had been referred to the Lok Adalat, and before the Lok Adalat, a settlement had been arrived at on 21st November 2014, when the insurance company had agreed to make payment of a sum of rupees 50,000 without interest, in addition to the amount already awarded by a tribunal in full and final settlement of the claim amount. It is recording this settlement, this joint memo. This settlement was recorded by taking into consideration the joint memo which had been filed, signed by the claimant and its counsel, the insurance company and its counsel. The submission now made by the learned counsel for the petitioner is that since MFA number 9513 of 2011 had been allowed, the appeal filed by the claimant in MFA number 3250 of 2012 could not be connected to the said matter, and much subsequently, on 21st November 2014, a settlement had been arrived at, which could not have been so arrived at after a period of 1 year of the disposal of MFA number 9513 of 2011. This court is unable to agree with or accede to the submission made by learned counsel for the petitioner, inasmuch as a responsible officer of the insurance company has signed the joint memo agreeing to make payment of a sum of rupees 50,000 in full and final settlement, which has been accepted by the claimant. The payment not having been made, despite a lapse of nearly 9 years, execution case number 1467 of 23 was filed. It cannot now be heard for the insurance company to contend that no settlement could have been arrived at in MFA number 3250 of 2012 after a settlement was so arrived at and signed by a responsible officer of the insurance company. On inquiry, if the said officer was authorized and if any action has been taken against the said officer, learned counsel for the petitioner submit that no action has been taken against said officer. That being so, when the said officer is authorized to enter into a compromise and has entered into a compromise in the scope of and course of his employment, the insurance company is bound by the settlement arrived at. No infirmity can be found in the settlement arrived at in MFA number 3250 of 2012. Consequently, in the filing of the execution case in EP number 1467 of 2023, no grounds being
A
laid on petition.
waiting time of 30 days could be granted, but they will process and I will say, I will advise them to.
Since the submission is made by learned counsel for the petitioner that the payments will be made in 30 days, the execution court is directed to provide a period of 30 days from today to the petitioner to make payment of said money, said amounts. The said amounts to be paid without any delay by 10th September.
I have advised them, but they
We are getting all these local. I did not sign. I was not advised. Fraud. Once you sign, you are bound by it. Next,
17. KV Babu.
Mr. Bagur.
Lordship, I am for the petitioner.
Yes, please.
I am challenging annexure E, page 51 of the writ petition, Lordship. I had taken a car loan from the respondent bank, and they have merged it with some other loan account which I am having with them and declared it as NPA. No, Lordship. Write para number 3 of this notice.
Page number?
Line number. Yes, Your Honor.
Page number?
Page 51, Lordship. Page 51.
51.
Yes, Your Honor.
Yes.
Para number 3, line number 3, Your Honor. The bank shall repossess the vehicle hypothecated by you as security towards the loan through Messrs. AAS Associates acting as bank's authorized recovery agent for repossession/sale, Your Lordship. Para number 4, Your Lordship, you are requested to cooperate with the recovery agent and deliver possession of the vehicle together with all switch keys and so many other accessories and all other things. Pursuant to this notice, Your Lordship, if Your Lordship can come to page number 54, Your Lordship. The bank sent goons to my house, Your Lordship. 54 and 55, Your Lordship.
Yes.
They can be seen sitting in the reception area, waiting for the whole day to take over the vehicle parked in the parking lot, Your Lordship.
So you made them wait for the whole day?
They came because I was not there, Your Lordship, and the reception did not allow them to enter the premises, Your Honor.
Yes.
And at page 56 is the reception register where they make the entries, Your Lordship.
Yes.
So, Lordship, it is a decided issue that you can take possession of the vehicle only by a due process of law, but not sending by a muscle man to my house, Your Honorship. Therefore, I am before this honorable court, Your Lordship.
How much is the amount due?
3 crore, Your Lordship.
And how much are you willing to deposit now?
Lordship, this is part of another proceedings, Lordship. The bank has merged it. I am prepared to pay whatever the decree comes, Your Honor. I am not saying that I will not follow the due process of law. Bank should not use muscleman to recover my gadi, Your Honorship. That's my humble submission.
It's a hypothecation agreement, Mr. Babu. They are entitled.
Yes, Your Lordship.
This is not a surface of proceedings.
I appreciate Your Honor, but they should not send goons to recover.
You are not paying. They are not the goons. You are calling them the goons. They don't look like goons.
They come and sit in my office in the reception area. They create a ruckus. If Your Lordship can see the mail from the reception manager. So my humble submission is let the proceedings go on, Your Lordship. In the they have also filed a case in the DRT.
Yes.
I am not saying I will not go by the law. My only humble submission is let the process of law be followed, Your Lordship. They cannot take over a vehicles by use of muscle man, Your Honor.
They are entitled to recover a mobile property. It's a hypothecated one.
Not by use of muscle man, my Lordship. It is a settled position of law. If Your Lordship will give me opportunity, I will produce the citations before Your Honor.
Please produce it. State Bank of India.
Yes, Your Lordship. I will produce because it is settled. This is a matter before a court, Your Lordship. How can they send muscle man to my house, Your Honor?
We are aware of the judgment in Standard Chartered.
I will produce the judgment.
They came and barged in. Here they have sent you a letter and asked you to hand over.
Yes,
you are not handed over. Have
yes,
you
Your
handed
Lordship.
over the vehicle?
No, Lordship. We haven't handed over. They didn't enter the party.
Will you hand over the vehicle tomorrow?
No, Lordship. Because there is a case going on in DRT, let them settle via, because it is not an NPA, Your Honor. My argument is this is not NPA. How can they declare this? Suo moto and declare
to furnish 2 sets of the petition along with annexures on the said council, released on 19th August. Next.
Number 18, Madhukar MP.
Please, Your Lordship.
For the petitioner, my lord.
Yes.
The petitioner was arraigned as accused number 10 by the Canara Bank on the basis of a complaint lodged by the Canara Bank, my lord. Then, my lord, charge sheet was laid, my lord. In the charge sheet, her name has been dropped on the count that she has repaid the entire loan amount, my lord. In spite of that, my lord, Financial Intelligence Unit has continued her name in their records, my lord. And for that reason, I have sought for expunging her name from the records because that has been being circulated with all the banks, my lord. I am unable to avail any banking services, my lord.
Manoj, I appear for respondent number 1 and 2. I take notice, Manoj.
Access notice for respondent number 1 and 2. Canara Bank?
Pro forma defendant, my lord. Presence may not be necessary.
That's not
They are the
correct,
ones who have
my
to
lord.
say that the amount has been
So,
paid.
in fact,
that has been recorded in the charge sheet, my lord. In
My
the year
lords, my-
2020 itself, it has been recorded. I request my lords to kindly take page number
For
49.
respondent. Page?
49, my lord. At left side column, my lord, name of Netravati is mentioned. Serial number 2 is my name, my lord. There is a, the note is mentioned, my lord. ಮೇಲ್ಕಂಡ ಕ್ರಮ ಸಂಖ್ಯೆ 1 ಮತ್ತು 2ರಲ್ಲಿನ ಆರೋಪಿತರು ಬ್ಯಾಂಕಿನಿಂದ ಮಂಜೂರಾಗಿದ್ದ ಸಾಲದ ಮೊತ್ತವನ್ನು ಕಟ್ಟಿ ತೀರಿಸುವುದರಿಂದ ಸದರಿಯವರ ಹೆಸರನ್ನು ದೇಶಾರೋಪಣಾ ಪಟ್ಟಿಯಿಂದ ಕೈಬಿಡಲಾಗಿರುತ್ತದೆ. Lord, this FIU is required to review the records from time to time. Then they have to update it, my lord. That has not been done in this.
Yes, madam.
My lords, my instructions from the FIU is that, my lords, we're an intelligence agency. We don't deal with any banks or give any of our information. It's all classified. The bank has itself, my lords, classified this as a fraud. It is not at our instance. The fraud, the reason for that is at page 38 in their own writ petition, namely that they've given bogus ITRs, etc., and the vehicle was never availed. So, my lords, FIU is not a necessary or a proper party. It is between the bank and the petitioner, my lords. Secondly, my lords, kindly see there is not a shred of document to show that the FIU has undertaken this. They've only produced some database that they have themselves written up based on information from other financial institutions at paragraph 8. My lords, the source of this data is not disclosed in the petition, my lord. Therefore, my humble submission, my lords, even in the objections that I am to file, FIU is not a necessary or proper party. Their role is not to indicate.
This database is not maintained by respondent number 2?
No, my lords, this is the averment at paragraph 8 is denied, my lords.
Yes.
My lords,
So where did
FIU
you
is
get these details from?
My lord, from the bank, I have got this detail. I have noted down, my lord, because they will not provide those information. And they have informed me that
You say it is on a database maintained by respondent number 2.
the database shared by the data, which is shared by the respondent number 2 with the banks, my lord.
My lords, my instruction
And
is that we deal with only reporting entities. A bank is not a reporting entity. We have not
If
shared
they
any
say that
information to
they
any
won't
bank.
share this type of data, my lord, that may be recorded, my lord.
Let the bank
Yes,
come.
my lord, no problem. Yes.
My lords, kindly
Bank
see
has given you
This information has been given by the
So
bank.
your dispute is with the bank.
The,
Yes, I
no,
should.
various banks, my lord, they are not they are not providing any banking services to me because of this entry.
Which bank has reported this?
My
This is
lord,
Canara Bank.
one of the financial institutions, not the respondent bank.
Fraud
Kindly
reported
see
in
paragraph 8.
13 accounts, Canara vehicle and MSME loans of Amina Kanu and 34 others sanctioned by Ms. So-and-so in collusion with the customers mediators at Kannamangala branch. Kannamangala branch of?
The Canara Bank, my lord.
You made JC Road branch.
My lord, this is the information what I have received from the JC Road branch, my lord. For that reason, I have made them as a party. It was closed long back in the year 2020 itself, my
Where
lord.
is your account?
My lord, my account was with the Canara Bank, my lord. That account has been
Which
loan
branch?
account.
Which branch?
Yes, ma'am.
Which branch did you
Yes,
avail
my
of
lord.
the
Yes, my lord. The loan account was with Kannamangala village and Devnahಳ್ಳಿ branch, my lord. I will take notice to them also, my lord.
Why did you make JC Road?
When I approached them, my lord, they have informed this
Why
particular
will you
information.
approach JC Road when your account is with Kannamangala, Mr. Deshmukh?
My lord, that account is closed, my lord, in the year 2020 itself. And when I approach for the further financial services, I will
Doesn't
make both of
inspire-
them as a party, my lord.
Doesn't inspire any confidence. Here can TP Mutrana. TP Mutrana for respondent number 3.
My lord,
Mr. Mutrana is directed to secure instruction as regards, sorry, Ms. Nayantara BG Learned Counsel for respondent number 1 and 2 submit that the second respondent does not maintain any database. Is the banks who are the reporting authorities and those information are captured. Her submission is that dispute, if any, of the petitioner is with the bank and not with the respondent number 2. Hence, TP Mutrana, Learned Counsel for respondent number 3, is directed to secure instruction, make a submission as to whether there is any reporting made by respondent number 3 as regards any fraud committed by the petitioner. If so, to place the same on record. Released on 19th August.
My lord, I may be permitted to add the another branch address also, my lord, so that the service can be made up to the.
To file an application, we can't add like.
Yes.
19.
I'm grateful.
Mr. Sriram?
For the petitioner.
Sorry?
I filed a petition challenging Annexure C, my lord. In this
Ah.
case, my lord, the respondent number 4, Police Inspector of Artinagar Police Station, submitted the report before the respondent number 3, stating that the petitioner is a rowdy sheeter within their jurisdiction. The report recommended initiating extrement proceedings against the petitioner under section 55A and 55B of Karnataka Police Act to banish him from Bangalore city. On this notice, the respondent number 3 has passed the order stating that to be is extrement for from 24/6/26 to 23/6/27. Your Honor, in this case, the order passed by the DCP is respondent number 3 is page number 18, Milad. Milad, in this case, is having only 3 cases, Your Honor. From 11 months, he is not having any cases, Your Honor.
You were heard in the matter.
Milad, I filed an application to stay the proceedings until the discourse of this.
You appeared, your counsel has appeared, you made your
Yes,
submission.
Milad. Yes, Milad. I appeared and filed the objection before the respondent number 3, Your
Appellate
Honor.
remedy. You go on an appellate remedy. And AGA accepts notice for respondent number 1 to 4. What is being challenged? Petitioner is before this court seeking for the following reasons. What is being challenged is an order passed under section 55 after notice having been issued and opportunity having been provided to the petitioner to file his objection and being heard. In that view of the matter, the petitioner has a statutory appellate remedy under section 59, reserving liberty to the petitioner to avail the statutory appellate remedy. The petition stands disposed. IA 1 of 26 stands. We'll come back in 5 minutes.
sought for mandamus.
Notice has to go.
These
And AGF for respond number 1, KB Monish Kumar for respond number 2, issue notice to respond number 3 and 4, returnable by 10th September.
21, K.S. Harish.
Even I appear for the respondent.
Petitioner, my lord.
One submission, my lord, before my learned friend begins. My lord,
You know,
there is
notice order agilla.
There is an appeal remedy, my lord. He's availed the opportunity also. Before the order could be passed, he's approached for this honorable court. My lord, let the appeal be decided, my lord, and then, my lord.
You know, notice order agilla. I'll clarify the appeal remedy. Kindly. Really. It would have been appropriate for my learned friend to wait for his turn. Anyway, my lord, this is the policy under which, my lord, the petitioner, my lord, is a senior.
What are the facts, Mr.
Lord, facts are like this. Lord, the petitioner, Lord, is one of the most decorated, Lord, scientific officers of the country, working in Indian Institute of Science for the last 30 years or so. Lord, he completed his basic education here in India, Lord, then went to went USA, Lord, and came back in the year 94. Since then, he has been associated, working with the Indian Institute of Science. Lord, for a brief period, about 3 years, Lord, during 2017 to 2021 to 25, Lord, he was not the director of AICTE, All India Council for Technical Education.
Yes.
Lord, while working there, Lord, he is a principal contributor, Lord, to the Chenab Railway Bridge project. My lords would be aware. Lord, Chenab Railway Bridge, my lord, in Jammu and Kashmir is the tallest railway bridge in the entire world. Lord, for that, Lord, the geotechnical, Lord, science, Lord, the petitioner is an expert. Lord, he would give a complaint on 19/11/2025 to the Indian Institute of Science that in relation to the work conducted by him for the Chenab Railway Bridge project, Lord, one of his juniors, who is respondent number, arrayed as respondent number 11 before this honorable court in this petition, Lord, has conducted several instances of research misconduct. So, Lord, the petitioner would give a complaint to the director, Indian Institute of Science, not seeking to investigate into the matter. But the director would form a committee known as the Academic Integrity in Research Committee. That is the guideline which I have placed before my lords.
Yes.
And that guideline, as my learned friend says, has 8.1, guideline 8.1 provides for an appeal remedy. 8.1, any person aggrieved by the report cum findings of the and the consequent action taken by the disciplinary authority may file an appeal to the competent authority as per bylaw 22 of the scheme, regulations, bylaws, if aggrieved party is an employee, and to the director if the aggrieved party is a student. Now, Lord, kindly see bylaw 22. Lord, may I pass on, Lord? Bylaw 22 is from the scheme, regulations, and bylaws. Kindly come to page 54. My learned friend will not dispute that to me and to Professor the respond number 11, the disciplinary authority is the council, not the director. Kindly come to page 54 minutes.
Yes.
Your Lordship just saw 8.1. It says appeal shall be to the authority as specified in bylaw 22.
Yes.
Now kindly come to bylaw 22 at page 54 of the other printout which I just submitted. Your Lordship will see a table here. In the table, my lord, appellate authority is item 4. Appellate authority is the council in respect of all cases where the disciplinary authority is the director. The disciplinary authority is the council, not which is not higher in not position.
Why is in your case, how is it the council?
Not I am the teaching and non-teaching teaching staff. Not I am the teaching staff. Not I am grade A. Group A, my lord, I'm sorry.
The
Your lordship will see.
disciplinary authority is not against you.
No,
You have
not,
filed
not,
a complaint
but even
against
the respondent number 11 is group
respondent number 11. What is the post held by
A.
respondent?
Is also group A.
Is also group
Is also group A. So the disciplinary authority is the council. So, my lord, there is no appellate authority as provided here. Though, my lord, by wrong understanding of law, the petitioner filed an appeal before the appellate authority, understanding it to be the council. And though, my lord, in my writ petition, I have stated, given an undertaking that I will withdraw the appeal.
Your 8 point, there's no conflict takes place.
No, no conflict. No.
Competent authority, any person aggrieved by a report come finding and the consequent action taken by a disciplinary authority may file an appeal to the competent authority as per bylaw 22.
Yes.
Of the scheme if aggrieved party is an employee.
Yes.
And to the director if the aggrieved party is a student.
Yes.
Only if a student then it is a director.
No, my lord, in appellate authority is provided in bylaw 22. Yes, my lord, I read that. I read that. What my lord says.
These rules, ethical guidelines apply to students, to the faculty.
Yes, ma'am.
Everybody.
Yes, ma'am.
Faculty will come under rule 22.
But faculty is not here. Of course, my lord, the term employee is used. My lord, I will not dispute there for a moment.
If you come to clause 1.4.
Yes.
This policy shall apply to all individuals, including all faculty, scientific staff, students, project assistant who may be involved in research in the institute, to so and so.
Yes, ma'am. So the employees are there who are not faculties also. So, my lord, I will not dispute there for a moment. It may not be relevant also. But bylaw 22 nalli appellate authority yaru anta kottidare?
Aitu council.
Council in respect of if the disciplinary authority is the director. My disciplinary authority is the council itself.
For even respondent number 11.
Yes, yes, yes. In any case, my lord, I have also contended that my lord, opportunity of hearing has not been granted. My lord, those other my lord, natural justice, my lord, those contentions also have taken. But now, my lord, sitting here, I have to my lord, confess, while sitting here when I was going through, my lord, the appellate authority, my lord, in relation to my lord, a petitioner or the respondent number 11's issue, Lord, there is no appellate authority provided.
Lord, may I, Lord, if your lordship sees this policy, my lord, policy for academic integrity and research, my lord, this my lord proceeding should not be confused as though, my lord, it is a proceedings under CCA rules for disciplinary action. One. Secondly, my lord, insofar as petitioner is concerned, yes, my lord, if there is a complaint filed against the petitioner, disciplinary authority, my lord, would be the council. My lord, insofar as others are concerned, especially, my lord, a complaint under the ethics policy.
What about respondent number 11?
Yes, my lord. Again, that is what I'm coming to.
But yes,
even against respondent number 11.
Group here.
Even against respondent number 11. My lord, the disciplinary authority should come to a conclusion as to whether a minor penalty proceeding should be initiated or major penalty proceeding should be initiated. That is why, my lord, if your lordship comes to page 55 of the rules, disciplinary authority, Lord, in rule 3, if your lordship come to number 2, director for minor penalties in respect of teaching and group A non-teaching staff. The very same, my lord.
Major penalties in
Lord, disciplinary authority has not yet come to a conclusion whether disciplinary proceedings as against respondent number 11 is to be taken, not taken, my lord, or whether the report submitted by CARE is the ethics committee that is formulated under this act. My lord, in fact, if your lordship sees these provisions also in this proceedings also, my lord, what the report that is now submitted by CARE is a preliminary investigation report. Now, whether action of disciplinary proceedings should be taken on that, whether minor penalty proceeding should be taken, major penalty proceeding should be taken, that is a decision that is yet to be made by the institute. Lord, it is at this stage that the petitioner has approached this honorable court. Lord, no action under, my lord, either under rule 22 of the bylaw, that is, my lord, rule 21 of the bylaw, which provides for conduct, or, my lord, rule 22 of the bylaw for disciplinary action is taken yet. My lord, a complaint was filed, ethics committee was constituted, they have submitted a report. Now, whether the disciplinary authority accepts it, rejects it.
Now, the preliminary inquiry of CARE has been submitted.
CARE has been submitted. Now, whether the disciplinary authority accepts it or rejects it, my lord, it is at that stage that the petitioner has approached this.
And that is
therefore, my lord, let the order be passed by the authority. Lord, if the disciplinary authority comes to a conclusion that the complaint filed by the petitioner against
Who is the inquiry authority?
Lord, inquiry committee is not yet constituted.
But the
Not yet
preliminary
constituted.
inquiry committee is constituted under
Care committee
this.
is constituted as per the act. If your lordship sees this act, in fact, my lord, I'll read out the, to get more clarity, I will read out, my lord, the procedure for conduct of inquiry. Your lordship may kindly take this, my lord, my learned friend submitted
Yes.
this policy. Now, my lord, in
Six.
that, your lordship will see, my lord, page 6, rule 3E. Your lordship has rule 3E, my lord.
Yes.
Also known as fact-finding
But in that
inquiry,
case,
is
may
a
I
process
request
of
not-
evaluating the veracity of complaint, which in all cases will be conducted by the care. Now, my lord, care is the,
But in that case, may I
the very
request not- I will
same
present
report
my
which is
case.
presented. My lord, report
You
is
will
at
present
annexure
my
A,
case.
page 36.
I will present my case. my lord.
You asked him to make a submission, that's why we
No,
asked
I
him.
didn't ask, my lord. My lords asked a query only.
Let him show appeal ಅಂತ ಹೇಳಿದ್ರಿ ಅದಕ್ಕೆ
I'll
show
just
appeal ಅಂತ
conclude this,
ಹೇಳಿದ್ರಿ.
my lord, page 38 of the writ petition.
ನೀವೇ ಹೇಳಿದ್ರಿ.
ಆಯ್ತಾ? ಆಗ್ಲಿ.
I'll just conclude this, my lord.
Let him make a submission.
But the facts are like this.
Yes.
Not petitioner has been, as I submitted, is a senior, one of the decorated scientists. He is associated as principal consultant for.
That you already made your
Yes.
submission.
Having submitted this complaint on 19/11/2025, annexure F, there was no action taken on my complaint for a very, very long time, almost 6 months. I also submitted a reply, I'm sorry, a reminder on 27th April 2026. Till then, not kindly see 19th November 2025 to April, end of April 2026, almost 6 months, nothing took place. The policy requires, my complaint has to be disposed of within 45 days. But there are
Is that why
judgments.
you are here?
No, not just that, not just that. But also the fact that the policy requires that if there is not a response from the respondent, but it has to be put to me. There has to be a discussion on the.
Show us the policy, Mr.
Yes, policy. Kindly, my lord, kindly come to the policy itself.
Yes.
Your lordship, my lord, saw the introduction under clause 1.
Show us the relevant provisions.
Lord, the complaint was in relation to research misconduct, which is defined, Lord, in item number 2. Specifically, Lord, falsification, plagiarism, and misrepresentation.
Yes.
Thereafter, Lord, definitions are there. Item 3, clause 3, who is a complainant? Lord, Committee on Academic Research in Lord, 3B, also known as CIR, is the committee formed by the director and will consist of such members as deemed fit by the director to preliminarily inquire into a veracity of a complaint as per clause 5 of this policy. Then disciplinary authority means the authority defined under the bylaws 22.1 of the scheme research and bylaws, who is competent to impose any of the penalties enumerated in this policy if the respondent is an employee or the director, if the respondent is a student non-employee. Again here, kindly see, clause D, there are two different things. If the respondent is an employee, it is the disciplinary authority, or the director is the respondent is a student or non-employee.
Yes.
Slightly different from what is in 8.1. Then preliminary investigation, also known as fact-finding inquiry, is the process of evaluating the veracity of a complaint, which in all cases will be conducted by the CIR, and such preliminary inquiry will include the following steps: study and analysis of the complaint, listing the facts that need to be verified and the documents in support thereof, listing the documents and persons who can provide information on the matter, and taking their statements, and if necessary, also requesting the complainant to provide any additional information or evidence. So more or less, like a civil court, they can conduct. Then studying the information collected as to decide if there is a basis for all investigation, for a full investigation, preparing the preliminary investigation report and submitting it to the disciplinary authority along with documents and statements of the witnesses. Now, my lord, after this, kindly see, my lord, witness is also defined. Witness is any individual who gives statement to CIR during preliminary inquiry or during disciplinary inquiry. Then, my lord, compliance with laws, regulations, and policies is there. Then kindly come to, my lord, the committee itself at 4. The director has formed a special committee on academic integrity and research, which will be responsible for preliminarily inquiring into a complaint on receipt of direction from the director. If need be, the director may take assistance of the CIR to take a decision on whether the complaint so received needs to be inquired into or not. In addition, the CIR may be vested with the additional responsibility of setting and communicating standards with respect to the principles of academic integrity in the conduct of research and overseeing the administrative procedures relating to the review of any allegation of research misconduct. The members of CAR shall have a 3-year term subject to renewal by the competent authority and reconstitution at the end of every 3 years. The safeguards in section 7 shall be provided to the members of the CAR as applicable. Complaint. Any individual who discovers or comes across an act of research misconduct may make a complaint in writing and submit it to the divisional chair, dean or director as the case may be. The complaint will be forwarded to the director, who will decide whether or not to forward the complaint to CAR for preliminary investigation. This decision should be made as soon as possible, preferably within a week of the receipt of the complaint. A complaint in the first instance could provide some details on the concerns raised by the complainant, which must be followed up later to include in all relevant details, including the names of the relevant parties, names of witnesses, if any, relevant dates, list of documents, along with documents, locations, publications, and the subject matter of research misconduct in question. On receipt of the complaint, and before the respondent is notified of the complaint by the disciplinary authority, CAR shall take all reasonable and practical steps to appropriately preserve in a secure manner and all potential so and so on. Inquiry. Kindly come to 6. An inquiry into a complaint shall consist of 3 phases. Preliminary inquiry, which is what is subject matter of challenge before my lords. Preliminary inquiry conducted by CAR, gathering of preliminary information and fact finding to assess whether such complaint has substance, and if so, whether an inquiry is warranted. The preliminary inquiry should be conducted as expeditiously as possible and should normally be concluded within 45 days from the date of receipt of the complaint, along with all details by CAR. Inquiry. This phase would start when the inquiry authority receives the report of preliminary inquiry conducted by CAR, along with recommendations from the director. The procedure to be adopted for inquiry into the complaint is provided as Annexure 1, appended to this policy. Decision and corrective action. The formal procedure for reviewing and evaluating the inquiry report and taking next suitable steps, including furnishing of report to the respondent and reviewing the response of the respondent, and finally imposing penalty. Now, kindly similar section 7, safeguards in dealing with research misconduct. When a complaint of research misconduct is given, these are the safeguards. 7.1, I'll skip guidelines. Confidentiality must be maintained. Conflict of interest, handling whistleblowers, not all these are there. 7.2, kindly similar, safeguards for the complainant. In addition to any other safeguards provided for in this policy, the following safeguards shall be provided to a complainant. In all cases of complaint, the institute shall ensure that the complainant is treated fairly and reasonably. That is item number 1. All reasonable and practical efforts are made to protect the complainant from potential or actual retaliation. Diligent efforts are made to protect or restore the position and reputation of the complainant. The item number 1 and 2, one is natural justice. I will not trouble my lords more of that.
Treated fairly and reasonably.
Yes, that is what is
Different
required.
from natural justice.
B, kindly see, all reasonable and practical efforts are made to protect the complainant from.
Has anybody retaliated against you?
The respondent number 11, she files a complaint against me of workplace harassment. Not sexual harassment. My learned friend will not dispute that. Workplace harassment in March 2026, when I have just joined back. After I was deputed in AICT.
That will be separately inquired into.
It should have been. It should have been protected. At least the complaint. Yes, I'll just let me complete in relation to 7.2b. And at least till my complaint was to be disposed of within that 45 days or any other reasonable time.
Until a suit is disposed of, counterclaim cannot be filed.
I'm not saying.
Good jurisprudence.
I am not submitting. I'm not comparing this to a suit. All I'm trying to say is that a retaliation should have been treated with some caution. But what they do, my lord, what they do is they go ahead, consider that complaint, issue notices to me. I approach this honorable court. This honorable court grants time up to, that is in fact expiring tomorrow, 4th August, to submit my reply to that complaint. Even before I submit my reply to that complaint, they issue a charge sheet to me. Kindly see, my complaint.
We are not dealing with that. We are dealing with.
We are not. I am only submitting that these guidelines framed by IISc have not been implemented, have not been followed by the committee itself, have not been followed by the director himself. And even otherwise, if I were to, even otherwise, my submission, my lords would not agree that there is an appeal remedy available if my lords were to come to conclusion. Lord, appeal is
We won't agree with both of you on that. Appeal is premature right now.
Lord, Lord, I
No
will
appeal right now.
Lord, I will show Lord the findings of the committee, which does not say Lord inquiry is required or not required.
This is what will be placed before the director.
Yes.
On the basis of the recommendation of the director, inquiry committee would be constituted.
Yes.
The inquiry committee then thereafter will decide whether further inquiry is to be conducted or not in terms of clause 6.
Clause
6B.
6, your lordships are right. Clause 6B.
This phase would start when inquiry authority receives the
Yes.
report.
Yes.
Only after 6C is the corrective action.
Lord,
After 6C comes 8. Once 8 is done, then 8.1 appeal will come.
Lord, this appeal,
8.1 appeal
as
is
it
too
reads,
premature right now.
as it reads, Lord, appeal, any person agreed by the report come findings and the
consequent action taken by
and the
disciplinary
consequent
authority.
action. Lord, if I am agreed by the report come findings,
Report come finding is not the preliminary report.
disciplinary
It's the
authority.
inquiry report under clause 6B.
Lord, it doesn't read so. It doesn't read so, Lord. It doesn't limit itself. Lord, this entire policy, Lord, is the CAR policy. This is different from the appeal note which is provided under the scheme regulations and bylaws.
When can the disciplinary authority take any consequent action, Mr. Herberti?
But it could be based on this report.
You deal with inquiries left, right, and center every day, appearing on
But-
this side.
But this is slightly
Any
different.
person agreed by the report come finding and the consequent action taken by disciplinary authority.
Yes,
If
Lord.
and it is.
Lord, still, yes, Lord, I would have agreed with that. But with great respect, Lord, my submission would be like, my respectful submission would be like this, that if I am agreed by this report come finding, which will not consequently lead to the next step by the director, Lord, I am still not entitled to challenge not the report.
After that, not now. Not now. This is a preliminary inquiry by the CAR.
By the CAR.
That's all.
Your lordships will reserve liberty, Lord, to me, if any Lord, consequent action is taken by the director.
Absolutely.
It's always there.
Absolutely. Both of you are saying appeal. Appeal will come only after
I
8.1.
filed an appeal. That's why I made that submission. Otherwise, that's why my first submission was
Make
no
your
decision is
submission as
taken
per
by
your
DA only.
rules,
But I am
not
only-
just because he did something or because you
I
did.
am only appalled by the situation that
authority
the
is not yet
petitioner, in
taken a
fact, Lord, even before notice is ordered, not they are hounding me like this.
That is not the subject matter of this. You should, we can't advise you what to do. Petitioner is before this court seeking. And Shri Pradeep Savkar accepts notice for respondent number 1 to 4. What about the others?
Lord, 1 to 4, my lord, only. Others are inquiry committee and then the complainant.
Notice to respond number 5 to 11 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following leaves. The petitioner is a senior professor in respondent number 1 institute, namely Indian Institute of Science, hereinafter for brevity IISc. The petitioner had lodged a complaint as regards respondent number 11 being a postdoctoral researcher having what was the specific allegation?
Lord, in the
Plagiarism and ethical
Of plagiarism
and ethical.
Your lordship could see not page 38. The committee has not serial number 1, 2, 3, 4. They have summarized it.
Page number?
Page number 38, item number 1.
Plagiarism and ethical violation.
Then item number 2 in next
of
page.
The IISc policy for academic integrity in research. Misrepresentation of the role of respondent number 11 in Chena Bridge project.
Then Lord, next item is at page 41.
The attribution of contribution within IISc and disregard of primary contributors.
Then page 43, item 4.
And ethical misrepresentation by respondent number 11. The said complaint the preliminary inquiry has been done by the Committee on Academic Integrity in Research, for brevity CAIR. And a report having been submitted, the petitioner is before this court seeking for a certiorari to quash the said report. The submission of Shri Venkatesh Arbati, learned counsel for the petitioner, is that the CIR has not conducted an inquiry in a proper manner. The petitioner has not been, the principles of national justice have not been applied to the petitioner, inasmuch as the petitioner has not been provided an opportunity of being heard in the matter before the CIR submitted its report. And on that ground, he submits that the report is required to be set aside. Though the submission of learned counsel for response number 1 is that an appeal is available under clause 8.1 of the said policy, this court cannot accede to the said submission made. Inasmuch as the scheme of the policy provides for a complaint to be filed in respect of the aspects which have been adverted to in the complaint, and a preliminary and in terms of clause E of
Rule 3.
what is this?
Rule 3. Rule 3.
A preliminary investigation is to be conducted, which is also known as a fact-finding inquiry by the CAIR. The CAIR, in terms of clause B of Rule 3, is a committee formed by a director consisting of such members as deemed fit by a director to preliminarily inquire into a veracity of a complaint as per clause 5 of the policy. In terms of clause 5, on receipt of a complaint, the CAIR, the director shall forward the same to the CAIR for preliminary investigation. 66 The inquiry is to be conducted in terms of Rule 6. Clause A of Rule 6 provides for preliminary inquiry by the CAIR, who is required to gather the preliminary information and fact-finding to assess whether such complaint has substance, and if so, whether an inquiry is warranted. The preliminary inquiry is to be conducted as expeditiously as possible and should normally be concluded within 45 days from the date of receipt of the complaint, along with all details by the CAIR in terms of clause B of Rule 6. It is this report of the CAIR which has been furnished as of now. In terms of clause B of Rule 6, the phase of inquiry would start when the inquiry authority receives the report of the preliminary inquiry conducted by CAIR along with recommendations from the director, and then the procedure as contemplated in Action 1 appended to the policy would apply. And thereafter, in terms of clause C of Rule 6, corrective action is to be taken on the basis of the inquiry report. At present, what has been conducted is a preliminary inquiry by CAIR and not an inquiry by the inquiry authority. The preliminary inquiry report is required to be placed before the director, and the director, along with his recommendation, is to forward it to the inquiry authority. The preliminary inquiry by the CAIR is not the final report, but is only a preliminary report. It is but required for the director on receipt of the preliminary inquiry report to make his recommendations to the inquiry authority. It is only on the inquiry authority completing the inquiry that the question of taking any decision or corrective action would arise. At present, the appellate remedy provided under clause 8.1 is for any person aggrieved by a report cum finding and the consequent action taken by a disciplinary authority. Such aggrieved person may file an appeal to the competent authority as per bylaw 22 of the scheme regulations bylaws. And if aggrieved party is, if the aggrieved party is an employee, and to the director if the aggrieved party is a student. The question of an aggrieved party would arise only after the report cum findings are placed and consequent action taken by a disciplinary authority and not before that. As indicated supra, the stage at which the matter is now is of preliminary inquiry conducted by CIR and report submitted to the director. It is only after the director makes a recommendation to the inquiry committee that the inquiry authority would conduct an inquiry. At that stage, there would be two options. One, for the inquiry committee to drop the proceedings, or second, to go ahead with the inquiry. It is only when such a decision is taken by the inquiry committee can the petitioner be said to be an aggrieved party, inasmuch as dropping of the proceedings would also be a consequent action. As indicated, a preliminary inquiry report having been submitted by CIR, the petitioner cannot be said to be aggrieved as of now, reserving liberty to the petitioner to challenge the inquiry report and or the corrective action and or reserving liberty to the petitioner to challenge the report cum findings and the consequent action taken by a disciplinary authority. The petition stands disposed. Great. IA1 is allowed.
22, Ananthi.
Appear for the petition in this matter. So the matter pertains to challenge to section 10 2A of BR Act, Banking Regulation Act.
10A to A1.
Yes, madam.
Ms. Nayantara BG accepts notice for respond number 1 to 3.
Yes.
Pradeep, idu RBI
File memo 1 to 3.
ನೀವು ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ? Shri Pujappa J accepts notice for respond number 1 to 3. RBI ಯಾರು ಅದರಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿದೆ? Swati Kamath for respond number 4 and AGA for 5 and 6. Issue notice to respond number 7. Returnable by the date?
I'll serve on the standing counsel, Mr. Devraj is standing counsel.
6th August, counsel for the Devraj is standing counsel.
For this bank.
Devraj is directed to Devraj?
Election Commission appear.
Initial.
Election Authority, Cooperative Election Authority. Initial, I'll serve.
Devraj Moorjana.
Otherwise, I'll take notice.
Initial lady. Devraj is directed to accept notice for respond number 7. Connected material.
A Devraj. A Devraj.
A Devraj. Since the virus of section 10A 2A1 of the Banking Regulation Act 1949 has been challenged, issue notice to Learned Attorney General, Learned Solicitor General, Additional Solicitor General accepts notice on his behalf. Amen. Same order.
Interim protection.
Same order.
Please.
Serial number 23.
For petitioner.
Yes. Yes.
This petition is filed challenging the order passed by the respondent number 1, my lord, stating that there was a direction issued by this honorable court in WP number at annexure Q, my lord, page 159.
159.
Yes, my lord. In writ petition number 35296 for 2014. There was a direction issued by this honorable court whether to conduct an inquiry of the interested parties and as well as the petitioner and consider whether the impugned notifications passed by the respondent number 2 are valid or not. A detailed inquiry was conducted by the respondent number 1, my lord. Later, I had appeared before the respondent number 1 by filing an impleading application to show cause that I am the owner of the said property through a will executed by my grandfather at annexure G, my lord.
He cannot do that.
My lord?
Only a preliminary inquiry the Deputy Commissioner has been directed to do, it is done. If you are asserting title under a will, then you will have to
No, there was a property suit was filed, a partition and separate possession. It
What
was,
has happened to that suit?
it came to be dismissed and still RFA is still pending before this honorable court. That was the contention raised by me before the respondent number 1. But on an affidavit, I had swear that things, my lord, at annexure. N, my lord, at 132 page.
132.
Yes, my lord.
Your impleading application.
Yes, my lord. I had filed an impleading application since I was an interested party to be dealt and considered by the respondent number 1 as per the directions issued in annexure Q, my lord. So I filed that. Later on, the respondent number 1 has failed to consider that I am in possession for a very long time, my lord. I produced the relevant documents and as well as the rental agreements which have been lettered out by me to the tenants, my lord, which is at annexure from H to H1, H and J, my lord. 3 rental agreements I produced,
The
my lord.
notification on the slum clearance board. Slum
Yes,
Act.
my lord. And the direction was
We
issued.
do the exercise of hearing petitioner and as regard to said notification.
Yes, my lord.
Not anything else.
My lord, but in the order of the respondent number 1, the High Court had issued, this court had issued a direction whether it is a slum board ಸೇರುತ್ತಾ ಇಲ್ಲಾಂದ್ರೆ private land ಅಂತ decide ಮಾಡೋದಕ್ಕೆ ಅಂತ ಹೇಳಿದ್ರು. But unfortunately, the respondent 1 has declared the petitioners are the owners of the said land, my lord. That's why I'm being agreed by that order. I am before this
Who
court.
are you? What is your right?
I have a will executed in my favor, my lord. Still, RFA is still pending before this honorable court. 100 but 2013, my lord, at annexure. D, my lord, page number 66. Because there was 2 wills, my lord. Both the sides did not prove before the trial.
Directed to be considered is whether the notification has been issued properly and whether it was a slum. That's how much the deputy commissioner has considered.
Yes,
now your claim would be as regards compensation.
Yes.
If compensation is required to be paid to you or to whom it is to be paid, it will be subject to result
What
in
has
the
happened
RFA.
in the order of the respondent number 1 at page, wait, my lord, I'll come to the order of the respondent number 1.
Yes.
145, my lord, page
Yes,
number.
we are seeing that.
The petitioner pursuant to the directions issued by the High Court of Karnataka in so and so, dated so and so, exercising powers conferred under the Karnataka slum area so and so, petition filed by the Mr. M.R. Ravi Kumar.
Notification is inoperative. So it is not, it won't come under the Slum Act is what they have said.
Yes, my lord.
You
And-
want it to come under the Slum Act, is it?
My lord?
You want it to become come under Slum Act.
ಇಲ್ಲ ಸ್ಲಮ್ ಆಕ್ಟ್ ಅಂತಲ್ಲ ಅಲ್ಲಿ ಅವ್ರನ್ನ ಓನರ್ಸ್ ಅಂತ ಡಿಕ್ಲೇರ್ ಮಾಡಿದ್ದಾರೆ. The direction was that whether it belong to slum or not, an inquiry has to be conducted to that effect. But
for the purpose of these proceedings, because they had opposed the final notification.
Yes, my lord. Final notification opposed ಮಾಡಿ challenge ಮಾಡಿ.
Notification has been set aside.
Yes, my lord. Based on that, they have declared as a owners at the end of.
There is no declaration. This is a deputy commissioner. He can't declare ownership. That is not what has been declared. Only for the purpose of consideration of the application.
Point number 3, my lord, of the last order.
On the so and so are recognized as owners of the subject property for the purpose
Petitioner
of
are
these,
recognized
these
as the
proceedings. Only for the purpose of their contending that it should not have been declared to be a slum.
Yes, my
had
lord.
opposed it.
But
This-
even I had produced relevant documents to the, show that I am also the owner of the soil.
A deputy commissioner cannot decide it, nor can we decide it in a writ petition.
Yes, ma'am.
Your RFA, what will be decided, then that will decide the rest. We'll observe that. and dispose.
There are chances of, based on this order, the respondent number 3 may seek for a
PG
demolition
access
order,
notice
my lord.
For respond number 1, slum clearance board.
Kindly
Pradeep
pass
Kumar
on.
for respond number 2, notice to respond number 3 to 5 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. Property bearing details. Property in survey number 136 measuring 11 guntas and survey number 136 measuring 6 guntas of Binmangla village were declared a slum and notification had been issued under the Slum So and So Act under section 3(1). The same came to be challenged by certain persons in WP number 35296 of 2014, contending that the said land was not a slum and would not come within the purview of the So and So Act. This court, a coordinate bench of this court, had ordered 8th August 2024 in WP number 35296 of 2014, directed, taking into account the submission of the Additional Advocate General, directed the Deputy Commissioner to redo the exercise of hearing of the petitioners insofar as the notification under section 3(1) of the Act is concerned, to determine whether the land was vacant land and whether the Act would apply thereto or not. When the Deputy Commissioner had taken up the matter for inquiry, the petitioner had filed an application for being impleaded in the said proceedings, claiming that the petitioner is the owner of the land, deriving title and a will said to be executed in favor of the petitioner. The Deputy Commissioner, upon an inquiry as regards the status of the land, came to a conclusion that the same said land could not have been declared to be a slum under subsection 1 of section 3, but for the purpose of passing the said order, recognize the petitioner as owners of the said property. The petitioner is before this court contending that the Deputy Commissioner has declared the petitioner therein to be the owners of the land, which he could not do. On inquiry as to whether any other proceedings are pending, Land Counsel for the petitioner submit that there is a proceeding in RFA number
1007/13, my lord.
birth code, which is pending. The inquiry which had been conducted by Deputy Commissioner was in furtherance of the order passed in WP number 35296 of 2014, only to ascertain the status of the land and whether the Slum Act would be applicable thereto. The objections having been raised by the petitioners in WP number 35296 of 2014 that the Act would not be applicable to the said lands. It is considering those objections that the Deputy Commissioner has held that the final notification dated 28/1/2014 in respect of the aforesaid land would be inoperative and that the Slum Act would not be applicable to the said land. The consideration of the objections raised by the petitioner was only for the purpose of determining whether the Act would apply or not, and not for declaration of title of the petitioners in respect of the said land. The Deputy Commissioner obviously not having any powers of such declaration, grant of such declaratory relief. In that view of the matter, the apprehension on part of the petitioner is completely unfounded. The determination of title of the property would have to be title of the as regard the property would have to be done by the first appellate court seized of RFA number so and so. The declaration made by the Deputy Commissioner, the consideration made by the petitioner was only for the purpose of ascertaining whether the Slum Act would be applicable or not, and not to determine the title of the petitioners or the petitioners in WP number so and so, or the petitioner in the present matter. Reserving liberty to the petitioner to agitate all issues in the pending RFA in number so and so. Petition stands disposed.
Much obliged.
24, Srinivasa DC.
For the petitioners in this case, my lords, petitioner is aggrieved by the order of the second respondent, my lords.
Could you be a little louder, please?
Petitioner is aggrieved by the order of the second respondent, cancelling the authorization, my lords, to run a fair right shop.
Cancelling the authorization. Yes.
Authorization, my lords, PDS. My lords, the facts of the case, my lords, on 22/11/2026, the villages of Kodgala villages with misunderstanding.
Dying a 24/6/24 order.
Yes,
2 years order, no matter. 24 order.
24 order, my lords.
And AGA accepts notice for respond number 1 to 5. He seeks for and is granted 2 weeks time to obtain instruction, make his submission.
Stay, my lords. Yes, not well. I
2
even
years.
filed a medical report to that extent. Why
27th
couldn't I come, my lords?
Not after 2 years.
My lords, I was not well, my lords. I have even filed a medical report.
Let us get their instruction whether they have
There, my
allotted it
lords.
to somebody.
No, my lords, there's a temporary authoritative person, my lords. That's why they're collecting.
So we can't state if there's a temporary authorization.
There's a B report filed, my lords, against me. That's why.
25,
I represent the petitioner.
Yes.
Petitioner, my lords, was under this Industrial Facilitation Act to allot. KDB was directed to allocate about 12 acres.
Where is Mr. Vasudev? SLSWC approved your project.
Yes, policy with the direction to the KIDB to allocate 15 acres of land. But KIDB intimated us that if 15 acres is not possible, we'll confine it to 12 acres, asked us to deposit about 5 crores, which is being 30% of the total income, which we have paid. Till this time, Lord, no allocation has been made. We have given representation.
For respond number 1 and 2, Shri Vasudev.
Only one, I may point out, of course, Lordships may issue notice. One question, Lord, which Lordships may have to consider to decide, because in other cases, the contention which the state seem to be taking is, may I point out, Lordships, kindly permit me to refer to in a connected petitions. At kindly see, Lord, Annexure C.
Page?
Annexure B, page 30.
30.
Page 30, Annexure B.
Yes.
But our contention is that there was a direction to KIDB to allocate. They have not done so. Kindly see page 32, last sentence. This approval is valid for a period of 2 years from the date of the issue of this order. But in some connected petitions, in all fairness, I must say, the learned advocate general who appears for the KIDB states that since it is for 2 years, and the 2 years period has lapsed, so this order no longer is which cannot be expected to be implemented, is a contention raised, Lord. This is something, Lord, which I'll be in a position to show before your Lordships. Until KIDB allocates, this order doesn't start.
How will the time period start?
And in fact, Lord, that is the contention raised by the learner in the connected petition. Court or daily orders.
They have to get the land to implement the
Yes,
project.
yes. In the connected my land, Lordships may kindly see page number 2.
You are giving we must summon the ideas.
No.
Please don't give him ideas.
no, I must point out, Madam Kota. There is one that in the connected petition.
We'll deal with it when it is.
Yes, yes.
No,
I'm just point out.
They may not even raise it. Who knows?
Connected petition or raise ಮಾಡಿ the learned. Anyway,
ಅದರಲ್ಲಿ ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರು BDA ಇದು KDB ಗೆ
ಯಾರು ಅಪಿಯರ್ KDB ಗೆ DB ಪಾಟೀಲ್ KDB who is it?
The same person you can issue notice.
State of Karnataka, state 1 and 2 words, the state learned friend can take notice.
Yeah, that is done.
Third respondent word, the standing council.
That was HL Pradeep Kumar. HL Pradeep Kumar is directed to accept notice for respond number 3.
Council for the some apprehension that they must not allocate.
Along with annexure on the said council. Take into consideration that the 30% of the amounts have been deposited by the petitioner. The respond number 2 is restrained from, respondent number 3 is
Three,
restrained
three.
from allotting plot number, which is that plot
No,
number?
but they have not allocated. They have to allocate.
Is not even identified.
No, it is in survey number. There is
we
a
can't
land
reach.
allocated in survey number. I'll just point out. It is in
Respondent number 3 is directed to
Sulivele Hobli Hoskote, Kamblipura village.
preserve an extent of 12 acres as indicated by the KDB earlier. A1 of 26 is allowed. Released on 27th August.
26.
My lord,
Yes,
I'm for
Mr.
the petitioners, my lord. My lord, the sixth respondent has issued the section 35(3) of the BNS Act notice to the petitioners to appear
Not
before the
maintainable,
sixth
my lord.
respondent. Then
It's issued by Atheni Police.
annexed K, my lord, it is page number 53. My lord, the petitioners are residing as the Bengaluru, but the police sixth respondent, the Atheni Police, Belgaum district, my lord, wherein the no question of issue noticed by the respondent number 6, my lord, because no any offense committed by the petitioners. But earlier, the petitioners have filed a petition before this honorable court against respondent number 7 to 9. It is pending consideration. My lord, kindly tag this petition along with my lord WP number 194, 2025, my lord. We filed suit against the respondent number 7 to 9 for a petition pending before consideration of the
1
court, my
to
lord.
6. Notice to respond number 7 to 9 is deferred for now. Connect with so and so. When is that posted?
ಅದು ಡೇಟ್ ಕೊಡ್ಲಿ ಸ್ವಾಮಿ ಅದಕ್ಕೆ 6th or 5th, my lord.
27th August.
Please, my lord.
But they are residing here.
Please.
They will have to go to Belgaum.
Please, ma'am.
Only if it is other state, we have no jurisdiction. This will have.
Please, ma'am.
This case I am seeking writ of mandamus. Annexure K, page number 36, and also seeking squashment of the endorsement issued by the respondent police. In this case, my lordship, some of the people
Certiorari, Girish, not mandamus. Certiorari to quash the endorsement.
and also consequently I seeking for mandamus, my lordship.
First certiorari ಆದ್ಮೇಲೆ
Yes, my lord.
ಈ annexure ಎಲ್ಲಿ ಏನು?
Annexure L, my lordship. In this case, my lordship, some of the person, unknown person has trespassed the land belongs to the
Civil
petitioner.
dispute, my lord.
And they have to plug the areca nut and coffee seeds. And it was restrained by the petitioner and handed over to the police. Police, in spite of lodging the complaint,
Where's your
without
complaint?
initiating the
Page 38.
Where are the
my lord.
allegations in your complaint?
allegation in the complaint, page 36, my lord.
36. Type copy 37.
Earlier complaint, which is in page number 17, my lord.
17.
17, page number 17.
And what are the allegations made?
Can I read, my lord?
Yes, please.
ಮೆಗುಂದ ಹೋಬಳಿ ದೇವೇಗೌಡ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 207/1 ಮತ್ತೆ ಅವರಿಗೆ ಸೇರಿದ 3 ಎಕರೆ ಜಾಗವಿತ್ತು. ಪ್ರಸ್ತುತ ನಾನು ನೋಡಿಕೊಳ್ಳುತ್ತಿದ್ದೇನೆ. ಸದರಿ ಜಾಗದಲ್ಲಿ ಕಾಫಿ ಹಾಗೂ ಅಡಿಕೆ ಮರಗಳು ಇರುತ್ತದೆ. ಅವುಗಳನ್ನು 4 ದಿನಗಳಿಂದ 24/11/24ರಂದು 18 ಜನಗಳು, ದಿನಾಂಕ 25/11/24ರಂದು 16 ಜನಗಳು, ದಿನಾಂಕ 26/11/24ರಂದು 15 ಜನಗಳು, ದಿನಾಂಕ 27/11/15 ಜನಗಳು ಪ್ರತಿದಿನ ಬಂದು ಕಾಫಿ ಹಣ್ಣು ಹಾಗೂ ಅಡಿಕೆಯನ್ನು ಕುಯ್ತಿದ್ದರು. ನಾನು ಸ್ಥಳಕ್ಕೆ ಹೋದಾಗ, ಅಂದರೆ ನಿನ್ನಟ್ಟಿಗೆ ಹೋದಾಗ, ಹರೀಶ್, ಪ್ರವೀಣ್, ಸತೀಶ್, ಸುಜಿತಾ, ಸೋನ್ಸೋ 8 ಜನ ಸತತವಾಗಿ ಕಾಫಿ ಹಣ್ಣುಗಳನ್ನು, ಅಡಿಕೆಯನ್ನು ಕೊಯ್ದು ಮಹೇಂದ್ರ ಪಿಕಪ್ ಗಾಡಿಗೆ ಲೋಡ್ ಮಾಡಿಕೊಂಡು ಹೋಗುತ್ತಿರುವಾಗ ನಾನು ತಡೆದು 112 ಕರೆ ಮಾಡಿ ಸ್ಥಳಕ್ಕೆ ಪೊಲೀಸರ ಸಹಾಯ ಪಡೆದು ಬಾಳೆಹೊನ್ನೂರು ಪೊಲೀಸ್ ಠಾಣೆ ಕರೆದುಕೊಂಡು ಬಂದಿರುತ್ತೇನೆ. 112 ಅಧಿಕಾರಿಗಳಾದ ಭಾಸ್ಕರ್ ಗೌಡ ಹಾಗೂ ಗೌಡ ಇವರುಗಳು ನನ್ನ ತಮ್ಮ ಜೊತೆ ಬಾಳೆಹೊನ್ನೂರು ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಬಂದಿರುತ್ತೇನೆ. ಈ ಕೃತ್ಯದಿಂದ ನನಗೆ 15 ಲಕ್ಷ ರೂಪಾಯಿಗಳು ನಷ್ಟ ಉಂಟಾಗುತ್ತದೆ. ಇವರ ಮೇಲೆ ಕಾನೂನು ರೀತಿಯ ಕ್ರಮ ಕೈಗೊಂಡು ಕದ್ದಮ್ಮಲ ನನಗೆ ಮರಳಿ ಕೊಡಿಸಬೇಕಾಗಿ, ಜೊತೆಗೆ ನ್ಯಾಯ ಕೊಡಿಸಬೇಕಾಗಿ ತಮ್ಮಲ್ಲಿ ವಿನಂತಿಸಿಕೊಳ್ಳುತ್ತೇನೆ. And also this properties belongs to the mother-in-law of the petitioner, my lordship, wherein a sketch has been prepared by the surveyor, and where it is indicated that this property survey number 207 is where the incident has been taken place. It is belongs to the mother-in-law of the petitioner. In spite of the specific allegation of illegal trespass and theft, there is no precipitative action taken by the respondent police by conducting inquiry and filing the necessary report against the culprits, my lord. In spite of that, they have given an endorsement stating that the matter is in civil in nature, hence the matter has been closed by advising them to approach the competent civil court.
How do you say it is civil in nature? On what basis?
They could have access. Please.
ಅಲ್ಲ ಸ್ಕೆಚ್
8
ಅಲ್ಲಿ
ಜನ 14 ಜನ 16 ಜನ ಬರ್ತಾರೆ
ಫೋಟೋಗ್ರಾಫ್ಸ್ CD ಎಲ್ಲ ಇದೆ. I have furnished every document to the investigation officer.
Is there any other complaint, anything for you to say it is civil in nature?
No, my lords.
I'll seek instructions from you.
And AG accepts notice for respond number 125. She seeks for and is granted 2 days time to obtain instruction, make a submission as to on what basis the NCR has been issued, indicating that the dispute is civil in nature. Relist on 7th August.
Please.
Fresh matters list.
In preliminary hearing.
Much obliged.
28, Aditya SK,
Mr. Aditya
General
Karola. And AGA for respond relist on 5th.
29, Siddhesh
Mr. Siddeshi. Idara. What is this? What is-
Lease deed has been cancelled by the Tahsildar. Page 55, my lord. Based on the order of the Tahsildar, the sub-registrar has cancelled the lease deed.
My lord?
Yes, you are appearing in 29?
29 for petitioner.
Yes, really.
My lord, this petition is filed challenging the cancellation of lease agreement between the petitioners. The petitioner number 2 is the aspirant of obtaining the license from the oil company for running a petrol bank. So there is no commercial activities taken place in the land proposed to be taken for the license of petrol bank. So considering a lease agreement could not be possible under section 5 of the Land Reform Act. They have given direction, the Tahsildar has given a direction to the sub-registrar for cancellation of lease agreement.
Is agriculture land.
Agriculture.
Yes, it is an agriculture land.
Can't use it for non-agriculture purposes.
Yes, Your Honor, after obtaining the LOI from the petrol company, will because there is so many aspirants to obtain the license before the oil companies. So out of that, one is selected for that.
One of the conditions is that it has to be converted land. You can't give agriculture land.
After obtaining the LOI, we will convert the land, change of land, and we are already pursuing with the change of land at annexure C. We have applied for the PODI, Your Honor.
Mr. Renuka Prasad, you do everything, then you do the lease, not before that.
Yes,
You
Your Honor.
can't execute a lease for commercial development of agriculture land. There's nothing wrong with this.
Yes, my lord, but
Finish all those things and then again you do the lease. And AG accepts notice for respond number 1 and 2. Petitioner is before this court seeking for the following reliefs. Petition number 1, as owner, had entered into a lease with petition number 2 of the land in Kata number 570, survey number 150/**3 of Irenalur village, Irenalur Obli, Kadur Taluk, Chikmagalur district. The said lease had been entered into to facilitate an application to be made by respondent number 2 for obtaining a license for running a petrol bunk. Respondent number 2, on noticing that an agricultural land has been leased for non-agriculture purposes, had directed the first respondent to cancel the said lease. On inquiry with the learned counsel, it is the said order which is challenged in these proceedings. On inquiry with the learned counsel for the petitioner as regards the status of the land, he submitted the land continues to be agriculture in nature. Once necessary documentation is done with the oil manufacturing company, then necessary application would be made for the purpose of conversion of the land. Now an application having already been made for 4D of the land. There can be nothing, there can be no infirmity found in the direction issued by respondent number 2.
One submission,
Respond-
Your Honor.
Yes.
The Tahsildar had, the respondent number 2 Tahsildar had not given the opportunity of filing the objections and all.
There is no opportunity. What is there?
And they have not
Agricultural
conducted.
land. There can be no infirmity found in the order passed by respondent number 2 and the action taken by respondent number 1, inasmuch as admittedly the land is agricultural land and could not be put to non-agriculture use. What has been only directed is for cancellation of the registered lease agreement and not for forfeiture of the land. In that view of the matter, finding no infirmity in the said order, the petition stands dismissed.
30, Praveen Kumar Raikote.
Mr. Raikote.
I have taken notice on C. Jagdish Milord, he is online, he request for
Caste verification. Yav caste idu? Scheduled caste?
scheduled tribe.
Scheduled tribe.
Yes, ma'am.
Shri C. Jagdish is directed.
He is
to
already,
accept.
Milord, I have a third copy, but he is online, but he is blocked, I am told.
Mr. Jagdish? Idara? Ilva? So C. Jagdish is directed to accept notice for respondent number 1 and 2. Counsel for the petitioner to
I
furnish
sought for
2 sets
stay
of
of
the
further
petition along with
proceedings.
annexures.
And what has happened is, Milord,
Hmm?
the caste certificate was cancelled on the direction of the deputy commissioner. I filed a writ petition. In the writ petition, this honorable court, the deputy commissioner cannot direct the caste Tahsildar to cancel the certificate, but however is able to take action in accordance with law. After that direction, Milord, the DCVC takes up the proceedings on a third party complaint on the report submitted by CRSL on its own. Then that order was challenged before this honorable court. But this honorable court directed Milord on third party complaint and the report of the CRSL, you cannot initiate the proceedings. Now again, Milord, what they have done is, Milord, on the third party complaint, they have again taken up, before this order could be passed, second time, Milord, they have taken up suo motu proceedings.
Milord.
And, Milord, they refer.
May I submit, my lord?
Yes, Mr. Jagdish.
My lord, the district caste verification committee has no jurisdiction, as my lords are aware, and only under 4F they can invoke this provision. Under subsection 2 of section 4C, only for the purpose of appointment and education, the DCVC will have a role.
Correct.
Therefore, my lord, the matter may be remanded, the set aside.
No.
Liberty may be reserved to the deputy commissioner to invoke 4F. And liberty may be also, my lord, reserved to the third my lord, the complainant, one Mr. Subhash, to challenge under 4F.
Third party complaint, Milord,
First
liberty.
one, yes. Second, liberty.
Madam, third party react
We don't need to give that.
He belongs to schedule.
He is no agreed person, he is not
Jagdish
agreed person.
accepts notice for respondent number 1 and 2. Petitioner is before this court seeking for the following reliefs. The petitioner had obtained a caste certificate for purpose of contesting the local elections, contending that she belongs to the Nayaka caste, which is a scheduled tribe. The second respondent, Deputy Superintendent of Police, had submitted a report to the Tahsildar, on which basis the said certificate came to be cancelled, which was challenged by the petitioner before this court in WP number 7390 of 2020. This court, observing that such a cancellation could not have been made on the basis of a report by the Tahsildar, by the Deputy Superintendent of Police on the basis of a report submitted by Tahsildar.
No, I'm sorry,
Had
there is
reserved-
some mistake. The Tahsildar might cancel the certificate on the instructions of the deputy commissioner.
Correct.
No, because Tahsildar and the deputy commissioner instructed Tahsildar to cancel the certificate, he cancelled it.
Deputy Superintendent of Police first time, ಆಮೇಲೆ Deputy Commissioner.
ಆಮೇಲೆ deputy commissioner, ಅದು jurisdiction deputy commissioner
First
ಇದೆ.
time ಇದು.
First line, second line deputy commissioner ಇದೆ ಅದಕ್ಕೆ.
The Tahsildar cancelled the caste certificate on the basis of a report submitted by Deputy Superintendent of Police, which was challenged before this court in WP number 7390 of 2020, when this court reserved liberty to Deputy Commissioner to proceed in accordance with law. The Deputy Commissioner instead of the deputy commissioner taking action, the first respondent DCVC, District Caste Verification Committee bracket DCVC, issued notice to the petitioner, which came to be challenged before this court in WP number 28113 of 23. When this court set aside the said notice.
Order, my lord, not notice. Order only, they passed the order.
Order.
Yes, my lord. Order. Annexure C is the order. Annexure C is the order cancelling the caste certificate.
Issued notice. Thereafter passed an order cancelling the certificate, which came to be challenged before this court in WP number 28113 of 2023. This court taking into consideration the DCVC had issued a notice and initiated proceedings at the instance of the CRE cell, set aside the said order, and once again permitted the deputy commissioner.
No, my lord, concerned authority to initiate action, that's all.
Concerned authority means avare.
Concerned authority to initiate proceedings.
Under the provisions.
The deputy commissioner, you again,
No, my lord, again DCVC initiated proceedings.
The deputy commissioner once again wrote to the DCVC.
Yes.
And the DCVC again issued a notice on 6/7/2026 at Annexure F, which is under challenge in these proceedings.
And Annexure, yes, both are E and F are challenged.
E, no.
E and F, my lord. The DCVC has, the CRSL now issued notice to me, Annexure F. Before the order could be passed, my lord,
What is Annexure E?
Annexure E, my lord, the DCVC now, the CRSL writes to the DCVC. The CRSL, my lord, writes to the DCVC. We cannot send a report. You say, you ask us to send a report. Then the right letter to directing the DCVC to send, ask them to pass an order to.
This is not deputy commissioner, this is DCVC.
DCVC only, I am saying DCVC only.
Caste verification committees.
The DCVC on 11/3/26 called upon the CRE cell to submit a report. The CRE cell, wide notice dated 6/7/26, has called upon the petitioner to appear before it. It is both these which are challenged in these proceedings. This court had earlier, a court bench of this court had dealt with the same issue earlier, while it's ordered dated 17/6 in WP number 28113 of 2023, and categorically came to a conclusion that the DCVC would not have jurisdiction. The very same reasoning of the coordinate bench would equally apply to the present fact situation also, since it is the DCVC who has called upon the CRE cell to inquire into the matter and submit a report, which it could not have done. Once a caste certificate has been issued, the only remedy which is available is under clause F of section 4.
4F, my lord.
4F. Under section 4F, clause F. Section 4F, which is by way of a revision by the deputy commissioner. The deputy commissioner, being the chairperson of the DCVC, cannot, through the DCVC, initiate action. The action under section 4F is an independent action by the deputy commissioner of revision of a caste certificate which has been issued. In that view of the matter, this court passes the following order. Writ petition is allowed. The cesura is issued. Annexure E and F are quashed. Liberty is reserved to the deputy commissioner to act in terms of section 4F of the Karnataka SC/ST and so on so Act.
But he reserved to take action.
All competentions are left open.
Section badlu in accordance with the act.
ಮತ್ತೆ ಅದೇ ಸೇಮ್ ಮಿಸ್ಟೇಕ್ ಮಾಡ್ತಾರೆ, ಮೂರನೇ ಸತಿ ಆಗಿದೆ.
ಅದೇ ಸ್ವಾಮಿ, ಇವ್ರಿಗೆ ಬೀಸೋದಣ್ಣ ಸಪ್ಪರ 1000 ವರ್ಷ ಆಯ್ತಂತೆ. ಹಂಗೆ ಇವ್ರು ತಗೊಳ್ತಾ ಇರ್ತಾರೆ.
4F either suo moto or an application ಅಂತಿದೆ.
Then this court
ಇಲ್ಲ ಸುವಮೋಟೋನು ಇದೆ.
It was for him to do it under 4F.
Yes.
Instead of that, he did it as chairperson of
Chairperson
DCC.
of CTC.
Yes, next.
Please.
Allah, liberty may be also reserved to the complainant, one Subhas, my lord.
Complainant
At
is
his
not
instance
before us,
only
we are
this
not
has happened.
reserving any liberty for him, Mr. Jagdish. First, let the deputy commissioner take action.
Please, my lord. Please, my lord, please. Oblige me.
The petitioner, my lords, sought a writ of mandamus seeking to direct the respondents to pay the pending bills.
Who is the
Which is the
pending
9th and 10th bill dated
Opinion
18/2/2025 and 17/3/2025.
National Highways,
Yes, my lords.
NHA or
NH, my lords. NH 548.
and AG accepts notice for respond number 1 to 5. Petitioner is before this court seeking for the following leaves. The petitioner, being a successful tenderer, was issued a short-term maintenance contract for NH 5488 for the year 23-24, in furtherance of which the petitioner has raised running bills which were not paid. Hence, the petitioner submitted a representation. Where is your representation?
This representation. Annexure J1. Representation ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ
They have already rejected it. By annexure K, they have rejected it. Again, why are you coming before us for mandamus?
My lords, we have performed the
K,
work,
my
my
lords.
lords. We've executed the work.
And AG accepts notice for respondent 1 to 5. He seeks for and is granted 2 weeks time to obtain instruction, make his submission. Pre-list on 27th August.
Narasimhamurthy.
Debit freeze of the entire account.
Please,
Correspondence ellide. Where is the correspondence from the bank?
Canara Bank, Swami.
Where is the correspondence? Page number.
Page number.
Police station party ಮಾಡಿಲ್ಲಲ್ಲಪ್ಪ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಅಕೌಂಟ್ ಫ್ರೀಸ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ.
ಹೌದು, CN crime police station ಹಾಸನ್ ಸಿಟಿ.
ಹಾಸನ್ ಸ್ವಾಮಿ.
ಅವ್ರು ಹೇಳಿರೋದಲ್ಲ.
ಅದಾಗಿತ್ತು ಸ್ವಾಮಿ, ಕ್ಲಿಯರೆನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಕ್ಲಿಯರೆನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಬಿಟ್ಟು ಅಕೌಂಟ್ ಇಮೇಲ್ ಟು ಕೆನರಾ ಬ್ಯಾಂಕ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಮೇಲ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಕ್ಲಿಯರ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
ಎಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ? ಪೇಜ್ ನಂಬರ್?
ಪೇಜ್ ನಂಬರ್ ಬಂದ್ಬಿಟ್ಟು 385 ಸ್ವಾಮಿ.
385
annexure D ಸ್ವಾಮಿ.
Canara Bank TP Muthana. TP Muthana is directed to accept notice for respondent. He is directed to secure instruction, make a submission as to whether any other orders. He is directed to place on record all the orders received by the bank as regard the debit freezing and or marking lien on the account of the petitioner. Pre-list on 13th August.
33. Tejas.
Mr. Tejas.
Dispute as to who the parent is, my lord. The child could be passed over, my lord.
Pass over.
34. Harish Bhandari.
The tender was called for provide the manpower, unskilled manpower, Your Lordship. Even earlier also, I was providing the manpower to the same institution. Your Lordship, kindly refer to page 15, Your Lordship. of the tender conditions.
Yes.
At clause 8.0, prices, your lordship got it. There, your lordship, note, in case of more than one bidder happens to be L1, the selection will be done on the basis of agencies having highest average annual turnover in the last preceding 3 financial years. This, your lordship. And about to that, your lordship, the bidder shall quote minimum 3% service charges, providing manpower services, that's unskilled category, garden laborer 45 numbers on outsource. The service charges quoted by the agencies are firm throughout the contract period, your lordship. Now, what I am agreed with these conditions, your lordship, it is the L1 conditions and 3% conditions. The prime, first, your lordship, the L1 conditions, your lordship, three financial year conditions, your lordship. Authority, where your lordship get it page annexure 30, annexure C.
Yes.
This is in reference to your tender notification so and so, 15.6, wide intimation so and so. The L1 selection will be done on the basis of agencies having highest average turnover in the preceding 3 years, is arbitrary and violative of KTTP rules. There is a clear guidelines how to deal with the case of equitable bid. Copy of the KTTP rules as and we are request you to receive the above clause of the amendment may be issued for correction if any. Then your lordship there writes a letter stating an annexure tender conditions for the selection done on the basis of the highest turnover has been already adopted in this office in the previous tender. Besides, the draft tender dated so and so has been, labor has been approved by the SCE Mangalore City Corporation, hence your request cannot be cancelled. Now, your lordship, kindly turn to the annexure D, the previous tenders, your lordship. Previous tenders, your lordship, the condition was, your lordship, page 37. In page 37, last, your lordship. Tiebreaker system, how it was. If the bids have been same service charges, the percentage will be decided in drawing lots.
The commissioner and chairman. Pilkula, deputy commissioner is the.
Yes, he's a.
There standing council idara, Pilkula development.
Pilkula ಯಾರು ಇಲ್ಲ ಮುಂಚೆ ನಾನೇ ನನಗೇನೆ ಕೇಳಿದ್ರು ಮುಂಚೆ ಅಲ್ಲಿ ಕಮಿಷನರ್ಸ್
ಇವಾಗ ಯಾರು ಇಲ್ವಾ?
ಇವಾಗ ಯಾರು ಇಲ್ಲ.
And AGA for respond number 1. Yes, madam. ಯಾರು ಇಲ್ಲ ಅಂದ್ರೆ notice will take 3 months.
Pilkul authority. Pilkul authority. Development authority.
Issue emergent notice to respond number 2 and 3.
No, no,
Returnable by
we can't.
7 September. Considering that KTP Act, padi.
If there are more than one L1 bidders, my lord.
It is bound to happen in these tenders. Everybody will give 3% only. All these manpower tenders, you are only making the contractor rich by giving 3%.
And the word says, your lordship, shall quote minimum 3%.
ಅದು ಯಾವ್ದು ಇದು by drawing of lots where the equal.
Drawing of lots
the only way that
They
you
have
can.
extracted in their
Guidance
petition,
government
my
ಅಷ್ಟೇ
lord.
ಅದು.
It's on page 7.
Your lordship in rules ಗೆ ಬಂದಾಗ determination of lowest evaluation, your lordship get it rule 25 ಅಲ್ಲಿ lots ಅಂತ ಏನಿಲ್ಲ ಅದರಲ್ಲಿ actually. Previously it was followed, your lordship, and government some guidelines has issued, your lordship, that may be by way of lots.
25.
Rule 25.
Does not have anything. ಅದು lowest evaluation. Among the lowest,
Among the lowest ಇದರಲ್ಲಿ ಇಲ್ಲ ರೂಲ್ಸ್ ಅಲ್ಲಿ ಹೇಳ್ತಾ ಇಲ್ಲ, ಬಟ್ ಸಮ್ ಗೈಡ್ಲೈನ್ಸ್ ಆಸ್ ಇಶ್ಯೂಡ್ ಬೈ ದ ಗವರ್ನಮೆಂಟ್ ಲಾಸ್. ಲಾಟ್ ಸಿಸ್ಟಮ್ ಅಲ್ಲಿ ಮಾಡಬೇಕು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
what will happen if you have these clauses? Then whoever is the highest turnover,
This one.
then anyway 3% is there. Whoever
Percent is
it doesn't make. It's already pre-decided
this one.
as to who will get it. It cannot be that way in the tender at all. So what are the guidelines for
This one.
when more than one
L1.
Bid, L1 bidder.
L1
bidder
bidders.
is? And AGA for respond number 1, issue notice to respond number 2, emergent notice to 2 and 3, return up by 7th September. Considering that that no bidder shall quote, and that every bidder shall quote minimum of 3% service charges for providing manpower services, thus necessarily envisaging more than one bidder to have quoted the same price, since anyone quoting more than 3% would automatically get disqualified. The consideration of the highest average annual turnover for last preceding 3 financial years in the considered opinion of this court would result in the biggest, the most successful bidder, person with highest bid turnover being automatically selected, which will go against the concept of tendering. Hence, the operation of the tender notification bearing number so and so at annexure A is stayed till the next date of hearing. And AGA to secure instruction make a submission as to whether there are any guidelines
Please.
which have been laid down by the competent authority when there's more than one L1 bidder.
This one. I'll accept notice for 2 and 3 also.
2 and 3 also like
Yes, ma'am.
1, 2 and 3.
Handle area of the entry model. Handle.
EN and upload again. 126 is allowed.
Great.
35.
Yes, Mr. Arvi.
Action to the third respondent, my lord, to transmit the complaint against Annexure A, my lord, to the fourth respondent, enabling the respondent to register complaint against respondent 5 to 7, my lord. Condition Annexure, my lord, Annexure A. Page number 22, my lord, the last paragraph is 22.
You want the superintendent of police to transfer it to
Please, my lord. Because earlier went to the S1, the fourth respondent, not accepted the claim, my lord. Condition page number 22, my lord, last paragraph, my lord. ದಿನಾಂಕ 14/7/26 ನಾನು ನನ್ನ ಯಜಮಾನರು ಕೊಣನೂರು ಠಾಣೆಗೆ ದೂರು ನೀಡಲು 4 ಗಂಟೆಗೆ ಹೋಗಿ ಖುದ್ದು PSI ಸಾಹೇಬರಿಗೆ ನೀಡಿದ್ದು ಪೊಲೀಸ್ ಸಂಜೆ 7:30 ವರೆಗೆ ಪೂರೈಸಿಕೊಂಡು ನಂತರ ದೂರು ತೆಗೆದುಕೊಳ್ಳದೆ ವಾಪಸ್ ಕಳಿಸಿರುತ್ತಾರೆ. We went there in the first instance, my lord, but not accepted. Therefore went to the third respondent, lodged the complaint, issued the complaint, lord, 16 July 2026. Therefore enabling the person to transmit this complaint to the fourth respondent, my lord.
What are the allegations?
My lord, this
Cognizable
is
or non-cognizable?
It is cognizable, my lord.
And what is the cognizable offense?
Condition, my lord, wherein, my lord, the page 20, my lord. ವಿಷಯ 1975-74 ಸಾಲಿನಿಂದಲೂ 3 ಎಕರೆ ಪಹಣಿ ಪಡೆದು ಸ್ವಾಧೀನ ಬದಲಿ ಮಾಡಿಕೊಂಡು ಬರುತ್ತಿರುವ ನಮ್ಮ ಜಮೀನನ್ನು ಉಳುಮೆ ಮತ್ತು ಕೆಲಸ ಮಾಡುತ್ತಿರುವ ವೇಳೆ ಸಂಚು ಮಾಡಿ ನಮ್ಮ ಜಮೀನಿಗೆ ಅತಿಕ್ರಮಣ ಪ್ರವೇಶ ಮಾಡಿ ದೊಣ್ಣೆ ಮತ್ತು ಕಾರದ ಪುಡಿಯನ್ನು ನಮ್ಮ ಮುಖಕ್ಕೆ ಎರಚಿ ಹಲ್ಲೆ ಮಾಡಿ ಅವಾಚ್ಯವಾಗಿ ನಿಂದಿಸಿ ನಮ್ಮೊಟ್ಟಿಗೆ ವಿನಾಕಾರಣ ಜಗಳ ತೆಗೆದು ದಬ್ಬಾಳಿಕೆ ದೌರ್ಜನ್ಯ ದರ್ಪ ಮಾಡಿ ನಮ್ಮಗಳನ್ನು ಕೊಲೆ ಮಾಡುತ್ತೀರಿ, ನಮ್ಮ ಜಮೀನನ್ನು ದಕ್ಕಿಸಿಕೊಳ್ಳಲು ಮತ್ತು ದೈಹಿಕವಾಗಿ ಮಾನಸಿಕವಾಗಿ ವಿನಾಕಾರಣ ಕಿರುಕುಳ ಹಿಂಸೆ ನೀಡಿ.
Standard words are used.
please.
ಏನಪ್ಪ ಮಾಡಿದೀರಾ?
I just seek instruction, my lord, whether the complaint has been
The
forwarded.
Excel notice for respond number 1 to 4. Notice to respond number 5 to 7 is deferred for now. And AGS seeks for and is granted 3 days time to ascertain and make a submission as to what is the status of the complaint filed. Released on 7th August.
Statement.
To serial number 3 withdrawn.
List 2 serial number
3.
3 withdrawn.
Published.
Serial number 45, your lordship. Secondly, serial number 45 regarding that PDS, whether the gazette has been happened or not. That is the matter.
Which is not now.
Another matter was linked to this on 29th, but that is not yet been come on today listed.
Serial number
45 ಇದೆ ಇವತ್ತು, ಇನ್ನೊಂದರ ಜೊತೆಯಲ್ಲಿ ಇರೋದಿಲ್ಲ.
ಏನ್ ಅಜ್ಜನ್ ಮಾಡ್ಬೇಕು ಏನ್ ಮಾಡ್ಬೇಕು?
ಅಲ್ಲ ಇಲ್ಲ, that should be tagged, ಅದು ಬಂದಿಲ್ಲ ಅಂತ ಫೈಲ್ಸ್.
ಟ್ಯಾಗ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಅಜ್ಜನ್ ಆಗುತ್ತೆ, ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇರೋದು.
It may be taken up in the fresh matter tomorrow being spoken.
ಏಕೆ ನಾನು ಕನ್ಫ್ಯೂಸ್
ಕಂಟಿನ್ಯೂ ಅಲ್ಲ, ಫಸ್ಟ್ ಧಾರವಾಡ.
ಇಲ್ಲ ಇಲ್ಲ, ನಾನು ಇನ್ನೊಂದು ಪೇಜ್ ರಾಂಗ್ ಪೇಜ್ ಹೇಳಿದ್ದೆ.
ಅಲ್ಲ ಹೇಳ್ತೀನಿ ಇವಾಗ, ತುಂಬಾ ಜನಕ್ಕೆ ಉತ್ತರ ಸಿಗುತ್ತೆ. ಫಸ್ಟ್ ಲಿಸ್ಟ್, ಫಸ್ಟ್ ಧಾರವಾಡ 2 ಮ್ಯಾಟ್ರು, ಕಲಬುರ್ಗಿ 1 ಮ್ಯಾಟರ್, ಆಮೇಲೆ ಥರ್ಡ್ ಲಿಸ್ಟ್ ಪಾಸ್ಟ್ ಓವರ್ಸ್, ಲಿಸ್ಟ್ 1 ಕಂಟಿನ್ಯೂ, ಆಮೇಲೆ ಲಿಸ್ಟ್ ಅದು ನಿಲ್ಸ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದ ಡೇಟ್ ಯಾವುದು?
ಇಲ್ಲ serial number 79
ಹೌದಾ? ಸರಿ, ಈಗ ಆ ಫೈಲ್ ತರಿಸಿದ್ರಾಗುತ್ತಾ? ಅಲ್ಲ, ಅವತ್ತು ಯಾರಿಗಾಗಿತ್ತು ಸ್ಟೆನೋಗ್ರಾಫರ್
ಓದ್ಬೇಕಾ?
ಇಲ್ಲ, ಸುಮ್ಮನೆ ಟೈಪಿಂಗ್
ಈಗ ಹೇಳಿದ್ದಲ್ಲ, ಸೇವ್ ಮಾಡಿ ಅದೆಲ್ಲ. ಫಸ್ಟ್ ಧಾರವಾಡ, ಕಲಬುರ್ಗಿ, ಥರ್ಡ್ ಲಿಸ್ಟ್, ಥರ್ಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಒಂದು 7-8 ಇರ್ಬೇಕು. ಥರ್ಡ್ ಲಿಸ್ಟ್ 5 ಮ್ಯಾಟ್ರು, 5. ಆಮೇಲೆ ಫಾಸ್ಟ್ ಅವರ್ಸು. ಹಾ ಲಾಸ್ಟ್ ಇವಾಗ ಹೇಳಿದ್ನಲ್ಲ, ಯಾವ ಲಿಸ್ಟ್? ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಇಲ್ಲ, ಇದೆ ಇಲ್ಲ ಸರ್, ಇದೆ 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 ಕಡಿಮೆನೆ. 4 ಗಂಟೆ ಆದ್ಮೇಲೆ ನೋಡಿ, ಇವತ್ತು ಥರ್ಡ್ ಲಿಸ್ಟ್ ತುಂಬಾ ಕಮ್ಮಿ ಇದೆ ಮ್ಯಾಟ್ರು, ಅದಕ್ಕೆ ಲಿಸ್ಟ್ 1 ಆದ್ಮೇಲೆ ಲಿಸ್ಟ್ ಮಾಡಿ ಮಾಡಿ. ಆಗ್ಲೇ ನೋಡಿದ್ರಲ್ಲ ತಗೊಂಡು ಊಟ ಮಾಡಲ್ಲ. ಎರಡೇ ಅಲ್ಲ, ಈಗ ಬೇಡ ಸರ್, ಬೇಡ ಸರ್ ಅದು. ಅದು ಎಲ್ಲ ಸೇರಿಸಿ ಇವತ್ತು ಮ್ಯಾಟ್ ಯಾವತ್ತು ರಚನೆ ಆಗುತ್ತೆ ಅಲ್ಲ, ಈಗ ಏನ್ ಗೊತ್ತಾ, ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಲ್ಲ, ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಅದ್ರ ಪಾಡಿಗೆ ಅದು ಬರುತ್ತೆ, ಇದ್ರ ಪಾಡಿಗೆ ಇದಾಗ್ತದೆ. ಇದೆ ಮಧ್ಯಾಹ್ನ ಇದೆಯಲ್ಲ ಸರ್, ಮಧ್ಯಾಹ್ನ ತಗೋತಾರೆ. ತಗೊಂಡ್ರಾ? ಇಲ್ಲ ಸರ್, ಫಸ್ಟ್ ಧಾರವಾಡ, ಕಲಬುರ್ಗಿ, ಥರ್ಡ್ ಲಿಸ್ಟ್, ಫಾಸ್ಟ್ ಓವರ್ಸ್, ಲಿಸ್ಟ್ 1 ಕಂಟಿನ್ಯೂ, ಆಮೇಲೆ ಲಿಸ್ಟ್
39 ಲಿಸ್ಟ್ 1 ಬರುತ್ತಾ? ಪಕ್ಕ
ಇವಾಗ ಇವತ್ತು ಹಿಸ್ಟ್ರಿ ತುಂಬಾ ತಪ್ಪಿದೆ.
ಎಷ್ಟಿದೆ ಮೇಡಮ್?
ಅರೆ
ಒಂದೇ ವಾರ ತರ ಹೋಯ್ತಾರೆ ಅಂತೀರಾ?
ಸ್ವಲ್ಪ ಕಷ್ಟ. ಆಗ್ಬೋದು ಅಷ್ಟೇ.
question, my lords. May I mention one matter, my lords, for the end of the list? It's listed in list number 2, serial number 66, 67.
Whatever reaches will be taken up.
May I just request, my lords, I'll just make 30 seconds, my lord. The reason is my lords had heard the matter. There was a blanket freeze of the bank account. State said that
Whatever will reach in seriatim will be taken up in seriatim. No exception because everybody will ask for it. We can't do
Very
that.
My lord, memo for withdrawal, my lord.
Yadu.
List 2, serial number 41, my lord.
List 2, serial number?
41, my lord. As there are
41,
defects in
yes.
the petition and
This
seeking
was-
liberty to file fresh petition.
Liberty to file fresh petition ಏನಕ್ಕೆ?
There are defects in the present petition, my lord.
Then we'll have to consider it when the matter reaches, not like this.
Serial number 45 in the second list.
Yes.
That may be taken up day after tomorrow. Interim order may be extended.
Any adjournment will be 28th of August. You want adjournment?
Because the short question, like a PDS gazette ಆಗಿದೆಯೋ ಇಲ್ವೋ ಅಂತ ಅಷ್ಟೇ ಹಂಗಾಗಿ.
Everything is short question until it is taken up. Yes.
My lord, serial number 20, your lordship ordered notice. I was not allowed to come online, my lord. It's a long date is given, short date, my lord. There is some serious
Notice
problem.
ಆಗಿ ಬರಕ್ ಒಂದ್ ತಿಂಗಳು ಆಗೇ ಆಗತ್ತಲ್ಲ ಮಿಸ್ಟರ್. ನೋಟಿಸ್ ಆಗಿ ಬರಕ್ ಒಂದ್ ತಿಂಗಳು ಆಗೇ ಆಗತ್ತೆ.
ಇಲ್ಲ 15 ದಿವಸ ಸ್ವಲ್ಪ ಪೊಲೀಸ್ ಅವರು ಆಕ್ಷನ್ ತಗೊಳ್ಬೇಕು ಅದಕ್ಕೆ.
Private parties are there. If action notice has to be issued.
ಸೀರಿಯಸ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಮನೆಯಲ್ಲಿ ಅದಕ್ಕೋಸ್ಕರ.
Hand summons ತಗೊಂತೀರಾ?
ತಗೊಳ್ತೇನೆ.
20 ಅಲ್ಲಿ petitioner is also permitted to take out hand summons. Return by 20th August.
45 same it may.
WP 1774, Dastamji versus State of Karnataka. This matter in the previous hearing, it was referred for time-bound mediation, and tomorrow it is to be, the mediation has changed. But the reason is that the connected matter it's reflecting as posted on 10th, my lords.
If it is a matter coming up tomorrow, we can't do anything today, madam.
No,
Tomorrow
both
you
the matters may be taken up.
move a memo, it will be coming up. Yes.
Serial number 65 in list 2, my lord. There's some urgency. If it is not listed.
As what we told just now, we can't make exception, please. We can't make exception because everybody will ask for, then it will be like chaotic. We'll take 65, 18, 32, can't happen. Yes.
Same thing, my lord. 57 serial number, the matter may become infructuous, my lord, might be taken at the end of the list, my lord. Because within the pendency of this.
45 any date your lordship may be given. Interim order may kindly be
45
extended.
connect with so and so, relist on 27th, interim order extended.
List 1,
Great.
my lord.
Give that other number.
List 1, my lord. Serial number 33. May be taken up after a week, my lord. Senior is unwell, my lord.
List 1, serial number 33. It will go to 28th of August.
Please, my lord.
At the request of counsel for the petitioner, relist on 28th August.
Another number that will be maybe listed tomorrow in the being spoken to your lordship.
Yes, next.
Yes, great.
Harvard bench matter. Serial number 1, Abhijit, yes.
Mr. Upar. Mr. Upar. Yes, I will. Praveen Upar. Relist on 28th August.
Serial number 2,
Same 28th August.
Kalburgi bench matter. Naresh V. Kulkarni.
Yes, madam.
Lords, today I have filed the status report, my lords. The software has been developed regarding Urban Development Authority for the open space
You
and
filed it today.
yes, it was.
And AGA submit the status report has been filed today. Registries have put up the same. Relist on 19th August.
Please.
List number 3, serial number 1, Satisha S. Party in person.
Yes.
I'll just place all the documents, my lord. He was here. I'll just, can I request for a short pass over, my lord?
Where is
Documents.
he? Has he come today with the
No,
file?
Tahsildar has not come, my lord. The FD has come. I'll place it, or I'll leave it to your lordship.
Despite several orders.
Take
So
action
what has
against
happened?
this Tahsildar, Mr. Shaman.
I've asked the Tahsildar, my lord. I've contacted her
This is
yesterday.
the fourth time. We understand if somebody is busy.
My lord, that's why I said, my lord, I'm not contesting this. I leave it to your lordships to do what's needed.
We'll secure him through NBW.
I leave it to your lordships. And in fact, all I can place is, my lord, these documents. And though there was a direction, my lord, in 2023 saying, my lord, to reconstruct the documents. No letter has been sent by the Tahsildar to the Deputy Commissioner to do this. So no action has been taken post that order. I'll just place the file on record, my lord, of the particular survey number, then I leave it to your lordship. Well, I have contacted her since Friday, my lord, and
Sorry to interrupt, Your Honor, sorry to interrupt. It has been adjudicated by two competent authorities.
We are aware of it.
They are not any right to hold deliberately violating and non-compliance, Your Honor.
Can I request for a
Deliberate
short
willing.
pass just to place the documents on record, then I'll leave.
Is not been done. We'll recommend disciplinary inquiry in terms of subsection 2 of section 20.
Yes, sir. Orders passed in 2023. This Tahsildar has been appointed in
within 3
2025.
weeks. We'll fix a time limit. So this person is completely.
But I'm exhausted, Your Honor. Please.
All I can say is she's a young officer. She's not able to understand what is going on in terms of.
If he at least comes before us, we can explain.
Yes, my lord. Yes, my lord.
He's
I've in
avoiding
fact
that.
tried. I've made my attempt, my lord. I leave it.
Flippant attitude, Your Honor, towards this honorable court also.
You don't pour more oil on the whole thing.
Nothing.
We'll deal with it.
I'll just. I've asked her to be present on VC at least. I've asked her officer to inform her to be present on VC. It's not happened.
Why this attitude?
Lordship may do the needful, my lord. We'll secure her presence.
Give a long rope and they do like this.
Nothing to be heard. Your Honor only ordered.
Not even written to the Deputy Commissioner.
Is what I'm informed from the FDA today.
File.
This request for a short passo, my lord. I'll just
passo.
Serial number 2. Yes, Rajshekar.
Petitioner, my lord, praying for a short passo, 5 minutes.
Passo.
Serial number 3. Bhargav Gilbert.
Lords, relinquishment deed without consideration, my lords.
Mr. Devraj.
Lords, I make one more submission, my lords. ಇದರಲ್ಲಿ ಲಾಸ್ಟ್ ಟೈಮ್ ತಾವು ಯೋಗೇಶ್ ನಾಯಕ್ ನೋಟಿಸ್ ಮಾಡಿದ್ರಿ, ಅವ್ರ ಹೆಸರು ಬಂದಿಲ್ಲ ಕಾಸ್ ಲಿಸ್ಟ್ ನಲ್ಲಿ.
ಯಾರಿಗೆ ರಿಲಿಂಕ್ವಿಶ್ಮೆಂಟ್ ಡೀಡ್ ಮಾಡಿರೋದು?
I have done it in favor of the Bidirguppe village panchayat respondent number 3, for which Mr. Devraj was directed to take notice, done at the behest of the planning authority, for which Mr. Nayak appears, my lords. ಅದು AGA ಅಂತಾನೆ ಬಂದ್ಬಿಟ್ಟಿದೆ.
Correct the appearance of the parties as learned AGA for respond number 4
and 5.
Shri Yogesh Nayak for respond number 1 and 2. Galat not filed, Mr. MS Devraj. None appears for respond number 3, relist on 12th August.
I've served copies on Ms. Nayak already. Copies are already served on everybody. Obliged.
Serial number 4. Dr. Reddy, non-connected matter.
Who is to report compliance, Shaman?
My lords.
4. Yes, madam.
Serial number 4, my lord, writ petition number 39565 of 2025, my lords.
Yes.
This matter is disposed of with a certain direction to the GBA, my lords. Last year, my lords, we have filed a compliance report and the date given was 10/8/2026, my lords.
10/8. No, dear.
Yes.
Relist on 10th August.
My lord, may I request for another 2 weeks, my lord, since the officials are engaged in SIR duty, my lords.
And counsel for respond number 1 and 3. Submit that the officials are engaged in the SIR. She seeks for 3 weeks time. Relist on 24th August. 24th August, madam.
Serial number 5.
4:30.
4:30, madam.
30 mood matter, Azhar Ali.
To the petitioner in this case, Your Lordship.
Yes.
Minor child, 29, almost 29 weeks.
Where is
Page-
she?
Page number 15.
Mysore Road, Bengaluru.
Vani Vilas Hospital.
And AJ accepts notice for respond number 1 to 4. The medical superintendent, the second respondent is directed to constitute a medical board. She's in Bangalore?
She's in the hospital itself.
She's in the hospital. Examine the petitioner and submit a report by tomorrow. Release tomorrow at 2:30 p.m.
No, sir. May I request it may be uploaded online? The
It will be uploaded.
No, I'll inform him.
Because
By the time it will get uploaded, it will be 7:30. He'll inform.
Passport matter, list number 1, serial number 3, Ramesh N.
Yes. Yes, Mr. Ramesh.
Page number 67, my lord.
67.
Yes, ma'am.
Yes. Is the first judgment.
Also,
ಆಯ್ತು.
14/10/2014 ಗೆ judgment ಆಯ್ತು. Still it is in operation till today. That was a partition suit.
That gets overridden by your compromise in 718.
My lord, that is not the finding in the Lok Adalat. That was not set aside by an order of a judicial order. That was suppressed by the.
Until execution is done, until FDP is done, the shares can be reworked. You have reworked the shares.
No, my lord, even in the compromise petition, my lord, there are so many corrections which are not signed by any of the parties. All these things I have.
ಎಲ್ಲಿ corrections ಏನಿದೆಯಪ್ಪ?
ನೋಡಿ ಸ್ವಾಮಿ, measurement out of 4 acre 20 guntas, out of 10 acres in item number 5, item number 2 out of 4 acre 10 guntas, item number 3 out of 10 acres. Everywhere there is correction, my lord. And this was done, my lord, at the instance of the land mafia, that is defend number 6, my lord. He is the instigator for filing all these things.
There's
my
no
lord,
different
even-
number 6.
Even my lord, item number.
There is different number 6. There's no different number 6.
I will just please come to the page number 44, my lord. 44, 45,
Only different
46.
number 5 is there.
Different number 5. ಅವರು the compromise petition the contents of the compromise petition, if it's looked into, the third item is the plaintiffs and defendants 1 to 4 hereby have agreed and confirmed the share allotted to defendant number 5 is not at all related to my family. As such, the properties are purchased by defendant number 5 belongs to defendant number 5 only, because he wanted to make a confirmation of his agreement. Agreement iddidna, now by virtue of this compromise, he wants to make it a judicial order. All these things were questioned because that was the time where COVID was also there, my lord. Subsequently, I filed all this fraud in my suit. But my lord, when the matter was set down for evidence, my lord.
Where was COVID in 2017? Mr.
ಅಲ್ಲ 2017 ಆದ್ಮೇಲೆ ಅವರು ಆ ಡಿಗ್ರಿ ತಗೊಂಡೋಗಿ RTC ಎಲ್ಲ ಚೇಂಜ್
ಏನೇನೋ
ಮಾಡಿಸ್ಕೊಳ್ತಾರೆ.
ಬೆಳಗಿಂದ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾನೆ ಇದ್ದೀರಾ. 17 ಆರ್ಡರ್ 14 ಅಲ್ಲಿ ಸೆಟ್ ಅಸೈಡ್ ಆಯ್ತು, ಅದು ಇದು ಅಂತ. Then we have got the dates.
ಅಲ್ಲ
17 ಅಲ್ಲಿ ಇವಾಗ ಕೋವಿಡ್ ಅಂತೀರಾ.
ಅಲ್ಲ 17 ಅಲ್ಲಿ ಅವ್ರು ಮಾಡಿಸ್ಕೊಂಡಿದ್ದು ಈ ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿನ without in making any corrections, and by virtue of the item number 3 in the compromise petition by the.
Yes, you have signed the compromise.
ಅಲ್ಲ ಎಷ್ಟು ಕರೆಕ್ಷನ್ ಇದೆ ಅಲ್ಲಿ, ಆ ಕರೆಕ್ಷನ್ at least all those things should have been brought to the knowledge of the all this brought to the knowledge of
Only
the
brought to
parties.
in accordance with the plaint. Ali, it has been missed out that out of 10 acres. So the out of 10 acres has been added. What difference would it
No, my
make?
lord, my grounds are that, my lord, 24 of 2007, all the shares were worked out by the, that is a contested judgment, not a compromise judgment, my lord. All those shares were
ಹೌದಪ್ಪ,
compromised.
ನಾಳೆ ಇದ್ರಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಂಡ್ರೆ ನೀವು we should not record it.
ಅಲ್ಲ ಇದು ಯಾರ್
ಇವಾಗ ನಾಳೆ ಇದ್ರಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡಿದ್ರೆ ಅದ್ರಲ್ಲಿ ಸೂಟ್ ಇತ್ತು, there was a decree, so we can't record compromise ಅಂತ ಹೇಳಕ್ಕಾಗತ್ತಾ?
ಅಲ್ಲ ಇದರಲ್ಲಿ parties who are not, my lord, concerned to my family members, and moreover the defendant number.
Yes, purchase the property from your family members, you have confirmed it. Nothing wrong
Allah,
with this.
these are all three generation ancestor properties. Nobody is the parties, my lord.
I asked you to sign the compromise.
No,
You
my
are a
lord,
legal,
if
you are
that is-
represented by a lawyer.
No.
Did you appear in that matter?
I don't know. I am
Nothing.
appearing only in this matter, my lord. The things.
Lawyer was representing you. You are legal advice. You have signed it. What is the value of a compromise in a Lok Adalat if this kind of things
I
are
do agree, my lord. I
accepted?
do agree, my lord, because my lord, all the conditions have been taken by me subsequently by filing a suit alleging the contention that there is a fraud. My lord, this court and also.
Have you taken action against the lawyer who appeared for you?
No, those persons, because my lord, I don't know what happened there. There was no.
You take action against the lawyer and come, then we'll consider. You are very easy to make allegation against the lawyer who is not before us.
No, I am not making any allegations, my lord. The things is that, my lord, everything.
You are represented
What
by
the
counsel.
judgment says, my lord, if there is the judgment of the Honorable Supreme Court and this court, my lord, says that when the compromise recorded by the Lok Adalat, my lord, the court has looked into everything, the aspects of the complete aspects of the pleadings, where in the original plaint, my lord, they say they question the validity of the earlier judgment and decree 24/2007 to be set aside. That
where is it set aside?
Page number 44, my lord. 44. Then come to my lord, page number 50.
Set aside illagide.
ಇದೆ Swami. To declare that the judgment and decree dated 14/10/2014.
Compromise ಅಲ್ಲಿ ಏನಾಗಿದೆಯಪ್ಪ?
ಕಾಂಪ್ರಮೈಸ್ ಅಲ್ಲ ಅದೇನು ಹೇಳಿಲ್ಲ.
ಮತ್ತೆ ಕಾಂಪ್ರಮೈಸ್ ಏನಾಗಿದೆ ಅತ್ತನೆ ನೋಡ್ಬೇಕು.
ಅಲ್ಲ ಆದ್ರೂ ಇದು this will have a bearing, my lord. Without setting aside this also, my lord.
You can't be signing compromises and then come and say there's fraud just like that.
No, my lord. In rural area it happens, my lord.
In rural area we'll do one thing. We'll bring on record the KSLSA.
ಅಲ್ಲ ಇದರಲ್ಲಿ
get their input as to whether it has to be allowed or not.
No, my lordship is very well known that the rural people, all the family members are not before the court also. All these things are there, and even the correction.
We not accept compromise because a person belongs to a rural area.
I do agree, my lord. But here is the circumstances, my lord, where fraud is played by the proposed purchaser. He gets the.
We'll do one thing. We are getting a lot of these matters where everybody comes and says fraud and that. It's very easy to say fraud. We'll get the member secretary,
What
legal
can I
service
say?
authority to be a party.
More than that, I don't know, my lord. Because
be a party. You have signed it.
My lord, even the signature and also the LTM may kindly be seen.
This is yet another matter where persons who have executed, there is yet another matter where persons who have executed a compromise petition before the Lok Adalat are before this court contending that there's fraud.
One point, legal point is there, my lord. One legal point I will make clear to the minds of this before passing that.
We'll hear the member secretary legal service authority because these kind of submission that it should not be rural.
Yes.
We'll consider it and pass it on.
One more good submission I will make it. I have filed a suit for challenging the compromise decree in 277 of 2020, page number 111, my lord, where I have made all allegations about how I have been played fraud before the Lok Adalat. There, my lord, the matter was posted for evidence of my, because fraud is vitiates everything, my lordship is now. So I have to be proved as per the decisions of the Honorable Supreme Court and this court, Anchan Katesh. Shivkumar, latest judgment, fraud, if there is a fraud, you prove that is a point to be proved in the civil court. So therefore I filed a civil suit. My lord, my lord, again this purchaser, defendant number 5, my lord, he files one application 7 Rule 11. If I would have been permitted, I would have been proved of a fraud there itself. He intervened in the matter and he files 7 Rule 11 application.
Yes, because suit
alone,
is not maintainable.
Alone, my lord. That was partly alone. Partial rejection of plaint is not permissible, my lordship is well aware.
Permissible, read Supreme Court judgment. This is yet another case where the petitioners who were signatories to a compromise before the Lok Adalat are before this court alleging that there is fraud played on them before the Lok Adalat and that they had not executed the compromise petition voluntarily. This despite their signatures being found on the order sheet, they having signed the compromise petition and a compromise decree having been passed way back on 8/4/2017 the challenge to this said compromise was made by filing the suit number,
Yeah, sir.
compromise challenge ಮಾಡಿದ್ರಲ್ಲ.
7/18 of 2015.
How can that be? 2017 is the compromise. ಮತ್ತೆ ಸೇಮ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ. 718 ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದ್ದು.
ಹೌದು.
ನೀವು ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ರಿ ಅಂತ
ನಾನು
ಹೇಳಿದ್ರಲ್ಲ.
277 of 2020.
277 page number?
111, it seems.
111? By filing a suit in invoice number 277 of 2020 and now by filing the above writ petition.
7 rule 11 ಅಲ್ಲಿ they say you go to High Court for writ petition.
These kind of issues arising on a virtually a daily basis, it is required that these issues are considered properly and necessary orders passed. Hence, I am of the considered opinion that the Karnataka State Legal Service Authority, represented by its member secretary, who conducts the Lok Adalat, is required to be brought on record as a party respondent, and as such is brought on record as respondent number 9. Registry is directed to furnish a full set of the papers to the member secretary. Member secretary to make his submission as regard the allegations which have been raised in the present matter, and the procedure to be adopted. Relist on 19th August.
The other respondents can also be served so that.
We are not issuing a notice right now. We'll hear the member secretary and then. Mostly we may not issue a notice.
No, I do my best efforts, my lord, because I am
But
not.
you have done your best.
I am not advocate in the, whatever the matter transpired in the.
Suppose you are on this side and compromise has been entered into, after 8 years come and say it's not there.
Because they say COVID reasons and all these things, everything is, a lot of things are there, my lord.
Yes, next.
God bless.
36, B.M. Siddhappa.
Yes, Mr. Siddhappa.
This petition is filed by the petitioner for transfer of authorization. Yes. The father of the petitioner died on 1/7/2026. Transfer of authorization. Petitioner.
On compassionate basis.
On compassionate basis.
Rejected because more than 65 years.
More than 65 years.
And AGA accepts notice for respondent number 1 to 3. Petitioner is before this court seeking for the following reliefs. The petitioner's father had been granted an authorization to run a fair price depot on 8/6/2017, which has been renewed from time to time and is in force until 6/6/2030. Unfortunately, the father of the petitioner expired on 1/7/2026. Hence, the petitioner made an application to respondent number 3 to transfer the authorization standing in the name of his father on compassionate basis. The said request was rejected by the endorsement dated 10/7/26 on the ground that the father of the petitioner was aged more than 65 years as on the date on which the application was, as on the date of his expiry, and as said the application could not be considered. This court in a catena of decisions has held that it is the age of the transferee which is required to be considered for the purposes of transfer on compassionate basis and not the age of the authorization holder. In that view of the matter, this court passes the following order. Writ petition is allowed. A certiorari is issued, so and so 10/7/26, Annexure C is quashed. Respondents are directed to consider the application for transfer made by the petitioner dears the age of the deceased father by complying with the applicable formalities within 30 days from the date of receipt of a copy of this order.
7, Rakshita DJ.
For the petitioner, my lord.
Yes,
My lord,
madam.
on 15/12/2025, Annexure A is the tender notified by respondent number 4.
15/12/25.
Please, my lord, Annexure A at page 16.
Hmm.
If my lords kindly comes to page 22 onwards,
Hmm.
page 24, my lord, the bid validity period in the schedule at page 24.
Hmm.
Lord, bid validity period at the bottom end, my lords will find.
Yes.
180 days.
Hmm.
And this was notified, my lord, on 17/12, which my lords will find at page 22, published date,
Hmm.
17/12. So what has happened, my lord, the petitioner has participated and qualified in the technical bid. Annexure beach, page 26, my lords will find this. Thereafter, my lord, financial bid, it is once again with regard to service charges, page 27, my lord, 2% is the service charge quoted. Now, my lord, the bid validity period has expired on 17/6/2026. The tender process is not completed during this period.
Yes.
Thereafter, my lord, a letter is issued on 17/7/2026, page 40, my lords, by the Deputy Commissioner and District Magistrate, stating that they will call for, my lord, a draw of lots lottery system, page 40. To this, my lord, petitioner has also submitted objection at page 42.
Was there any litigation in between?
My lord, as per our information, it is not. And my lord, they can seek extension, but that extension should be with the even the validity period, my lord, extension rule 22(2) provides for that. But that should be in concurrence by all the tenderers. Page 43, my lord, this is the circular by the very state government.
180 days expired long ago.
180 day, I will just inquire whether they have sought the extension from the superior, my lord, because the rule says that this notification says,
And
my lord,
AGA accepts notice for
any, can I just,
Extension is not from the superiors, even from
1,
the
2, 3.
tenderers.
4 also you will accept notice?
no, my
City
lord.
officer?
Temple, I'll, yes, my lord.
1 to 4. He seeks for and is granted 3 days time. Relist on 7th August.
My lord, let them, if they issue work order, then
Nothing
third
will
party
happen.
rights.
Draw of lots. 1 of 26 is allowed.
My lord, then I'll be relegated to section 16 if award is passed. Any
Respondents are
order
restrained
passed
from
subject.
issuing any work order till the next day.
Yes, my lord. Because
Agreed
the,
to.
my lord, the notification says any relaxation above timeline shall be specifically authorized by authority superior to the tender accepting authority.
On record.
I'll just seek whether,
It expired in March 26.
no, my lord, not in March. 180 day, June 17th, it has expired. my lord.
June. Sorry, it's
So
180 days. June.
I'll just seek
1
this.
month this letter is issued, my lord.
Let's see.
Or those decisions also have placed it.
Let us see, madam.
Please. Obliged.
Your Lordship, petitioner is before this honorable court
Hmm?
seeking a disposal of the certain applications he has presented under the Arms Act, Your Lordship, for extension of
AGA
area.
accepts notice for respond.
Your Lordship,
Who appears?
no, Your
State.
Lordship, this is, Your Lordship may direct to dispose of the application within 15 days, Your Lordship, because this has been pending for 2 years, while the prescribed time limit is 15 days, basis the schedule
Does not
5
the
of
prayer that you
serial
have
number.
sought for? Have you submitted a representation?
Your Lordship, this is annexure B says his arms license is valid throughout Karnataka region. At the time of renewal, I was curtailed to Anekal Taluk. So with reference to this, he has filed an application to relook into it, which is
And
pending for
AGA
2
accepts
days,
notice
2
for
years.
respond. Is granted 10 days time to obtain instruction, make a submission. Relist on 19th August.
39.
Yes, Mr. Subrahmanyam.
This is unilateral cancellation, Lord's rectification deed executed after 50 years by the same person, without the other party, Lords, who executed the sale deed.
There is a registration.
What happens,
Writ
Lords, is,
petitioning maintainable.
Lords, in an identical circumstances, Lords, in fact, Lords, I was also concerned about the maintainability of the writ petition. Lords, may just pass on, Lords.
Yes.
It's, para 2, Lords, in the said order, it appears that the father of the appellants purchased the plot in question from respondent number 4 by a registered sale deed dated 21/6/1983, and since then the appellants have been in possession and enjoyment of the said property. Subsequently, it appears that the fourth respondent purported to get the said sale deed cancelled unilaterally, executing the cancellation deed dated 4/8/2005. and the same was registered by the third respondent without any notice to the appellants. Then, my lords, para 4. In our opinion, there was no need for the appellants to approach the civil court as the said cancellation dated so and so, as well as the registration of the same was wholly void and honest and can be ignored altogether. For the illustration, if A transfers a piece of land to B by a registered sale deed, then if it is not disputed that A had the title to the land, the title passes to B on the registration of the sale deed, and B then becomes the owner of the land. If A wants to subsequently get the sale deed cancelled, he has to file a civil suit for cancellation, or else he can request B to sell the land back to A. But by no stretch of imagination can a cancellation deed be executed or registered. This is unheard in law. And in fact, my lords, your lordship's order also, my lords, in
And that was a completely different matter. That there was a Madras High Court order. Everything.
yes. But here is a case where, my lords, the kindly see, my lords, 1968 is the sale deed. 3/10/1968. And after 50 years, my lords, the entire boundaries are changed by virtue of rectification deed without, my lords, the executor being a party to the rectification deed.
The impugned judgment is set aside. The civil appeal. There was a suit again. And AGA accepts notice for respond number 126. Issue emergent notice to respond number 7 written out by 8th September. Take into consideration decision of the Honorable Apex Court in 2010-15 SCC 207. You are also challenging a 2017.
It was not, my lords, notified to me. No, it was only executed by him. The person who presents, my lords, the document is the same person. The person who gets the
207. The respondent number 7 is restrained from any manner alienating, dealing with, encumbering, or changing the character of the petition scheduled property till the next date of hearing. Process fee and copies to be furnished by end of day 4th August, failing which the interim order will stand automatically. R5 Mysore City Corporation error. Pallava R for respond number 5. Serve copies on it.
40. Danuru Viswanathan.
My lord, this petitioner is defendant number 9 before the trial court, my lord. Plaintiff and defendant number 14 enter into the compromise petition before Lok Adalat. I filed, without knowledge of me, my lord, later I filed the recall application before the concerned court, my lord. Now.
You are a party to the suit?
Yes, my lord. I am defendant number 9 in the suit, my lord. The scheduled properties are standing in my name.
Where is the compromise petition? Are you signatory to the compromise petition?
Enter into the compromise petition annexure B and annexure C is award, my lord. I filed the recall application before the court, which is order passed in page number 99, my lord. In annexure E, order sheet, entire order sheet I have produced, my lord. The case is posted on 6/4/2026, my lord. That is in page number 96, my lord. Later, the matter is advanced before the Lok Adalat and compromise.
426.
Yes, my lord. 6/4, it is posted for further chief of PW1.
6.
Later on 14/3/2014, matter is advanced without knowing the knowledge of this petitioner, my lord. Enter into the plaintiff and defendant number 14.
You are not a signatory.
My lord?
You are not a signatory.
Yes, my lord.
So I filed
No one
recall
can have
of,
a guess, sir.
I
You're
filed the
not a signatory. And issue notice to respondents returnable by 8th September.
Defend.
Considering that the petitioner is not a signatory to the compromise entered into before the Lok Adalat
Yes, ma'am.
in OS number 58 of 2016, then pending on the file of the second additional senior civil judge, BRD and Renappa. Where is this suit pending?
Suit pending.
Bangalore Rural District.
Bangalore Rural District.
BRD and the Bangalore Rural District. The said compromise would not be binding on the petitioner. The respondents are restrained, either jointly or severally are restrained from any manner alienating, dealing with, encumbering or changing the character of the subject property till the next date of hearing. Process fee and copies to be furnished by end of day 4th August, failing which the interim order will stand automatically vacated.
41.
And for the petitioner, my lord. My lord, the respondent number 5 and 6, my lord, the illegally transferred the petitioner's SP account number 1,70,000, my lord, to some unknown number by way of the UPI transaction. But indeed, my lord, the petitioner made representation for the fifth respondent, my lord, on Annexure C, page number 16, on 18/4/2024. But till date, so this amount is not resorted by the respondent 5 and 6, my lord. The illegal transactions. And the FIR was registered against the one unknown person. Annexure E, my lord, page number 18.
Unauthorized transactions. And AG accepts notice for respond number 1 to 4, TP Muttanna for respond number 5, State Bank of India, Vignesh Shetty for respond number 6. Mr. TP Muttanna and Mr. Vignesh Shetty are directed to secure instructions and make their submission as to whether the transactions which occurred in the bank account of the petitioner on 17/4/2024 are authorized or not. And AGA is also directed to secure instruction, make a submission as regard the status of crime number 198 of 2024, released on 19th August.
Statement.
42. Vijay Kumar.
Mr. Vijay Kumar.
Okay, sir.
K. Rajshekhar is directed to accept notice for respond number 1, AGA for respond number 2 to 4. None appears for the petitioner, released on 8th September.
43. Shikara.
Mr. Shikara.
Andamus seeking refund of excess stamp duty collected. This honorable court by way of annexure A order set aside the order passed by respondent number 1 and 2. Where under they asked payment of about 15 lakh rupees as deficit stamp duty for registration of a lease deed of for 60 years. That order was set aside by this honorable court. An order was passed in February 2026 by annexure A, directing them to reconsider the and within 60 days and pass orders. I issued one letter at annexure B, told them this is the order. Then they did not respond. Again, annexure C, another letter issued saying that you have not complied with the order. Order should have been complied with within 16 days. You have not done it.
Yes.
Please refund. They have not done it.
Only mandamus, consider it in terms of the order passed by this court.
Contempt copy of the.
Copy not.
Not served. 43, if your lordship says.
There is no seal.
I'll hear, sir.
AG accepts notice for respond number 1 to 3. Petitioner is before this court seeking for the following. The grievance of the petitioner is that the direction issued by this court on 9th February 26 in WP number 15790 of 2022 had not been complied with by the respondent, which resulted in the petitioner submitting 2 representations on 13/4/26 at Annexure B and 12/6/26 under Annexure C, despite which no orders have been passed by the respondents till date. When orders are passed, this was contempt in ideyalappa nimge.
I am saying,
26.
I am saying order is set aside. Order directing payment, I have already paid the amount. I am saying refund the amount to me. Or
Matter is remanded, who shall take into consideration terms of the lease and pass reasoned orders.
order is set aside. They have to do either of the two. Either adjudicate or make the
Sale
payment.
number 4 is there. This court, wide order dated 9 February 26 in WP number so and so, had remanded the matter to respond number 2, who was directly taken into consideration the terms of the lease and pass a reasoned order as to if there are any covenants in the lease which impose restriction on the usage of property, ultimately affecting the market value of the property, and thereafter determine the market value of the property. Despite which and despite the representation submitted, the said action has not been taken by respond number 2. In that view of the matter, this court passes the following order. Writ petition is partly allowed. A mandamus is issued directing respond number 2 to comply with the directions issued on 9 February 26 in WP number 15790 of 2022 and pass orders on the representations at Annexure B and C within a period of, was any time fixed?
Otherwise 60 days.
Within a period of 30 days from the date of receipt of a copy of this order. It is made clear that this court has not expressed any opinion on the entitlement of the petitioner. Same would have to be considered in terms of the directions issued by the coordinate bench and so on.
44, Naveed Ahmed.
Yes, Naveed.
Lords, the impugned notice issued by the Lokayukta, Lords, but not against the petitioner. Lords, initially, Lords, first complaint was filed in 2021, Lords.
There is no interim relief. And AGA for
the interim relief, Lords. Lords.
1456. Venkatesh Arbati for respond number 2 and 3.
Public Lords.
Released on 19th August.
Public.
45, Nagaraj.
Yes, Ms. Nagarajan.
Petitioner, my lord.
Really?
It's the transfer of the authorization, my lord. It is endorsement as issued in response number 2. Is aged about 65 years. Petitioners have only for 40 years, my lord. It's covered matter, my lord. It is.
And AGA access notice for respond number 1, 2, 3.
Father of the deceased was 73 years, my lord.
The father of the petitioner had been, until you formulate that policy, we'll have to follow this. Had been granted authorization to run a fair price depot in 2017-18, which has been renewed from time to time. Yavagarugu ide, till when is it in force?
My lord is. Father is dead, my lord.
When was the last renewal? Till when is that authorization in force?
Renewal, my lord, it is 2020 tanka ide, sir. 31/12/2020.
ಅದು ಎಕ್ಸ್ಪೈರ್ ಆಗೋಗಿದೆಯಲ್ಲ.
ಅಲ್ಲ ಈ ರಿನ್ಯೂವಲ್ ಇದೆ ಸರ್, ಅದೊಂದು ಕಾಪಿ ಹಾಕಿಲ್ಲ ಸರ್. ಇದೆ ರಿನ್ಯೂವಲ್ ಆಗಿದೆ ಸರ್.
ಹೇಳ್ಬೇಕು ನೀವು
ರಿನ್ಯೂವಲ್ ಆಗಿದೆ. ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಆಫ್ಟರ್ ಲಾಸ್ಟ್ ಡೆತ್ ಆಫ್ ಫಾದರ್ ತನಕ
counsel for the petitioner seeks fund is granted a week's time to place the latest authorization which is in force on record, released on 19th August.
46, Ganpati Bhatt.
Yes.
Writ of mandamus for refund of banker's check amount.
Third respondent, Deputy Commissioner to issue NOC.
In the name of the, we take on the banker's check in the name of the third respondent. To the SBI. Annexure B, my lord, their bankers are saying that NOC is required from the Deputy Commissioner.
State Bank of India.
Vignesh Shetty.
Vignesh Shetty for respond number 1 and 2, and AGA for respond number 3. two sets of the petition, so on, so relist on 19th August.
47.
My lord, I'm for the petitioner, my lord. This is regarding externment, my lord. Order passed by the third respondent, my lord. My lord.
Where you served with notice?
Please, madam. Please not served notice, my lord. No notice to the my lord. The my lord, the fourth respondent had filed 15 cases against the petitioner. Order acquitted, my lord, except two. The 13 were acquitted. The two were so pending, my lord.
Party present ಅಂತಿದೆಯಲ್ಲಪ್ಪ.
ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ, but in
ನಿಮ್
not.
ಸಿಗ್ನೇಚರ್ ಇದೆಲ್ಲ.
ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ.
ರಾಜಶೇಖರ್ ಸಿಗ್ನೇಚರ್ ಇದೆ.
The order sheet ನಲ್ಲಿ ಇರಬಹುದು ಸ್ವಾಮಿ, but
Page
hearing
23 ನೋಡಿ, it's ರಾಜಶೇಖರ್ signature is there.
First page ಇದೆ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ 23 ಅಲ್ಲಿ. But regarding out of 15 cases, 13 were acquitted, my lord. Only two are pending. 354, 506, 504, and 323.
All that is an appeal, Mr. Harvey.
Externment. The DC has the deputy, the.
You have been issued notice, you have been heard, your client had appeared, he's been heard. Statutory appeal under section 59. We won't be considering the merits. And AG accepts notice for respondent number 1 to 4, 1 to 5. Petitioner is before this court seeking for the following reliefs. What is being challenged is an externment order passed under section 55 of the Karnataka Police Act, so on so.
The final order.
Seal of the records indicates that the petitioner had been served with notice. He had appeared personally before the executive magistrate and was heard by the executive magistrate before the order was passed, impugned order was passed. In that view of the matter, the principles of natural justice have been complied with. The petitioner has a statutory remedy in terms of section 59 of the Karnataka Police Act, reserving liberty to the petitioner to avail the statutory appellate remedy, leaving all contentions open. Petition stands disposed.
48. Anand Veerananavar.
Mr. Veerananavar.
This will have to go, my lord, before the roster court.
Complete the investigation.
528.
Only for completing the investigation.
CRPC. 528 read with 226, 227.
He has corrected it here and given you the.
He's corrected.
The mandamus to complete the investigation, crime number 352.
Please.
Now, AG accepts notice for respondent number 1, notice to respondent number 2 to 4 is deferred for now. Now, AG is direct secure instruction, make a submission as to the status of the investigation in crime number 352 of 23, registered by the first respondent. Relist on
This is
19th.
pursuant to a complaint under 200.
What is the status of the investigation?
Chandra Lever.
49.
The petitioner's case. Not the, it's a mandamus seeking consideration of a application filed under the Arms Act, my lord. The petitioner is an agriculturist and a doctor. The respondent number 4, the Tahsildar has also given a written recommendation letter in favor of the petitioner getting an arms license, saying that he qualifies, he has a medical training, he has the medical fitness, the police training for obtaining a arms license. The application was filed in the month of November in 2025, my lord. It's been over 260 days now that the respondent has not considered the application.
It's been sent back for reconsideration.
Please, my lord, if I may be. Annexure E, my lord, if you see at the paragraph number 2, ಅರ್ಜಿದಾರರ ವ್ಯವಹಾರ ಅಥವಾ ಉದ್ಯಮದ ಬಗ್ಗೆ ಯಾವುದೇ ಬೆದರಿಕೆ ಇರುವುದ ಬಗ್ಗೆ ಯಾವುದೇ ದೂರುಗಳು ವರದಿ ಆಗಿರುವುದಿಲ್ಲವೆಂದು ಅರ್ಜಿದಾರರಿಗೆ ಆಯುಧ ಪರವಾನಿಗೆ ಮಂಜೂರಾತಿ ಶಿಫಾರಸು ಮಾಡಿರುವುದಿಲ್ಲವೆಂದು ತಾವು ಉಲ್ಲೇಖರಂದು ವರದಿ. This is not, my lord, section 14 of the Arms Act, my lord, is exhaustive. Only if those parameters are met, it has to be rejected, my lord. Not having any criminal threat against the petitioner is not a ground to reject, my lord.
You'll have to challenge it. You have not challenged that.
There is no final order being passed on the application, my lord. This is only sent back for reconsideration on the ground that there is no criminal threat of violence against the petitioner.
That sent back, you have not challenged it, Mr. Counsel.
Please, my lord. My lord,
They have to be set aside for a mandamus to be issued.
My lord, this is reconsiderations and there are high court decisions which say that.
Can't say anything more. We can only decide.
My lord, my humble submission is there are high court decisions which say the application ought to be considered.
Respond number 1 to 4. The 6th fund is granted 2 weeks time, relist on 8th September. Think about it and do what is required.
Please.
Serial number 50. Explain Ryan.
My lord, writ petition is filed by the insurance company, my lord, challenging the order of Annexure D, my lord. I filed an IA, Annexure B, my lord, to impede the owner and the insurer of the offending vehicle, my lord. The vehicle which was involved in the accident.
Yes.
And the tribunal has rejected the IA, Annexure D, my lord. They are necessary parties to adjudicate the matter efficiently, my lord, because
Why do you want to impede them? Because
because he is also necessary party, my lord, because the accident occurred due to both negligence on the part of the deceased. This honorable court in a similar circumstance has granted stay.
Here the charge sheet has been filed.
Yes, my lord.
Stating that the negligence is on part of the owner of the vehicle you have insured.
Yes,
the
my
driver
lord.
of the vehicle that you have insured. And there is no negligence on part of the proposed respondent.
Yes, my lord.
The charge sheet has already been laid, that has been taken into account and
My lord, they are both necessary parties to the case, my lord, because the deceased was, he himself was negligent in driving the vehicle and dashed against my vehicle, my lord. And this honorable court has pleased to grant a stay in another connected matter, another case, my lord. I'll pass the.
That is a different matter. In this matter, please argue
Yes,
and
my
make
lord.
your submission. The finding of the trial MSCT.
My lord, this is a case, my lord. As per the police document itself speaks that entire negligence on the part of the deceased.
Favor of the police documents
Yes, my lord.
submitted before the court, there is no whisper that the accident occurred due to rash or negligent driving of driver of the car. By considering all these factors, respondent
My
not
lord.
made out sufficient ground to allow the application.
The insurance company of the car and the owner is also necessary party to adjudicate the case.
Why, Mr. Counsel, is what we have been asking you.
My
That
lord,
time we asked you.
he was also negligent in driving the vehicle.
Charge sheet says otherwise.
Charge sheet is against me, my lord.
Mate?
Alright.
You can't be dragging in
impleading-
people just because you want them to be parties.
My lord, because he is also necessary party to decide the case, my lord, on merits.
For what reason?
Because he is also negligent in driving the vehicle, my lord.
Charge sheet says otherwise. They repeat ಮಾಡ್ತಾ ಇದ್ದೀನಿ. Notice to the respondent is dispensed with the new of the proposed order.
I have filed an IA.
Petitioner is before this court seeking for the following leaves.
In the similar matter, this honorable court has given.
Here we are
notice,
going
my
by
lord.
what is the finding in the order. That's a different issue.
Finding.
The respond number 1,
And the
2
charge
and
sheet and sketch speaks that he was also negligent.
Anjun Ravelli. Swaroop. Respond number 1 and 2 had filed a proceedings in MVC number 3845 of 2025 seeking for compensation on account of the accident which occurred on 9/1/2025. The respondents therein being the owner of the vehicle belonging, that namely respond number 4, and the insurer of the said vehicle being the petitioner herein. In the said proceedings, the insurer had filed an application to implead the owner and driver of the other vehicle which had been involved in the accident. The owner and insurer of the other
Also,
vehicle
owner
which
and
had been
insurer, both.
involved in the accident. The said application came to be dismissed by way of order dated 4/7/26, challenging saying the petitioner insurer is before this court. The submission of learned counsel for the petitioner is that the other vehicle involved in the accident, as also its insurer, are required to be brought on record for effectively adjudicating the dispute, inasmuch as the driver of that vehicle
Yes, my
was
lord.
negligent,
Yes,
resulting in the accident.
yes, my lord.
The MACT has considered the charge sheet filed in crime number 11 of 25 by the Nelamangala police arising out of the very same accident, and has come to a conclusion that the negligence in the charge sheet has been attributed to the driver of the vehicle, charge sheet vehicle insured by the petitioner, and there is no whisper of any rash or negligent driving of a driver of the car who is now, whose owner is now sought to be brought on record as a respondent. There being no particular allegation made against the said driver of the car, the question of impleading the owner of the car and the insurer of the car would not arise. This court does not find any infirmity in the order passed by the
This court
MACT.
has,
The petition stands dismissed. Kodiyad.
in the connected, this is same type of case, my lord. This,
ಮೂರ್ ಸತಿ ಹೇಳಿದಿರಾ ಅಂತ ನೋಡೋಣ. But we'll have to go by these facts.
please. In a similar matter, for impleading IA, Order 1 Rule 10. This court has granted stay, my
That's a
lord.
different matter. And there's only a notice
Notice.
dismissed.
51.
Stay has been granted, my lord, in that case.
That's a complete different matter.
Ajay N.
For the petitioner.
Yes.
Challenge to include order A to A2. Annexure B is the initial tender notification that is issued by the respondent number 5.
Annexure page
B allots, page number 17.
17. Yes.
That's the tender that was issued by respondent number 5 allots for the public work that is supposed to be executed in Delhi. Nowhere has there been a reference allots that the said office should be established in Delhi. While I upload my application allots, there comes a pop-up window which says that I'll have to have an office. In that particular regard, I also give a representation saying that I have been working in Bangalore for many years, and I've also given a representation saying that I have my people and an established office there. But despite that, a rejection order is placed under A, A1 and A2 allots. Nowhere in the notification they prescribe that an official office has to be established in Delhi.
In Delhi.
Please, your lords. But the work is supposed to be executed in Delhi, your lords. But in the official notification as such, there is no such bar or the embargo saying that I should also have an office in Delhi. Because I have an established office here.
Where does it say because that it's been rejected?
And previously, your lords, just placing on record the orders of this honorable court. In the previous such writ petition, your lords,
Where is that order saying that because
they
you
haven't told anything, your lords. That is where my annexure F, I've also given a representation saying what is the purpose of rejecting it. They've nowhere disclosed it.
accepts notice for respond number
My lord, may I make one submission, my lord?
Annexure F, if your lordship can kindly.
1 to 5. He seeks for and is granted a week's time to ascertain and make a submission as regard the reasons for rejection of the tender of the petitioner.
Lords, until
Released
then,
on
interim
11th
order.
August.
Interim order may kindly be.
Are you
Lords,
one of
one
26,
submission, your lords. Page number 31, your lords. One symbol. 31, your lords. Previously, there was similar such tenders where I have been rejected. This honorable court has given me an order in my favor saying that he should not be debarred until the conclusion of the said proceedings before the debarment committee.
You are now said your submission was that because you did not have an office
No,
in
I'm
Delhi.
the other
That
option.
is the only reason why it is. Let's find out what is the reason.
Please, your lords.
Though you know all the reasons, you are not stating it.
Please.
So we'll get it from them.
Please, your lords.
My lord, in the tender condition, my lord, electronic condition, it is not that when he is uploading the pop-up came, my lord. The tender condition.
Nowhere in the condition it's mentioned here.
My lord, I am submitting the online tender condition, my lord. It's clearly stated.
You are ready to address the argument or you want instructions?
No, my lord, I'll seek instruction.
Yes. ಅಲ್ಲ 2 ನಿಮಿಷ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬಿಟ್ಟು ಟೈಮ್ ಕೇಳಬೇಡಿ.
My apologies.
Please, your lords.
52. Open Prasad.
With respect to renewal application under the Arms Act, my lord, the petitioner previously owned an arms license. The same application was filed on 9/10/2025, my lord. It's not.
And AGA accepts notice for respond number 1 to 4. She seeks for and is granted 2 weeks time. Released on 24th August.
53, Akshay Kumar Jain.
Yes.
Order of extendment is under challenge, my lord, is at.
Were you
annex-
served with notice?
Page 28.
My lords, order sheet is at page number 20, my lords.
Hmm.
This is a case, my lords, where police have taken me and kept me present before the assistant commissioner. Later, there were no proceedings. Page number 24 may be seen, my lords. On 12/11, notice was ordered to be issued. Then final order has been passed, my lords.
We'll remit it back, madam.
Please.
Let them make their submission.
Yes.
And AGA accepts notice for response. Petitioner is before this court seeking for the following leaves. A perusal of the papers indicates that though initially the petitioner had been served with notice and appeared on 37/25, on all subsequent dates, that is 13/8/25, 28/25, 10/9/25, 17/9/25, 8/10/25, and 15/10/25, there was no sitting of the executive magistrate. And thereafter, without a fresh notice having been served on the petitioner, the impugned order had been passed. In that view of the matter, this court is of the considered opinion that the principles of natural justice have been violated. And as such, this court passes the following order. Writ petition is allowed. A certiorari is issued. The order dated 12/5/26 in case number so and so passed by the second respondent is set aside. The matter is remitted to the second respondent for fresh consideration. The petitioner shall appear before the second respondent without requirement of any fresh notice on 19th August 2026 at 2:30 p.m. and make a written submission as also oral submission on that date, which shall be considered by the executive magistrate and necessary orders passed within 30 days from such appearance.
Obliged.
54, Pallava.
Second round of litigation, my lord, before this honorable court seeking release of the admitted dues. Not in the previous round of litigation, your lordship may find it at annexure.
You want a declaration that they are due.
ಏನಾಗ್ತಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ, my lord, I had rendered services during COVID-19 pandemic. I had supplied vehicles.
In a writ petition, we can only issue a mandamus. If they don't comply, you can go for contempt. We can't direct them. We can't issue a declaration that they are due. That will be in a suit.
Correct, my lord. The reason is the deputy commissioner, sixth respondent, has clearly admitted that sum of rupees 92 lakhs is due to the petitioner.
Then file a suit.
ಅಲ್ಲ ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ, my lord, the only reason given by the state is the SDRF and NDRF fund, the guidelines issued by the central government for release of SDRF and NDRF funds at present would not allow for release of funds. But on the other hand, the deputy commissioner has returned to the health
It's
and
not
family.
a recovery court, Mr. Pallava.
Correct, my lord. I do agree, my lord. My lord,
Relief cannot be granted.
it's an admitted sum, my lord. It's an admitted sum. Your lordship may kindly come to annexure K, my lord.
This is not a civil court or recovery court. It's a
Lord, I'll amend the writ petition seeking a writ of mandamus, my lord.
We'll only direct them to consider it.
Last time you consider anta, your lordship has ordered, the deputy commissioner has considered and has stated that the state has to pay and he does not have funds. My lord, right from 2021, I've been giving representation. What they're saying is, your health and family welfare or ಹೇಳ್ತಾರೆ ನಮಗ್ ಬರೋದಿಲ್ಲ, disaster management ಬರುತ್ತೆ ಅಂತ. Disaster management ಅವ್ರು ಹೇಳ್ತಾರೆ ಇಲ್ಲ ನಮಗ್ ಬರೋದಿಲ್ಲ, this thing. But the deputy commissioner has availed services.
Who is the one who has issued the contract to you?
The deputy commissioner.
File a suit against the deputy commissioner.
The deputy commissioner, my lord,
arbitration
now-
clause is there?
My lord,
Is there an arbitration clause?
there is no arbitration clause.
Then I will have to file a
COVID-19 pandemic ಇದ್ ಮಾಡಿದ್ರು.
And AGA accepts notice for respond number 127. National Disaster Management Authority.
Respondent number 8, my lord, is a central agency.
Shri Shanti Bhushan and DSGI is directed to accept notice for respond number 8. Counsel for the petitioner to furnish 2 sets of the petition along with annexures and said counsel. Relist on 8th September.
Great.
Lordship, is a mandamus for change the IO. IO is very colluded with the accused. He not investigated properly. He not started at all the investigation at all.
Not started the investigation.
Lordship,
ಇನ್ನ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಏನು ಆಗಿಲ್ಲ.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಶುರು ಮಾಡಿಲ್ಲ. 16/12/2025 FIR ಮಾಡಿರೋದು.
And AGA accepts notice for respondent number 1 and 2. He is directed to secure instruction, make a submission as regards status of the investigation in crime number 304 of 25, registered by the Sadashivnagar police station, as also to make a submission as to when approximately they said investigation will be completed. Released on 19th August.
Great Lordship.
56, Prameya and 30.
Your Lordship appearing for the respondents in this matter.
For the petitioners, my lords. My lords, we were challenging the annexure A at page number 29, but in the afternoon, before lunch, the FRRO has reconsidered the application which is filed by the petitioners, and they have granted the extension visa which we wanted, considering
Conversion of the visa, Your Lordship.
So what do you want to do?
My lords, I may
It has become infructuous,
since
Your
it has been infructuous, like I'll withdraw the.
What do you have to do? File a memo. Shri Aditya Singh accepts notice for respondent number 1 to 3. Petitioner is before this court seeking for the following. Memo has been filed. Accepting said memo, petition is dismissed as infructuous.
Maybe, yes.
IA 1 of 26 is allowed.
Much obliged.
57,
57. Yes.
Petition has been providing catering services, my lord, Indian Railways. Certain rail routes and rails which have been in the allotted, my lord, to him has been assigned to somebody else, and the COVID also interfered, my lords, in the meanwhile. And our case is, my lords, the routes which were allotted to.
Go to civil court. You
No,
want
allotted this-
extension, you want compensation.
No, you are given the representation, they should consider the representations, my lords. They not consider the representations are pending. Since
So what is your vested right to seek for this
one
representation?
is, my lords, the COVID where it was completely closed. Second is, my lords, the routes which are assigned to this petitioner, my lords, in the work order. The routes you also mentioned page 71, the work order, 72 are the routes, different rail routes, my lords, train services. They are themselves given to somebody else, and we are, my lord, required to pay the fixed fee every year. The fixed fee is fixed, my lords. And the fixed fee is at page 37 lakhs 35,000 every year we have to pay. And my lords, if you have to pay that, we should be permitted to provide the catering services in these routes. They have
It's all disputed questions. How do we?
no, this as far as this aspect is concerned, my lord,
Contractual remedies you have.
my lords, our request is let them consider representation. They have duty bound to.
What is your vested right for that consideration?
No, once, my lord, the state authority, my lord, gives the route to us, my lord, they cannot, during the subsistence of that contract, during that period, again allot to somebody else.
It's a violation of the contract.
Exactly, my lord, violation.
The
of the
violation of the contract,
No, my
you have
lord.
contractual remedies.
No, my lord, I do concede, my lord, as far as contractual remedies are concerned, my lords, of course, the power of the honorable writ court is also available, my lord. It depends in which circumstances the honorable court. Now I am at this stage, my lords, I am not entering into disputed questions. My prayer is, my lords, our representations submitted, my lords.
First, to issue a mandamus, you should have a vested right. Without
They
a
have to
vested right,
consider
we
the
can't
representation,
issue.
my lord, since, my lord, the state also has to be an ideal
Sorry,
contracting party. Your lords, may kindly see, my lords, they,
The so and so accepts notice for R1. What about IRTC? IRTC doesn't have.
I've been instructed only to appear for it, but I will seek further instructions. We only sent the nomination for R1.
Then who is the standing counsel for R2?
If I am, then I will file my further nomination.
Are they?
My lord, my submissions, my lord, with respect to the annexure A that has been relied upon by the petitioner. At page 46, there is a tenure of the license. The prayer of the petitioner is seeking extension, but the tenure of the license strictly says no renewal is permissible.
Correct.
And further, my lord, there is an arbitration clause as well in the same the application.
Page?
Arbitration clause is at page number 68, my lord. Event of any dispute between or differences between the parties related as construction or operation of this contract or respective rights and liabilities of the parties on any matter of with reference to the contract, parties agree to use their best efforts to attempt to resolve all disputes. So point number B, parties here to further agree to waive of the applicability sections 12 clause 5 of the arbitration clause and will submit demand in writing that the dispute or difference referred to arbitration along with format.
Yes, there's the arbitration clause.
No, my lord,
in respect some subject matter, if they give it to somebody else, my lords, now
It's all contractual dispute, Mr. Hegde.
I do consider as far
For
as
us
those
to-
aspects, my quantification, etc. is concerned, my lord, it is the arbitration. Now, when I give the
Petitioner is before
representation, my
this court
lords,
seeking for the following leaves.
would your lordships, my lords, permit us to avail the
Arbitral remedies.
arbitral remedy, because, my lords, our endeavor was to request them to consider it, my lords, because they have considered it in other cases, my lord, where representation have been given.
You get a mandamus here, High Court has directed, consider it, and that is what will.
That's what this in the
You won't
similar
allow the High
circumstances,
Court
my
orders
lords.
to be misused like that.
Your lordships only said, my lord, similar, of course, it may not be binding, I don't know. Your lordship said, consider it. And therefore they consider it, my lords, give justice to the parties also. Therefore, only prayer is, my lord, if they
Before this court seeking for the following leaves. What is essentially sought for is extension of a contract as also for compensation to be awarded to the petitioner by considering the representation submitted by the petitioner on 30/1/126.
If
There
your
is no
lordship permits
vested
me only one
right
sentence,
in the
my lords.
petitioner
Please.
to seek for extension of a contract
Why?
and or in lieu thereof for compensation to be awarded.
Only one sentence, my lords. For others, my lord, representations are given and considered an extension is given, my lords. Several cases are there. Several cases where extension is given. I have the papers.
Others you are given, then you will have to give. Lord, you get your instructions. Lord Council seeks for and is granted a week's time to obtain instruction, make a submission. Released on 14th August.
My lord, in the meanwhile, what they do is, my lords, the routes which is assigned, my lord, they will contact to others. That's why we prayed, my lord. Now we have come to know today, they are today they are proceeding to issue a new tender in respect to same routes.
You'll have to issue new tenders.
That's why, my lord, pending consideration, my lords.
From when is your client a tenderer there and supplying? Ask him, he will tell you probably 10 years or 15 years.
No, but for all others it's given, my lords. The same grounds.
This IRTC, all tenders are a farce. We are not using the next word. Next.
I will file that IEA, my lords, in the registry with copy to my lord.
Yes.
Please, great.
I request my lords to take page 55, annexure R.
Page?
55, annexure R.
50.
55. 55, annexure R.
55.
How so?
Yes.
This is a notice issued by respondent number 2 to the petitioner, dated 17/7/2026. What has happened, my lords? Respondents 8 to 11.
How are you asking for ESF Small Finance Bank Limited?
What has happened, my lords?
Huh?
Petitioner is a bank. Respondents 8 to 11 have pledged the bank, have pledged certain gold with the petitioner bank. What has happened? The petitioner respondents 8 to 11 are the authorized representatives like Karyadarshi Gadu, President, Vice President of respondent number 6, which is Malayuru Primary Cultural Cooperative Society. ಅಲ್ಲಿಗೆ ರೈತರು ಮುಂಚೆ ಗೋಲ್ಡ್ ನ ಇಟ್ಟಿದ್ದಾರೆ, ಅದನ್ನ ಇವರು ಮತ್ತೆ ನಮ್ಮ ಹತ್ರ ಲೀಪ್ರೇಜ್ ಮಾಡಿದ್ದಾರೆ. So what has happened in 2023, there is a crime registered against respondent number 8 to 11 and they're absconding since then. 2023 annexure.
How can this release be granted? Mandamus directing respondent to issue and execute appropriate steps for petitioner to return the.
What has happened, my lord? There is no privity of contract between me and the farmers who are aggrieved in this.
Committee to be.
Committee. I'm requesting for that, my lords.
Since there are some farmers, right?
Farmers,
what it is. Apparently, they want to return it, not to recover.
We are ready to return also, my lords.
They want to return it. See what is.
My lords, what has happened, my lord? Page 56. There is some imminent threat in this issue that they are ready to, including DC has said this. ಈ ವಿಷಯವು ಅತ್ಯಂತ ತುರ್ತು ಹಾಗೂ ಸಾರ್ವಜನಿಕ ಹಿತಾಸಕ್ತಿಯ ದೃಷ್ಟಿಯಿಂದ ಮಹತ್ವವಾಗಿದ್ದು, ಜಿಲ್ಲೆಯಲ್ಲಿ ಕಾನೂನು ಮತ್ತು ಸುವ್ಯವಸ್ಥೆಗೆ ಧಕ್ಕೆಯಾಗುವ ಸಾಧ್ಯತೆ ಇರುವುದರಿಂದ ಗ್ರಾಹಕರ ಹಿತಾಸಕ್ತಿಗೆ ಸಂಬಂಧಿಸಿದ ಮಾರ್ಗಸೂಚಿಗಳು ಹಾಗೂ ಜಾರಿಯಲ್ಲಿರುವ ಇತರೆ ಕಾನೂನು ಮತ್ತು ನಿಯಮಗಳ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ರೈತರಿಗೆ ಅನಗತ್ಯ ತೊಂದರೆ ಉಂಟಾಗದಂತೆ ಪ್ರಕರಣವನ್ನು ಸುವರ್ಣಿಸೋಮಲ್ಲ. And this is the letter issued by the Federation of Farmers at page 51, Annexure P. Typed copy is at page 53.
So,
So today was the day that the DC has told us to form a guidelines and return the gold back. What has happened in this letter? They say some tasks force, all these things are already formed, which we are not aware, my lords. So there should be a court monitor committee so that we can return the gold back to the farmers who are aggrieved in this matter.
and AGA accepts notice for respond number 1 to 5. Is there a council who appears for 6 and 7?
6 and 7 notice has to be issued, my lords. By hand it may be issued.
We can't grant you this interim relief. Is your interim relief as good as the final relief?
Notices may be
Same
ordered.
thing that you have asked for, you have asked here.
ಅಲ್ಲ ಧರಣಿ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ,
Notice
ಅದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇ.
to respond 6 to 11. Emergent notice to respond number 6 to 11, returnable by 27th August.
6 and 7 by hand ಮಾಡ್ಬಿಟ್ರೆ ಆಯ್ತು.
Counsel for the petitioner is also permitted to take out hand summons on respond number 6 and 7.
Much obliged.
59.
Mandamus defreezing minutes. Mandamus in regard to the defreezing of the
Within the
account
state, outside the state.
outside the state of Tamil Nadu.
Axis Sarama.
Francis Xavier.
Francis Xavier for respond number 1. Notice to respond number 2 is deferred for now. Petitioner is directed to appear before the Cyber Command on 6th August, relist on 13th August.
Grateful minutes.
Serial number 60. Lakshmi G.
Petitioner seeking a direction to register an FIR and investigate my lord into a criminal conspiracy by the wife and her friend to commit the murder of the petitioner. Lord, there is a conversation between the 5th and 6th respondent on a platform called Slack, who are the colleagues. My lord. They are the 5th and 6th respondent. 5th respondent is the wife of the petitioner.
Yes.
There is a conversation between 5th and 6th respondent on this platform to commit the murder by poisoning. Right, a complaint came to be filed on 12/6/2025, 26, my lord. Even as on today, no FIR has been registered. The NCR had been registered, my lord. The predicament is that
NCR has been issued.
yes,
Non-cognizable.
my lord. The notice of preservation was issued by the petitioner. These conversations, your lordship would kindly find it at page 24 of the compilation, my lord. These are screenshots of the conversation between 5th and 6th respondent, wherein, my lord, there is a discussion regarding choice of poison to be used.
Page 22, my lord, paragraph 12.
Yes.
Their complaint, my lord. They're seeking for, in view of digital nature of evidence and real risk of destruction of such evidence by my wife and Utteji Gopiraj upon incoming. So I request your authority to invoke its power under section 94 of BNSS to seize the mobile telephone, SIM cards, laptops and other electronic devices in the possession of my wife and so on. So.
What does this have to do with this taking supplements? It's not poison.
The choice of poison, my lord, would find it at page 28, my lord, resin poison. And there's also discussion that it could be forensically managed. And pursuant to filing the petition also, my lord, there was an incident where food is ordered from a platform and the petitioner was
He suffered from severe diarrhea and he was hospitalized. These are limited screenshots, my lord, that were available. Lord, if an investigation is ordered, there is any material against the respondents, it could be detected.
But you're not even registered a FIR, madam. The allegations made that his life is at risk.
Page 23, my lord, they say that, my lord, we have,
That is also one of it. Para 10, 11 and then 12 comes. 12 is asking you to do that to
Life
have
threat.
proof of all these. He is telling you what to investigate. But what he is asking is 10 and 11.
we'll consider it. my lord.
Cognizable offenses,
Please.
non-bailable. You made all of them party. And AGA accepts notice for respond number 1 to 4. Issue notice to respond number 5 to 7.
Correct.
Emergent notice returned by 27th August. And AGA to secure instruction make a submission as regard the steps taken in pursuant to the complaint submitted by the petitioner on 12/6/26, since the allegation made therein are relating to cognizable non-bailable offences.
Page 23, they have issued non-cognizable.
But they say that, agillalla.
Yes.
61, Sampath.
Yes.
Petitioners, my lord, sought to give a complaint, my lord, though the offences are annexure page 28. But the complaint, my lord, discloses cognizable offences. Still, my lord,
28.
annexure, my lord, they issued a NCR.
Page, where is the complaint?
Complaint, my lord, lordship find at page 28, annexure E, my lord.
28.
Lords, that page 30, para 2, my lords, the event has been para 2, unnumbered para 2. ದಿನಾಂಕ 17/5/26 ರಂತೆ ಏಕಾಏಕಿ ಸುಮಾರು 20-25 ಜನ ಗೂಂಡಾಗಳು ಕರೆದುಕೊಂಡು ನಮ್ಮ ಕುಟುಂಬದವರೇ ಆದ ಕೃಷ್ಣೇಗೌಡ ಬಿನ್ ತಿಮ್ಮಪ್ಪ ಮತ್ತು ಮಂಜುನಾಥ್ ಬಿನ್ ಲೇಡ್ ಭೈರವ್
Suit and RA pending.
Lords, while that they want to demolish the second time, Lords, many have come, they have entered, my lord, trespass, they demolished the compound wall. Lord, they also threatened, Lords, all the women are there. Lords. The second time this is happening, they come up with the 20 to 30 persons. Lords. Lord, they trespass into my property. There is a house constructed by my grandfather. We are residing there. The
What have they
partition,
demolished? Where are the photographs of the demolition?
Lords, they want to put a photograph. No, they trespass. They want to put the compound
You
wall.
said they have demolished the
No,
compound.
they want to demolish. No, we are residing therein. So 20 people came to the property, wanted to demolish. We resisted, gave a complaint.
How many of you were there?
But 20 to 25 they said, well, there.
ನೀವು ಎಷ್ಟು ಜನ ಇದ್ರಿ?
Plus we reside, well, 5 all the family.
And you were able to hold 25 people.
No, plus we gave a
Convert
complaint.
civil disputes to criminal disputes.
No, this is not a civil. This is second time it's happening. Well, for a partition suit for I filed, well, they want to come up with demolition.
And now you want to go tell them, see, I've got the police.
No, well, this second time they did it.
And AGA accepts notice for respondent 1 to 4. He seeks fund is granted 2 weeks time to obtain instruction.
For page 23, my lord. Here, in the previous proceeding, this property has been allotted to others share, my lord. He has
Yes.
challenged that FDP, and he has not got the stay. As per, I don't find any document of stay. As per his own pleading in the plaint, he is not in the possession, my lord.
It's all a civil dispute he wants to released on 8th of September.
Please.
52, Umesh DL.
For the respond number 3. Permitted to appear for the petition.
Yes, please.
The last may kindly take page 265.
265.
Is in earlier occasion, very same writ petition was filed by the petitioner questioning the calendar of events. This honorable court on 22/4/26 was pleased to quash the calendar of events and give certain direction to the returning officer to conduct the election. Kindly take page 265, paragraph number 5.
Yes.
Learned counsel, senior counsel appearing for the respondent number 3, though initially contesting the writ petition,
on instruction fairly submitted in the event of this court come to the conclusion that the election process stands vitiated, the respondent 3 has no serious objection for conducting election afresh in strict conformity with the bylaws. It is further submitted the respondent of 4 returning officer may be directed to reinitiate the election process by issuing a fresh calendar of events in compliance with the procedural mandate, including the issuance of notice. This is what it contains. Next, last per contra, the alternate counsel appearing for the petitioner would vehemently contended that the illegality is not confined merely to the issue of calendar event, but goes to the root of the matter. It is pointed out that the enrollment of new members itself is adheres to the bylaws undertaken at the point of time when there was no duly constituted managing committee in existence. Therefore, it is contended that a very electoral process stands vitiated unless a fresh lawful voters it is to be prepared at scrutinizing the eligibility of the members. Any election conducted would mean the mere formality lacking legal sanctity. Having heard the alternate counsel for the appearing for the parties and on perusal of the materials on record, this court find that the foundational requirement of conducting election to the society is in existence of a duly constituted managing committee or in its absence a competent authority authorized in law to oversee the affairs of initiate election process. In the case on hand, it is evident that there is no subsisting or duly constituted committee governing the respondent number 3 society. In such a situation, the law is fairly well settled that the responsibility to set the election process in motion, kindly take next page 268, devolves upon the statutory authority, returning officer, who acts as a neutral facilitator to ensure that the domestic process within the society is to be resolved in accordance with law. In the absence of duly elected committee, any unilateral action, more particularly enrollment of members or preparation of the voter list, cannot be left to an unregulated or interested body. It is the returning officer acting under the supervision of the competent authority who is required to step into the take custody of the records of the society, scrutinize the membership in accordance with the bylaws, and prepare a valid electoral roll. Only upon such preparation of the lawful voters list on next stage of issuing calendar of events, it has been taken. This has not been done at all. Then therefore, this court is of the considered view that the impugned calendar of events, which is founded on a prima facie defective voters base and issued without adherence to the mandate notice period, cannot be sustained to be set aside. Writ petition is wrote, the impugned calendar of events so and so is set aside, quashed. It is declared that in the absence of the duly constituted managing committee, the responsibility to initiate the conduct of the election process rests with the competent returning officer, who shall act independently in accordance with the bylaws and the statutory mandate. The respondent number 4, returning officer, is directed to take custody of all the relevant records of the respondent number 3 society, undertake the scrutiny of the membership, and prepare a fresh list of eligible voters strictly in accordance with the bylaws. While preparing the voter list, the returning officer shall examine the legality and recently enrolled members and include only such members who satisfy the eligibility criteria under the bylaws. Upon finalization of the voter list, the respondent number 4 issue a fresh calendar of events by giving not less than 21 days prior notice, as amended under the bylaws so and so. So my submission is, kindly take the new members have been elected. Kindly take page 281. When there was no duly constituted body at all, 754 members have been included as a voters.
By whom?
By the non-existing committee.
Not by the returning officer.
No. This was challenged by me in an earlier writ petition questioning that there was no existing committee as on that date.
Yes.
There is no question of including these members as a members as voters to the society.
Now directions issued by the coordinate bench have not been complied.
Not been considered at all. All these persons have been included toward the election.
Who do you appear for?
I appear for respondent number 3.
3 for the society.
Society.
Returning officer is the state. What have we done? Have we complied with the orders in 9665 of 26?
After
2 weeks. 2 weeks Allah.
where now the calendar of
Can
events has
start
been
again.
issued, Lord. Where after complying,
Once it has been quashed, another time also it will be quashed. If it's
Nothing
not
has
been-
been done.
quashing, where the records have been called for and inquiry has been conducted. From the year 2019,
Has the enrollment occurred by your management committee or by the returning officer is the only question. Have you enrolled them as a managing committee or as the returning officer enrolled them? If you have enrolled, it has to be set aside. This coordinate bench has already held that. ನೀವೇ ಮಾಡ್ದಂಗಿದ್ದೀರಾ
Nil.
ಅಷ್ಟು ಕೊಯ್ಟ್ ಬದ್ರಿನಾಥ್ ಅಷ್ಟು ಕೊಯ್ಟ್ ಆಗೋಗ್ಬಿಟ್ರೆ ಚಾನ್ಸ್
ಒಂದು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಡ್ತಾರೆ ಎಲೆಕ್ಷನ್ ಆಫೀಸರ್ ಕೈಂಡ್ಲಿ ಸೀಕ್ annexure L page 293.
Access notice for 1, 2 and 4. Shri Badrinath R was filed caveat except notice for respond number 3. I1 of 26 is allowed. And AGA is granted 2 days time to secure instruction, make a submission as to whether the enrollment of how many people?
754.
754 persons between
in the year 2025.
In the year 2025 and 26.
Please, resolution dated 3/10/2025.
Made by the managing committee of respond number 3 or by the returning officer. Relist on 7th August. In calendar of events.
They have calendar of events ಕೇಳಿದ್ವಿ. Annexure
31, 7, 38, 38, 48. ಮತದಾನ ದಿನಾಂಕ 9/8.
ಹೌದು.
It's on 5th August at 2:30 p.m.
Please.
6th August at 2:30 p.m.
Serial number 63, Bipin Hegde.
Yes.
This is the mandamus seeking directions to the respondent police from not interfering to the lawful business of my petitioner, bar interested.
Could it judgment could it? And
They have
AG
produced
access
it.
notice for response.
They have produced it.
Produced it?
Please,
Page?
my lord.
Annexure G, my
28.
lord.
28. The list in the above matter has already been dealt with by a coordinate bench of this court, while it's ordered dated 23rd November 2018 in WP number 48795 and other connected matters. In that view of the matter, this court passes the following order. The respondents the petitioners and respondent shall comply with the direction issued by the coordinate bench in para 15 and 16 of the said order.
Please.
64,
Grateful, madam.
Gaurav Ganapati.
Yes.
My lord, aggrieved by a blanket freeze on my bank account, a blanket freeze, despite no such intimation being provided by the law enforcement authorities, my lord, the respondent bank has to blanket freeze the entire account.
Bank of Maharashtra.
Divya Purandar.
Ms. Divya Purandar is directed to accept notice for respondent. She is directed to place on record the correspondence, if any, received from any law enforcement authority as regards the freezing of the account of the petitioner. Relist on
My lord,
19 August.
If I may, my lord, Annexure C, page number 16.
Yes.
My lord, this is the letter provided by the bank enumerating the details of the freeze.
Correct.
Received from the law enforcement agencies. The total aggregate of all these amounts is, my lord, is only 1,72,000.
You have produced only this one letter. We'll have to see the orders which have been received.
My lord,
and from
if
whom?
I may, the next page, my lord, if I may.
Yes.
Page number 17, my lord. As mentioned above, due to multiple cybercrime complaints against your account, the transaction monitoring department head office has put debit freeze on your account. It's, my lord, the bank themselves on their own violation have put the debit freeze.
Yes.
My lord, my prayer is, my lord, the disputed amount, my lord, may be kept on
You
hold.
don't want a notice to be issued to them? Every time you keep doing this, and every time we are telling you the same thing.
My lord, the issue is more than 2 months
Until we
has
see
passed.
that, we are not going to pass any orders.
65, Gaurav Subramanian.
Yes.
Matter pertaining to externment, my lord. Externment proceedings, my lord.
Notice has been issued to you?
Notice not issued, my lord.
Page 17, my lord.
My lords, the fact is, my lords, yeah.
Third paragraph.
One sub.
Last but one. ಮೇಲ್ಕಂಡ ಎಲ್ಲ ಅಂಶಗಳ ಆಧರಿಸಿ ಕರ್ನಾಟಕ ಪೊಲೀಸ್ ಅಧಿನಿಯಮ. ಥರ್ಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್.
ಖುದ್ದಾಗಿ ಹಾಜರಾಗಿ ಹೇಳಿಕೆ ನೀಡಂತೆ ಹಾಗೂ ನೋಟಿಸ್ ಅನ್ನು ನೀಡಿ
ವಿಚಾರಣೆ ಹಾಜರಾಗಲು ಪ್ರತಿವಾದಿಗೆ ಕಾರಣ ಕೇಳುವ ನೋಟಿಸ್ ನೀಡಿದ್ದು ಸದರಿ ನೋಟಿಸ್ ಅನ್ನು ಮಂಡಿ ಪೊಲೀಸ್ ಠಾಣೆ ಆರಕ್ಷಕರ ಸಿಬ್ಬಂದಿ
is
ಮೂಲಕ
not appeared.
ಜಾರಿ ಮಾಡಿ.
Not appeared. My lords, issue is on 24/11/25 minutes earlier, old notice was issued, my lords. And 28/11/25, the first out of externment was issued. The same was challenged by the petitioner in criminal RP number 220 of 25.
There is no recording of his appearance. Direct him to
Please.
appear. And AG accepts notice for respondent 1 and 2. Petitioner is before this court seeking for the following reliefs. A perusal of the impugned order dated 14/7/26, though mentions that notice had been issued, the details of service on the petitioner are not forthcoming in the said order. Furthermore, a perusal of the order does not indicate that the petitioner had appeared before the executive magistrate on the given date. That view of the matter, being of the opinion that the principles of natural justice have not been complied with, this court passes the following order. Writ petition allowed, a certiorari is issued. The order dated 14/7/26 at Annexure A is quashed. The petitioner shall appear before the executive magistrate without requirement of any notice at 2:30 PM on 19th August 2026 and make his oral as also written submission on that day. The executive magistrate is directed to consider the said oral and written submission and pass necessary orders within 30 days
Yes.
of such filing by the petitioner.
For petitioner's counsel, Lord. Lord, petitioner is a practicing advocate. Lord, he has been attacked on a midnight, my lord, on 9/7/26. He has lodged a complaint. No action has been taken, my lord. Fair, speedy and transparent investigation is his fundamental right. For a lawyer, my lord, this is happening. Lord, police have not done anything. He is constantly in touch and he is following it up. Nothing has been happened. My lord, they have given one gunman also. But my lord, the matter has to be investigated. Who is the
They've given a
real,
gunman to whom?
the advocate? Now, and ಅಷ್ಟು ಮಾಡಿ ಅವರು ಕೈ ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಮತ್ತೆ ಇನ್ನೇನ್ ಬೇಕು?
ಅಲ್ಲ, that who has done this, my lord, that has to be investigated and there should be
I'll seek instructions.
punished properly.
And AG accepts notice for respondent 1 to 4. She seeks for and is granted a week's time to ascertain and make a submission as regard the status of investigation in crime number 312 of 26 registered by the Kadugodi police station. Released on 11th August.
Please.
Lord, your lordship may have a short date, my lord, because there is a threat also, my lord, and it is
You
for
have
a
a
lawyer,
gunman, what
only
more?
for discharging his professional duty, my lord, he has been targeted.
You have a
And
gunman.
there is a background to this case, my lord, where in a case, my lord, the parties approached for compromise, he did not yield. That is after, my lord, thereafter this has happened. Therefore, my lord, short date may be
Let
given.
us get 1 week is short enough.
Your lordship may have it in the same status, my lord, fresh
Preliminary.
matter.
Yes. Preliminary.
67.
Parole. And AGA for respondent released on 5th August.
68.
And for the petitioner in this case, my lords, FIR was registered before the respondent number 2,
Mumbai police.
police from Mumbai, my lords. My account has been frozen.
Frozen.
Please.
And AGA
Petitioner
for
is a company, my
respondent number
lords.
1, notice to respondent number 2 is deferred for now. Shri TP Mutanna is directed to accept notice for respondent number 3. Petitioner is directed to appear before the Cyber Command
Please.
on 6th August, released on 13th August.
My lords, my interim prayer may be considered. my
We can't grant you, we don't know what has happened in this. Until we see those orders of freezing,
FIR itself says 15 lakhs is the disputed amount.
you have produced only one. Most of the times one is produced, then in the other one matter, we had 198
Please.
complaints.
Please.
Serial number 69. General payroll.
And AGA for respond 5th August.
70. Gautamar.
My lords, I'm seeking to set aside certain garnishee orders which are at annexures F, G, and H.
Garnishee orders.
Garnishee orders issued to the banks,
I see.
issued to the banks as against me
Geeta Devi
for
Papanna for respond number 1 and 2. TP Muttanna for respond number 3, 4 and 5. Counsel for the petitioner to serve 2 sets of the petition along with annexes on the said counsels relist on 14th August.
71.
my lords, insofar as the interim order is concerned, what is
Yes. ಹೇಳಿ ಹೇಳಿ ನೀವು ಕಾಯ್ಬೇಡಿ.
My lord, this matter for premature release, my lord. Board recommendment.
AGA for respondent
My
relist
lord,
on
it's
5th
recommended,
August.
my lord. At page number 18,
Recommended,
it's recommended.
Yes.
At page number 18, I have annexed it, my lord.
Board has
The
recommended.
Advisory board.
Page number 18.
Yes, my lord. Custody certificate at page number 17. Clearly indicates that more than 14 years. And 22/6/2026, board has recommended.
Where is the recommendation of the board?
At page number 18.
18.
18, last paragraph. On 22/6/2026.
22. This is dated 14/7. Board has recommended same order as in page 20. AGA for respond number 1 to 4.
Obliged.
Chapter for petition, my lord. I have filed application under section 2 of the Forest Conservation Act 1980, my lord. That application is not considered by the CEC. In similar matter, my lord, it is honorable court directed to consider the application.
These expired in 2008, my lord.
Annexure D is the application filed 2026.
This recommendation will have to come from the empowered committee. And AGA for respond number 1 and 2. Shanti, anybody from central government? Shanti Bhushan and DSGI for respond number 3. Counsel for the petition to furnish 2 sets of the petition along with annexes on the said councils relist on 19th August.
Much.
73.
Please, my lords. One indulgence, my lords. Serial number 68, my lords. FIR is registered for 420, my lords, not cyber crime.
It can be for anything.
Please, please.
As long as they say
Please, my lords.
instruction.
Please.
73.
For the petitioner, Your Honor.
Yes.
Your Honor, seeking for the writ of mandamus, Your Honor, to consider the representation and to release the contractual amount of rupees 1 crore 10 lakhs. Your Honor, I had participated in a tender. Thereafter, a work order has been issued by the authority. And thereafter, a completion certificate at annexure J, Your Honor, page number 90. They have issued the completion certificate, Honor.
Yes, you are election commission.
Or Vaishali.
List.
Your Honor.
That's it. Yes, that word. And AGA for respond number 1 and 2, Ms. Vaishali Agde for respond number 3, SR Dodwad for respond number 4. The petitioner, being a micro, small, medium enterprise, had been awarded a work order by respond number 3, in person of which the petitioner claims that the petitioner has completed the works and raised its bills, which when not paid, the petitioner had submitted a representation on 10/7/26 at annexure P series, which is also not been considered and acted upon. Whenever any representation is paid, so and so. Mandamus 27/3/24 within 30 days from the date of receipt of a copy of this order. It's not made clear that this code is not.
Much obliged.
74. Veeraya Hiramat.
Mr. Hiramat? Odbedi.
74, I'm for the petitioner in this matter, my lords.
74.
74.
But why is he running?
For the petitioner in this matter, it's a writ of man.
Certiorari Rai, there's no interim order.
Sorry, my lords.
Yaudappa?
I'm challenging.
Veeraya Hiramat.
Please, my lords.
Heli.
Annexure C, my lords. The annexure C is passed by, order passed by them, lord.
What is annexure C?
Annexure C.
Page number?
Page number 14, my lords. The rowdy sheet notes. Order passed by the respond number 3, my lords.
And AGA accepts notice for respond number 125. Seeks for and is granted 10 days time to obtain instruction, make his submission. Released on 25th August. Please.
75, Girish sir.
Emergency payroll mail.
In emergency,
A convicted mother is suffering from a cardiac cancer mail. Annexure C, page number 27 mail.
Cancer.
He's convicted 138 case mail. Case.
You've been there only for 2 months, 10 days.
He is convicted 138 matter mail. NI Act.
Yes. You've been convicted for 1 year.
Yes, my lord.
You're there only for 2 months.
My lord, 138 matter my check.
Have you paid the fine?
He is suffering.
Land AGA accepts notice for respond number 123. He is directed to secure instruction, make his submission on the veracity of the medical certificate produced at, she is directed at Annexure C, released on 19th August.
5th, my lord, emergency. I will produce subsequent documents, my lord.
Parole all 5th, my lord. Parole 5th.
5th.
1 crore is this one, you are not paid. You have been there only for 2 months. Let, you
But
get
he has
the-
to arrange his money, my lord. But the Thai hospitalized agidare. She's in hospital only, so there further documents could have.
Let them verify the authenticity of that medical certificate. 1 week ಬೇಕಾಗತ್ತೆ. You don't go to a government hospital. You don't go to a board. You go to a private hospital and get
Hospital
it.
entire document I will submit. I submit ಮಾಡ್ತೀನಿ, so original
Let them
document.
verify. Next.
76, Suraj Kulkarni.
I'm for the petition.
Yes.
That in this case petitioner is challenging compromise decree
Before the
entered
Lok
into
Adalat.
between the plenty fund, the defendant number 2. There are 13 defendants, my lord. Ignoring the remaining persons, court has passed a decree. I have filed application to reject compromise petition, but the court has keeping it pending. IA number 11 filed under order 23 rule 3 without considering our objection has passed compromise
It was
decree.
before the Lok Adalat or where was it?
No, my lord. Regular court.
Regular court ನಮ್ಮ ಮುಂದೆ ಹೆಂಗ್ ಬರತ್ತಪ್ಪ? Only Lok Adalat will come as a writ petition.
Yes, my lord.
This you will have to, not
Yes.
before us.
We have categorized it as GMCPC. But
Then counsel for the petitioner submit that the above petition had been filed as GMCPC, registry to verify and post before the appropriate bench.
that till then,
We have no jurisdiction on this.
77, Dinesh Raj.
Yes.
Lords, I am seeking a direction, Lords, for issuance of a work order for construction, Lords, of floating cages in the KRS Dam, Lords. Lords, what has happened,
On what
Lords?
basis do you get mandamus to issue work orders?
Lords, I am seeking a positive direction, Lords, because if your Lordship were to pass an order just to consider my representation, they won't do it, Lords, and again I'll end up in the contempt court. Lords, seeking a positive direction to consider my representation and issue me, Lords, a work order.
What basis are you seeking for
Lords,
this?
your Lordship may see annexure B, Lords, at page 25.
25.
Lords,
Yes.
under the DLC committee, Lords, I have been included as a beneficiary, 3 of us. Thereafter, Lords, a representation is issued, Lords, seeking for issuance of a work order. There are 3 individuals, Lords, who have applied for this. One, Lords, by name Madhu Nayak. Lords, he has been granted a work order subsequent to the issuance of the representation. Now, Lords, I have filed the same exact representation. It's not considered, and they have taken, Lords, the deposit fees of about 40,000.
Yes, Shama.
Lord, I'm told that this representation is already considered.
And what
Just
have you
paste
done?
it. We've rejected it. I'll have to get more instructions on this, but I'm told, my lord, it's already considered.
You received the instruction in
I've
writing?
received it on WhatsApp, my lord. I'll have to just go through it. It's been
And
rejected. in
AGA
some-
accepts notice for respond number 125. He seeks for and is granted a week's time to ascertain and make a submission as regard the status of the representation of the petitioner dated 2/6/26 at Annexure D, released on 11th August.
Seventy-eight, Ketan A.
Lord, I appear for the petitioner in this case, my lord.
Yes. Yes.
For the petitioner in this case, my serial number 78, my lord.
Yes. Yes, go ahead.
Seek a week's adjournment, my lord.
Yes, go ahead.
Seek a week adjournment, my lord, in this case.
And counsel for the petitioner seeks for and is granted a week's accommodation, released on 27th August.
Grateful.
Kiran?
Let's stand for the petitioner in this matter. It's a writ of mandamus, my lords, wherein my representations weren't being considered. So it is a matter of dowry death, my lords, wherein police have not investigated the matter properly, in spite of giving suitable representation before the Vartur police station and also the police station before the Assistant Commissioner of Bangalore.
Dowry death.
Dowry death, my lords. It is within the 7 years of marriage that has happened, my lords.
And AGA accepts notice for
This
respondent number.
unnatural death has been registered initially, my lord. I'll just take the status whether they have converted it into FIR.
And AGA accepts notice for respondent number 1 to 4. Notice to respondent number 5 to 8 is deferred for now. And AGA seeks for and is granted a week's time to ascertain and make a submission as regard the status of the complaint lodged by the petitioner, released on 11th August.
Grateful, my lords.
80, Abhinav Ramanan.
Yes, Abhinav?
Lord, the tender, my lord, at Annexure V in relation to underpasses, my lord, issued by the Greater Bangalore is challenged. Lord, there is a dispute pending between me and the Greater Bangalore Authority. Injunction is granted, my lord, at page number 85. Now,
what is the dispute between you and?
The dispute is, my lord, they prevented me from showing the underpasses and maintaining it. And therefore, I'm entitled to extension of the, my lord, contract period. There is an order that is granted by the court. Matter was before this court. This court said it is a civil dispute. Please go to the civil court until it is decided that you will maintain the underpasses. Now there is an interim order, my lord. Despite there being an interim order, now, my lord, Annexure V.
Annexure?
V, my lord, is the page 89, my lord.
What is the suit you have filed for?
Suit is filed for, my lord, a declaration that I am entitled. Please turn to, my lord, injunction, my lord.
The plaint?
Sorry, my lord.
Where is the plaint?
Plaint is not produced, my lord.
What is the relief you have sought for?
Injunction, my lord. The page 82, my lord. My lords will see the
That
prayer,
is
my lord.
injunction, how is it maintainable, Abhinav?
Lord, I am entitled to, my lord, extension in the agreement.
Have you sought for extension in the
Yes, my
suit?
lord. Yes, my lord.
Where is the plaint?
I'll produce the plaint, my lord.
And AGA accepts notice for respondent number 1. Shri Pawan Kumar is directed to accept notice for respondent number 2 and 3. Counsel for the petitioner seeks for and is granted 3 days time to place the plaint.
Yes.
In OS number?
In OS number?
236 of 26.
Yes.
On record. Released on 7th August.
81,
Lord, may I request it to be listed in fresh matter 6.
Preliminary hearing.
Yes, great.
Yes, Mr. Manian. Yes.
My lord, we are covered by a judgment. This is a section 25 notice issued by the registrar on a complaint by 2 unsuccessful candidates in recently held elections. Elections are held once in 2 years. The elections were held on 7th of June 2026. A month later, 2 unsuccessful candidates petitioned the registrar for an inquiry under section 25. And notice is issued. An inquiry is commenced. My lord, we are covered by a judgment that matters pertaining to election do not come within the purview of the registrar's inquiry under section 26. Supreme Court has also upheld the judgment.
Page number or where is the copy?
The judgment is this one. Yes.
Para?
My lord, may come to page 14. The second paragraph in 14. the full bench clearly holds, my lord has it, that the registrar cannot hold an inquiry. This is the Madras High Court, section 36 is pari materia 25. The full bench clearly holds that the registrar cannot hold an inquiry under section 36 of the Act, therein to consider a petition which is akin to challenging the elections. The court holds that the power of the registrar therein cannot be stretched to annulling an election or giving a direction to hold fresh elections, as the registrar therein had directed conduct of fresh election, which would amount to directly setting aside the earlier election. Para 2. In more or less similar matters, this court has taken the view, as rightly contended by the learned HCGP appearing for the registrar, that in matters of this nature, involving disputes to the validity of election to a society which does not answer the description of other authorities under Article 12 of the Constitution of India, have to be worked out elsewhere, arguably before the civil court. This court is in complete agreement with the submission of the learned HCGP and therefore declines indulgence. You kindly see para 13 below that. On a coalesce of the judgments rendered by the full bench of the High Court of Madras, the apex court later affirming the judgment of the full bench and the judgment of the coordinate bench, what would unmistakably emerge is that the district registrar cannot assume the power of a civil court to consider the importance of evidence in election matters in the garb of conducting inquiry under section 25 of the Act. Conduct of elections or declaration of elected candidates or a direction seeking holding of fresh election will have to be before the competent civil court. Therefore, my lord, completely misplaced. There are allegations of malafide we want to urge at this stage.
Where is the notice?
My lord, we see the notices at Annexure A at page 16. At page 17 is the order.
It's the election dispute, yes. Now, AG accepts notice for respond number 1 and 2. Considering the order dated 27th March 24, passed by coordinate bench in WP number 19244 of 2022, which in turn relied upon the full bench decision of the Honorable Madras High Court in civil appeal number 59. No, that is 5989 is apex court. Full bench is in 2005, 2 CTC 161, affirmed by the Honorable Apex Court in civil appeal number 5989-5991 of 2009, dated 23/2012, wherein it's been categorically held that a registrar cannot hold an inquiry into election dispute. The operation of Annexure A is stayed till the next date of hearing. Released on 8th September.
Grateful.
82. Shirish Krishna.
Mr. Shirish Krishna.
I appear for the petitioner. Lord, this is a petitioner is a society. Petitioner has challenged the report given under section 25, recommending appointment of an administrator.
Yes.
On the ground that you have not conducted election, you have conducted election belatedly. Election is already conducted. Election is held on 10/11/2025. Notwithstanding the conduct of the election, he recommends that administrator should be appointed because there is a delay in conducting of the election. That is not permissible, my lord. Kindly see page 71, the recommendation.
Yes.
ಒಟ್ಟಾರೆಯಾಗಿ ಸಂಘದ ಉಪನಿಯಮದಂತೆ ಚುನಾವಣೆ ಹಾಗೂ ವಾರ್ಷಿಕ ಮಹಾಸಭೆಯನ್ನು ನಿಗದಿತ ಸಮಯದಲ್ಲಿ ನಡೆಸಲು ವಿಫಲರಾಗಿರುವುದರಿಂದ ಆಯಾ ಸಾಲುಗಳ ವಾರ್ಷಿಕ ದಾಖಲಾತಿ ಲೆಕ್ಕಪತ್ರಗಳನ್ನು ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಸಲ್ಲಿಸದಿರುವುದರಿಂದ ಕರ್ನಾಟಕ ನೋಂದಣಿ ಕಾಯ್ದೆ ವಿರುದ್ಧವಾಗಿ ನಿವೇಶನ ವಿತರಿಸುವ ಚಟುವಟಿಕೆಗಳಲ್ಲಿ ತೊಡಗಿರುವ ಕಾರಣ ಸದರಿ ಸಂಕಲ್ಪ ವೆಲ್ಫೇರ್ ಸೊಸೈಟಿ ಸಂಘವು ನೋಂದಣಿಯಾದ ದಿನಾಂಕದಿಂದ ಸಂಘದ ಉಪನಿಯಮಗಳ ವಿರುದ್ಧವಾಗಿ ಸೋನ್ಸೋ ಉಲ್ಲಂಘನೆ ಮಾಡಿರುತ್ತದೆ. He says that the society cannot deal with allot sites to its members. There is no basis for such a conclusion, and the election is already held, my lord. That also he notes it at page 65. Election is already held, accounts are submitted, only there was delay in submission of the accounts. Kindly see, my lord, at page 65, ವಿಚಾರಣಾಧಿಕಾರಿಗಳ ಅಭಿಪ್ರಾಯ. At page 65, my lord, your lordship got it? Page 65 makes a note, my lord, that election is already held. Lord, page 65. Page 65.
65.
ವಿಚಾರಣಾಧಿಕಾರಿಗಳ ಅಭಿಪ್ರಾಯ. ಸಂಘವು ರೂಪಿಸಿಕೊಂಡಿರುವ ನಿಯಮ ಮತ್ತು ನಿಬಂಧನೆಗಳ ಸಂಖ್ಯೆ 5ರ ರೀತ್ಯ ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿಯಲ್ಲಿ ಅಧ್ಯಕ್ಷರು, ಉಪಾಧ್ಯಕ್ಷರು, ಕಾರ್ಯದರ್ಶಿ ಹುದ್ದೆ, ನಿರ್ದೇಶಕರು ಹುದ್ದೆ, ಹೀಗೆ ಆಡಳಿತ ಮಂಡಳಿಯಲ್ಲಿ 8 ಹುದ್ದೆಗಳು ಇರುತ್ತದೆ. ಇವುಗಳನ್ನು ಚುನಾವಣೆ ಮೂಲಕವಾಗಿ ಆಯ್ಕೆಯಾಗಿರುತ್ತದೆ. ದಾಖಲೆಗಳ ರೀತ್ಯ ಸಂಘ ನೋಂದಣಿಯಾದ ಸಂದರ್ಭದಲ್ಲಿ 12/3/18ರಂದು ಸಂಘದ ಪದಾಧಿಕಾರಿಗಳ ಆಯ್ಕೆ ಮಾಡಿಕೊಳ್ಳಲಾಗಿದೆ. ನಂತರ ದಿನಾಂಕ 10/11/25ರಂದು 7 ವರ್ಷಗಳ ನಂತರ ಚುನಾವಣೆ ನಡೆಸಿರುವುದಾಗಿ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. He also makes a note that election
2018 to 25 there was no elections.
There was no election, but that cannot be a ground, my lord. What administrator can only conduct election only. Now election is conducted. Kindly see section 27A.
Not by the same body which we did not do it for 7 years, Mr. Arnoldi.
No, my lord,
27(1)
no.
A1A is clear on that.
And this entire initiation of the proceedings itself is contrary to law. He initiates, my lord, some complaints are filed by a non-member. And that non-member, my lord, he initiates suo motu proceedings without there being any application of mind. Under the Bangalore grain merchants case, the
But
court
it's
has held
admitted
that
fact that you did not have the election from 18 to 25.
no
That's
doubt, my
admitted.
lord. Once the election is held, he cannot once again say, I will conduct election once again. He has accepted the accounts. Election is submitted. Kindly see, my lord, section 27A. It is only where
Yes,
election is not held. A case, my lord, as the previous case also, he cannot go into the validity of the election. Kindly see section 27A.
Yes.
Notwithstanding anything in this act, where any society on account of pendency of litigation or otherwise has not held or is unable to hold the annual general meeting, or where the term of office of the members of the governing body of a society has expired and a new governing body has not for any reason been constituted, or where on a report made by the registrar or otherwise on inquiry state government considers necessary in public interest so to do. There is no recommendation that in public interest it should be done. The only ground on which he recommends appointment of administrator is that you have not held the election.
Yes.
Now, once election is held, my lord, and accounts are submitted, you lordship may also see the order passed by him, my lord, on taking suo motu proceedings. May I just point out the relevant portion, my lord, at page 219.
219.
Yes.
Yes.
But there he refers to the complaint given by certain members. We filed objection saying that they are not even members of the society. At page 222, what is written in Kannada? ಸದರಿ ವಿಷಯದ ಬಗ್ಗೆ ವಿಚಾರಣೆಯನ್ನು ನಡೆಸುವಂತೆ ಅರ್ಜಿದಾರರು ಹಾಗೂ ಎದುರುದಾರರು ಸಲ್ಲಿಸಿರುವ ಮಾಹಿತಿ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿದ್ದು ಸಂಕಲ್ಪ ವೆಲ್ಫೇರ್ ಸೊಸೈಟಿ
Where are you reading?
Page 222, my lord.
222. Yes.
ಅದರಲ್ಲಿ that English, what is written in English is our objection. After that, ಕನ್ನಡದಲ್ಲಿ ಬರೆದಿರೋದು ಮೇಲಿನ ಕಾರಣಗಳಿಗಾಗಿ ದೂರು ಅರ್ಜಿಯನ್ನು ವಜಾಗೊಳಿಸುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. ಸದರಿ ವಿಷಯದ ಬಗ್ಗೆ ವಿಚಾರಣೆಯನ್ನು ನಡೆಸುವಂತೆ ಅರ್ಜಿದಾರರು ಮತ್ತು ಎದುರುದಾರರು ಸಲ್ಲಿಸಿರುವ ಮಾಹಿತಿ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿದ್ದು, ಸಂಕಲ್ಪ ವೆಲ್ಫೇರ್ ಸೊಸೈಟಿ ಮೈಸೂರು ಈ ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿ ವಿರುದ್ಧ ಆರೋಪಗಳು ಮೇಲ್ನೋಟಕ್ಕೆ ಸಾಬೀತಾಗಿರುವುದರಿಂದ ಕರ್ನಾಟಕ ಸಂಘಗಳ ನೋಂದಣಿ ಕಾಯ್ದೆ ಕಲಂ 25 ಅಡಿ ಕೆಳಕಂಡ ಆರೋಪಗಳನ್ವಯ ಸ್ವಯಂ ಪ್ರೇರಿತ ವಿಚಾರಣೆ ನಡೆಸಲು ತೀರ್ಮಾನಿಸಿ ಕೆಳಕಂಡ ಆರೋಪ ಪಟ್ಟಿ ಹೊರಡಿಸಿದೆ. He does not even give an one-line reasoning as to how it is established. This is directly contrary to the full bench decision of Bangalore Grain Merchants case, where they say that if he decides to take sumo to proceeding, he will add there should be active application of mind. This is what it says, my lord. Concerned authority has to come to the conclusion on an active application of mind whether to take up the inquiry or not. Once the complaint is given by a person who are not even members of the society, he should have applied his mind whether to initiate the inquiry or not. And that too, my lord,
Admitted fact is from 2018 till 25, there was no elections.
No, there is no, that is not disputed. But the question is, once election is held, accounts are given and
That
accounts are
we'll
accepted.
see what is to be done about that, but we're not inclined to grant you any interim relief on that.
But let them
When
not appoint the
anybody,
administrator.
as soon as there is launched, one election will be conducted, that will not absolve the liability for 7 years.
Blood, once they, if they appoint the administrator, the case itself, blood, will become infructuous. Let them not precipitate at least, blood.
That will absolve them certainly.
Because our administrator appoint ಮಾಡ್ಬಿಟ್ರೆ in case ವಜಾದಾಗ ಆಗ್ಬಿಡುತ್ತೆ.
He will hold a fresh election properly.
ಅಲ್ಲ, election is improper ಅಂತ ಹೇಳಿಲ್ಲ ಅವರು. What is, if he holds, blood, that election has not been conducted properly, that's a different issue. The only
Who are
reason
you to
given
have
is
held the
you have not
election when
conducted.
you are not even the elected body in 2025?
No, but the fact is,
we are not inclined to grant any interim relief. Learned AGA for respond number 1 and 2. You have made the
Appointed
inquiry
that-
officer in the as a person.
No, he has not given any.
You'll accept notice for the
If I argue further, I'll get disconnected.
Learned AGA accepts notice for respond number 1 to 3. Released on 19th August.
Let them not appoint, blood.
By that time, if you can think about it, we'll direct them to hold elections in a proper manner within a time bound.
But nobody has complained about the election, blood. That is the issue. There is no complaint.
Not even an elected authority. What did that mean? Where is he? Getting disconnected.
Next case
Next third. Okay,
83.
Lordship, kindly permit virtual appearance for respondent number 6, my lordship.
I appear for respondent number 3 to 5.
Yes, Mujasim.
Transferred into NPI account, my lord. After that, the down payment also with the respondent 7, and now the respondent number 3 has taken proceedings against me, my lordship. So they have got fault, my lord. Kindly see page number 26, my lord, annexed. The bank employee clearly admits, my lordship, they have done a mistake.
Page?
Page number 26.
26. Yes.
Lord, down the middle of the page, my lord, yes, sir. This is to inform you that the loan disbursement wrongly linked to another accounts of measures profile in respondent number 7. Instead of transferring to Bank of India, transferred to Canara Bank account for 3 vehicles, plus fund of 46,000 per vehicle, 48 lakhs. We have visited the MD Road Canara Bank BPM. On 21st December 24. He has confirmed amount will be refunded, and also visited today met one more person policy. We are confirmed within 3 days we get the refund. We are confirming once we receive the funds, refund from Canara Bank, we will transfer the fund to actual account of Kalpanya. And if you want to cancel the loan, we cancel the same without any cancellation charge. And interest for the same. We are very happy to hear you from to continue with the loan. Really sorry for the error funds transfer. Clearly admits my lordship. And now after that, my lord, they have initiated proceedings against my for the NPA.
You did not continue with the loan.
We were waiting for the amount to come back, my lord. So Canara Bank did not return the money, and Kotak Bank did not pursue them. So these two people between two banks, I did not get the money, and the vehicles also did not get the school vehicles.
Who appears for Canara Bank?
Lordship, kindly permit virtual appearance.
Yes, Mr. Kelkar, you appear for Canara Bank.
Right, my lordship.
Yes.
Please.
What did you do with the money? It is still with you or?
Lordship, this respondent number 7 is a NPA customer with the bank who is having liability to the tune of 33 crores, my lordship. This amount of around 49 lakhs has been received for the customer, which has been appropriated to the loan account. And regarding this, they have raised an ombudsman dispute, which is part of the page number 18 to 20 of the petition, my lordship, wherein the transaction has been narrated. My lordship may kindly take the lordship's attention to page number 19, para 2, my lordship, there of the petition.
Yes.
In that, my lord, your complaint was taken up. This is the petitioner's complaint to the RBI ombudsman, my lordship. Complaint was taken up with the RE, Kotak Mahindra Bank and Canara Bank. In the matter of the complaint, Kotak Mahindra Bank submitted that they had transferred funds based on the Canara Bank account number provided by you in the signed disbursement request form. Basis the complaint, KMB raised chargeback with beneficiary Canara Bank. The beneficiary bank has adjusted the amount with the NPA account of the beneficiary towards its outstanding liabilities. KMB has submitted, that is Kotak Mahindra Bank, my lordship, has submitted that the legal steps have been initiated in the matter, including filing of OA with the DRT Bangalore. So, my lordship, even Canara Bank has also filed a OA that is numbered as 231 of 2024, which is posted for evidence on 15th September 2026.
Canara Bank has filed OA against the petitioner.
Yes, my lordship.
I'm for responding 3 to 5. I represent
Canara Bank
Kotak.
is you are for Canara Bank, so you would have filed it against Kalp Jain Motor World.
Kalp Jain, respondent number 7, my lordship.
Yes.
Yes, and my lordship may kindly draw the attention to page number 20 of the petition, my lordship, wherein
who appears for Kotak?
I appear for Kotak 3 to 5.
What do you have to say about this email at page 26?
Your Lordship, I have filed my written objections. I would
What
like
do you
to
say?
draw this court's attention towards Annexure R1, which is on page 10 and 11.
Objections, when did you file?
It was filed on 30th. I was instructed to file on 29th. However, there was a one-day delay in filing the written objections. However, copy was served to them on 29th.
Yes, what have you said in this?
Your Lordship, first of all, the amount has not been transferred to a
respond
third
number
party.
6 sama idu. Respond number 5 ಬೇಕು. Respond number 5.
Respond number 3 to
3 to 5 are Kotak Mahindra Bank, my lordship.
Yes, 3 to 5.
Yes.
3 to 5 is Kotak, is it?
Yes, Your Lordship. On page 10,
5 is
11.
Kotak. Just a moment. 3 to 5 the objections. When did you file it?
It was filed on 30th. 30th of this month, previous month.
That counsel for respondent number 3 to 5 submit that she has filed her objections on 30th of
30th,
July.
yes, Your Lordship.
Registry
I was
is
asked to
directed
file on 29th. However, there was a one-day delay.
Registry is directed to put up the same. Relist on.
R6 also filed objections in the counter on 1st of August.
Your objections are there.
Yeah.
Relist 11th
Please,
August.
Please.
24, Vasudeva Naidu.
Grateful, lordship.
Mr. Vasudev Naidu. None appears for the petitioner. Idara. Yes.
This matter, my lords, already, my lords, Sir, Chandrachud appears, my lords, are responding.
Yes, Mr. Naidu. We can't hear you. What is the problem?
My lord.
Yes, we can hear you, Mr. Chandrachud, but we can't hear Mr. Naidu.
There was a technical problem from the court end, my lord. We were only allowed now. We were all put on passive mode.
Now you are trying to be active. Yes, Mr. Naidu, you have to be active. We can't hear you.
My lords,
We can hear you now.
today it was started dictating, my lordships, but due to lack of time, that
My lord, if your lordship recollects a similar matter in WP number 37832 of 2025, your lordship has disposed it on 7/7/2026, wherein 2 years debarment, your lordship have cancelled that, and in the midst of
termination and
termination, your lordship have upheld the termination, but debarment for participating in further tenders, your lordship have. If your lordship a similar matter.
8/7, that is 1 month ago.
7/7, my lord. 7/7/2026. WP number 37832 of 2026. Connected, same tender.
WP number
37832 of 2025.
ಅದು WP 37832 order copy ತಗೊಂಡು ಇದರಲ್ಲಿ released on 7th August.
But one submission, name of its Rajshekhar may be deleted from the copy.
The Chandrachud has appeared for respond number 2. Registry is that delete the name of Sri S. Rajshekhar as that appearing for respond number 2.
Great.
85.
For the petitioner, my first prayer has become infructuous. The petitioner is a company empaneled with the respondent number 2, wherein the petitioners provides the agricultural machines to the farmers, wherein the complaint came to be filed against me stating that instead of providing 100 meters hose pipe, I have provided 50 meters hose pipe. Now, after the complaints, the respondents authorities
Not been ordered as it. And AGA accepts notice for respond number 1 to 4. Who is respond number 5?
No, it's the complainant, my lord.
Issue notice to respond number 5. Written up by
The petition may be disposed of, my lord. The authorities have compounded the offense against me by levying penalty. Now, the only issue pending before lordship is
filing now. What are you filing now?
A memo, the order compounding the offense against me. The authorities have conducted an inquiry and have levied penalty, my lord.
So, what about your prayer 2?
Prayer 2 is the only consideration your lordship has to be made. Your lordship may direct the respondents to empanel the.
They have to get instructions on that. That is why we have to issue notice. And AG accepts notice to respond number 1 to 4. Issue notice to respond number 5. Written up by 8th September. Submission of learned counsel for the petitioner is that the first prayer has been rendered infructuous.
My
His
memo
submission is placed on record. Learned AGA to secure instructions as regards the second prayer by the next date.
In fact, I have sent a mail and I have also paid the challan.
They'll get instructions.
86.
The memo may be taken on record.
Counsel for the petitioner has filed a memo. The same is taken on record.
40. 86.
Great.
My lord, on the last date, my lord had directed me to any material to demonstrate that I was running a homestay.
Is that homestay?
Demonstrate that it is my residence. I renovated my residence.
Served a copy on them?
Yes, my lord. I already served the chat. My lord, I have produced photographs which would demonstrate my old house. I have submitted an affidavit along with that. Which I renovated my old house. Lord, plan sanctions. The panchayat has not approved a plan as such, but I've set out a plan which demonstrates my residence.
Where is the plan sanction?
My lord, page number 6, my lord, annexed to W. That is not a sanctioned plan, I must confess, my lord, because there, when I had obtained an approval from the MUDA, thereafter I have constructed this renovate. The main house, my lord, will notice that is my residence. Page 6, my lord, annexed to W, may I, my lord, that is my residence. And the two other blocks, annexed to my residence are being used. In total, there are, as of now, I've set up 5 rooms. I've also set out a Google Maps, the image showing my estate as well as the surrounding cottages, and photographs. That is page number 8 onwards are photographs of the buildings amidst within my 10-acre piece of land. Photographs of my residence. Page 11 onwards, I've also set out the CCTV cameras which I have operationalized, and those show the police inspecting the premises as well. They had come over, inspected all of the CCTV cameras, inspected my premises.
Yes, where's the policy? You are working on additional policy requirements, is what we had submission was made. This is the policy.
Page
So
74.
have to be decided on that policy.
Page 74. They had a policy for bed and breakfast. That is separate. For homestays, the 74 is the policy that is set in place. My lord, I had drawn my lord's attention to that particular, the flow chart of how the approval is also taken, page 82.
Yes.
So, my lord, my primary contention here is that the 2 impugned orders are issued by one by the panchayat and one by the local police, that is the SP. My lord will see in the flow chart, I have submitted the application for verification to the ADTD. Thereafter, there is a site inspection and report. My lord will see the middle 2 boxes, that is the representative of the SP is obligated to do 2 aspects, that is criminal antecedents at the police station and presence of functional CCTVs. Both have been completed, and I have produced the photographs wherein they've come and inspected my premises and the CCTV cameras.
Yes.
But now number 2, the other part is representative of the CEO ZP, and he's to examine whether the khata number, my khata and my property ID are within the ULB. Both of these are completed. I have satisfied them. Instead, they issue annexures H and L completely beyond their page. Annexure H is at page 48. May I read, my lord?
Yes.
I'll read paragraph 2. ಈ ಬಗ್ಗೆ ಪೊಲೀಸ್ ಇಲಾಖೆಯಿಂದ ಪರಿಶೀಲನೆಯನ್ನು ಕೈಗೊಂಡ ಸಂದರ್ಭದಲ್ಲಿ ಈ ಅರ್ಜಿದಾರರು ಶ್ರೀ ಸಿ.ಎ. ನಂಜಪ್ಪ ಸೋ ಅಂಡ್ ಸೋ ರವರು ಹೋಮ್ ಸ್ಟೇ ನಡೆಸಲು ಸೂಕ್ತ ದಾಖಲಾತಿಗಳನ್ನು ಹಾಜರುಪಡಿಸದೇ ಇರುವುದರಿಂದ ಮತ್ತು ಇವರು ಹೋಮ್ ಸ್ಟೇ ನಡೆಸಲು ಗ್ರಾಮದಲ್ಲಿ ಗ್ರಾಮಸ್ಥರ ವಿರೋಧವಿರುವುದರಿಂದ ಹಾಗೂ ಈ ಸಂಬಂಧ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ರವರು ಹೋಮ್ ಸ್ಟೇ ನಿರಾಕ್ಷೇಪಣೆ ಪತ್ರವನ್ನು ನೀಡಿರುವುದಿಲ್ಲ ಹಾಗೂ ಅರ್ಜಿದಾರರು ಕುಟ್ಟ ಗ್ರಾಮದಲ್ಲಿ ಆದ್ದರಿಂದ ಅರ್ಜಿದಾರರು ಹೋಮ್ ಸ್ಟೇ ನಡೆಸಲು ಪೊಲೀಸ್ ಇಲಾಖೆಯಿಂದ ನಿರಾಕ್ಷೇಪಣೆ ಪತ್ರವನ್ನು ಒದಗಿಸುವಂತೆ ಕೋರಿ ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿಯನ್ನು ತಿರಸ್ಕರಿಸಲಾಗಿದೆ. I have produced my residence certificate as well as my Aadhaar to demonstrate that I reside at this very place. I have produced photographs.
You are not residing in Kutta.
No, I reside at this Poradu Grama.
And last time you had shown.
I had shown my lord the residence certificate as well.
Poradu village.
They have issued NOCs to me for conversion, for operating a homestay. The electricity connections have been converted to commercial. Some objections. They don't even give me a copy of what those objections are. And now they've rejected my application solely on those grounds. And the my lord may kindly see annexure L. This is by the panchayat. Kindly see the bare statement that they make. Annexure L, page 52. ಕೊಡಗು ಜಿಲ್ಲೆ ಪೊನ್ನಂಪೇಟೆ ತಾಲೂಕು ಬಿರ್ನಾಣಿ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ಸೇರಿದ ಪೊರಾಡು ಗ್ರಾಮದಲ್ಲಿ ಹೋಮ್ ಸ್ಟೇ ನಡೆಸಲು ಆಕ್ಷೇಪಣೆ ಇದ್ದರೂ ಮತ್ತು ಪೊರಾಡು ಊರು ಪಂಚಾಯಿತಿ ಆಕ್ಷೇಪಣೆ ಇದ್ದರೂ ಸಹ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ಅನುಮೋದನೆ ಪಡೆಯದೆ ಹೋಮ್ ಸ್ಟೇ ಅನ್ನು ನಡೆಸುವ ಬಗ್ಗೆ ಸಾರ್ವಜನಿಕರಿಂದ ದೂರು ಬಂದಿರುತ್ತದೆ. ಈ ಬಗ್ಗೆ ತಾವು ಹೋಮ್ ಸ್ಟೇ ಅನ್ನು ನಿಲ್ಲಿಸಿ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ಮತ್ತು ಸಂಬಂಧಿಸಿದ ಇಲಾಖೆಯಿಂದ ಅನುಮತಿಯನ್ನು ಪಡೆದು ಕಾನೂನಿನಂತೆ ಮುಂದುವರಿಯುವಂತೆ ಈ ಮೂಲಕ ತಿಳಿಸಿದೆ.
This is by Gram Panchayati. Yes, Mr. Chappa, you are appearing for the Gram Panchayat. You are appearing. Yes.
The verification if the petitioner is residing in that place is one that I will have to clarify. Second, if you have to see the photographs now produced, then
distinct cottages and not one unit as a house.
That is why we asked you, is there any guidelines for that? Is it to be part of the house? Do you need to get, and do they need to get no objection from the villagers or neighbors? If nothing is there. In the policy that has been placed before us, it's not there. So if this is the policy, we'll have to act only in terms of that policy.
Reading the definition, it sounds like that it should be one unit out of which one bedroom to a maximum of 6 can be given.
No, that
Now,
it is.
cannot be different.
Where does it say that?
No, as a matter of fact, the other side, serial number 4 says it can have separate rooms, separate buildings.
It doesn't
Page
say anything
86.
of that kind. You'll have to go by only this policy which is there. As per this policy, there's no requirement of no objection. It doesn't say that it has to be a single building.
That clear definition is not there.
Then
It doesn't have to say whether it is supposed to be a part of the same building or can it be different cottages or rooms separately built.
at the most we could take judicial notice if some building is built with 20 rooms or something. It's 2 rooms like this.
No, it says.
Only giving privacy for the people who are going to reside there. Stay there, reside under. These grounds are not applicable.
Anyway, I'll place my objections.
Indian objections,
In
Appa.
the light of the document now submitted, I will
My lord had already directed my lord to it, otherwise it will not be, it will taken as not filed. And
my lord, as of now, from what I read, the definition, it does not meet to the definition of the definition clause is one that I can place on record. The second is these are individual cottages built which qualifies for a resort and not a homestay, right? Second line of submission. The resort would be a complete different operation altogether than a homestay because the units built in different parts.
Two rooms will constitute a resort.
If it is not within the house, within the home that they stay.
Where do you draw that?
my lord, page 86, if that is his objection, page 86, my lord,
Where
serial
do
number
you
4.
where do you get this definition, or where do you get your definition? Where do you get that? Definitions are there. Yes.
Private owned residence, including a residence in a farm, plantation, where the owner or any of their immediate family, spouse, children is physically residing in the same residence. So thereby, when the word same is there, my lords, it means to say or connotes to bring in the ambit of staying, it should be within the parameter of that particular building and no further words. In the same building, residence, and letting out minimum 1 room, 2 beds, and maximum 6 rooms, 12 beds, where any tourist can stay on payment for boarding and lodging, and such a residence is recognized as a homestay by the Department of Tourism, Government of Karnataka. Homestay is a non-commercial activity. The same residence is what qualifies my argument.
My lord, page 86, if my lord may kindly read. Serial number 4, which specifically defines this. Page 86, serial number 4, my lord.
Yes.
The rooms may read, my lord, clause number 5, guidelines. 4, the rooms in a homestay may be a part of the residence in which the owner or their spouse or children is staying, or in a separate building or cottage that is part of the same plot of land that is the same survey number. That is why I produced the Google Maps footage.
Request only that a sign may be given, I will place the objections.
My lord, it was fixed for today, saying that if they don't file their objections, it will be taken as not filed. They don't allow me to opt
for the petitioner by relying on subclause 4 of guideline number 5. Submit that the rooms in a homestay may be a part of the residence in which the owner bracket or their spouse or children bracket close is staying, or in a separate building stroke cottage that is part of the same plot of land that is same survey number. His submission is that the homestay of the petitioner qualifies that requirement. It also qualifies the requirement of clause 1 of guideline 2, which defines homestay in as much as the maximum number of rooms that could be made available in a homestay being 6 with 12 beds. The petitioner's homestay also has only 6 rooms, 12 beds. And as such, the petitioner's home qualifying for a homestay, the guidelines do not require no objection to be obtained from the villagers or neighbors. And as such, the rejection of the request made by the petitioner on the ground that the neighbors are objecting is not permissible. Sri Ajita Chappa seeks for and is granted 3 days time to obtain instruction, make a submission, relist on 11th August. Not preliminary hearing.
Serial number.
In preliminary hearing.
My lords, one submission. My lords.
2:30.
Second list, serial number 23, my lord. Since there is some urgency, kindly have it tomorrow.
Tomorrow there are 154 matters already listed.
My lords.
So we'll have it tomorrow.
Much
With your lordship's kind.
List 2, my lord, serial number 66 and 60.
Whichever matters you want tomorrow will be listed tomorrow.
63 Monday, my lord. Monday, my lord.
Whichever you want
Passed
day
over.
after will be listed. Day
Your
after.
lordship's kind.
Lord, Monday, my lord.
Passed over matter in list 3.
Will be listed
My
tomorrow.
lord, kindly tomorrow, my lord, tomorrow 2:30. Because my lord, your lordship
My lord,
knows that
Monday.
that is the matter where your lordship heard it.
You want to argue now what mentioning?
My lord, serial number
No,
63,
your
my
lordship
lord.
knows, that is why. my
Yes,
lord.
Mr.
Kindly, 2:30.
Commission matter, lordship had listed it at 4:30 today.
Yes, Mr.
Sir,
Advocate
sir,
General.
court of sir. Court of sir.
Both of you, we have
Court
to
of
ask, so
sir.
we'll ask both of you.
Sir. Sir.
Serial number?
88, my lord.
Ah.
When they sought to
Nandu
challenge
Oh,
Election.
SIR.
List number 2, my lord. First matter, needful.
Like a memo in that. We have kept it in, we have kept it in abeyance. We of the SIR.
Yes.
Served a copy for your lordship.
Learned senior is right. So, my lord, they have also reserved their right to revive this order in case in future. So, my request is.
after-
You also revive your.
Yes, with that, lordship.
Just pass on the.
58.
Including, my lord, whether repetition is maintainable, all question of.
That he can argue in second
Cannot
round.
dispose, you want the matter to be disposed.
No, not.
Otherwise, the
He
memo
can file it,
be
they can
taken
file
up.
it, it can come up after 2 weeks.
88.
Memo can be taken up.
Counsel for respond number, Shri Ken Panindal and senior counsel appearing for respond number 1 has filed a memo. His submission is that the SIR in respect of, separate SIR in respect of the GBA is kept in abeyance pending the SIR for the MP MLA constituencies.
The order dated 23/7.
In view of the Supreme Court order.
And in view of the, yeah, his submissions are.
It's recorded in our order.
In the SIR will be completed when?
Lords, that will be completed by October.
October.
That's why the.
October 2026.
In that view of the matter, relist on 28th September.
Yes.
My lord, serial number.
My lord, list 2.
Serial number 63, my lord. Bar Association matters.
Yenamma,
63, Swami. Second list.
Nalega,
Monday.
Monday.
Second list,
My lord,
Swami. Second list, Swami.
34,
My lord,
my lord.
adina nange election petition ide, Swami.
My lord,
I have
serial
to
number
appear.
34,
It's
my
my
lord.
personal case.
Day after tomorrow, my lord.
Advocate Association.
Yes, my lord, they are, put the lock, my lord, they are not allowed the advocates, my lord, to use the washroom and all facilities.
ಯಾವ್ದಪ್ಪ ಅದು?
Serial number 19.
Serial number 19.
My lord, serial number 34.
Just tomorrow.
My lord, serial number 34, my lord.
My lord, 63, my lord. 63, one request, my lord. Second list, Swami. Monday. My lord, 63, my lord. Personal request.
My lord, serial number 34, my lord.
64, my lord. Second list.
My lord, day after tomorrow, my lord, top of the list. ಯಾಕಂದ್ರೆ
Top of the list.
yes sir, ಅರ್ಜೆನ್ಸಿ ಇದೆ my lord. ಯಾಕಂದ್ರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ಅವರು ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ರು ಹಂಗಾಗಿ.
Stay may be extended, my lords. Court officer, serial number 64, second list.
ಮೇಡಮ್ 430 ಮ್ಯಾಟ್ರ್ ಇತ್ತು ನೋಡಿ. ಮೇಡಮ್ 430 ನಮ್ದೊಂದಿತ್ತು. ಅದು 19
Madam, ನಂಗೆ ಮಂಡೇ.
ಇಲ್ಲ ಇದೆ. ಇವರು ಪಿಟಿಷನರ್ 19 ಹಾಕಿ.
Madam.
Second list.
Madam, ನಂದು second list 63, Monday.
19
Monday. Yes, ma'am.
ಮೇಡಮ್ ಅದೊಂದು 19 ಹಾಕ್ಬಿಡಿ.
Court officer.
ಮೇಡಮ್ ನಮ್ 430 ಇದು 19 ಹಾಕ್ಬಿಡಿ. ಅದನ್ನ 19 ಹಾಕಿ.
Serial number 36.
I'll tell you, sir.
It's
ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
Serial 36 ಯಾರು ಸರ್? Serial 36
ಮಾಡಿದ್ರೆ ಎಂಡಾಸ್ಮೆಂಟ್ ಇರುತ್ತೆ ಅಲ್ವಾ? ಪೋಸ್ಟಿಂಗ್ ಕೊಡ್ತಾರೆ ಅವರು. 27th ಆಗಸ್ಟ್.
Madam, serial number 36, day after tomorrow, madam.
ಎಲ್ಲ 27th ಆಗಸ್ಟ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. 40% ಇದ್ರೆ ಇಲ್ಲೇ ಇರ್ಬೇಕು.
Madam, 4:30 matter. Madam, at least next week, 36, second list.
matter. 4:30 matter date ಬೇಕು.
19. ಆಯ್ತು. ಹೇಳಾಯ್ತು. Both side. Madam, 36, second list, madam. 1st September petition.
ಬೇಡ. ಇಲ್ಲೇ ಇರ್ಲಿ. ಹಾ ಇಲ್ಲೇ ಇರ್ಲಿ.
Court officer second list 64 court officer.
ಅದು petitioners ಇಂಟರ್ ಮಾಡಿದ್ರೆ ಇದೆ madam, ಅದು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀವಿ.
List 2
ಇಲ್ಲ 27th ಆಗಸ್ಟ್.
Madam, second list 36.
ಡಿಕ್ಟೇಷನ್ ಆಗುತ್ತೆ ಅದೇ ಡೇಟ್ ಬರುತ್ತೆ.
Madam, second list ಯಾವಾಗ ಲಿಸ್ಟ್ ಆಗುತ್ತೆ ಮತ್ತೆ ಮ್ಯಾಟರ್ಸ್?
ಅದೇ ಎಲ್ಲ 27th ಆಗಸ್ಟ್. ಮಾಡಿದ್ರೆ ಡಿಕ್ಟೇಷನ್ ಆಗಿರುತ್ತೆ, ಅವ್ರು ಟೈಪ್ ಮಾಡ್ತಾರೆ. ಇಲ್ಲ 27th ಆಗಸ್ಟ್. ಅದು ಯಾವಾಗ ಬೇಕು ಲಿಸ್ಟ್ 3 ಇದು?
List
ಹೌದು.
64 court officer list 2.
ಮೇಡಮ್ ಎಲ್ಲ 27th ಆಗಸ್ಟ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
List 264.
ಅಷ್ಟೇ ಯಾರು ಬೇಕೋ ಮೆಮೊ ಹಾಕೊಂಡು ಅಡ್ವಾನ್ಸ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಡೇಟ್ಸ್ ಮಾತ್ರ